at me. I have my headphones in, like, before the stream. Look at this. Things are smooth. Knock on wood. Somewhere. How's it going, guys? Welcome. My name is Lacey Jane. This is Criminally Confident, and today is Thursday, January 8th. And today we are finishing our truth journey, as the kids say. I'm just trying to see if my bangs are gonna cooperate. The truth journey of Casey Anthony, and by that I mean the exact opposite. And finish closing statements and get that verdict and announce what is next. So, if you are still here, thank you so much for joining me. Please make sure to hit that like button and subscribe to my channel, both of which are free and helps the algorithm greatly. I've seen a lot of crazy things in my life, but knowing how this turns out and watching what I have watched, I'm still not surprised, but I'm discouraged. I think that this is crazy. Sorry, I have a heating thing. What are those called? Space heater. And I thought it went out. Hearing things. So we are chatting over on the vertical stream. If you are watching right now from like a desktop, a laptop, any sort of computer, you are probably watching from a horizontal screen. I have pinned a message there for you guys. And if you click that link in the message, it'll take you to the chat, the stream where we are chatting, which is just a vertical, thin screen, I guess is how I would put it. So with that being said, I don't know about you, but let's get this show on the road. Thank you so much. I will see you over in chat.
That there was a body in the trunk of this car. No hairs, no soils that match the actual scene. There's no evidence of that. So let's just speculate, shall we? That's not proper. That's not the law. And that's not your job. But yet that's what they want you to do. That's what they're asking you to do. Now, you saw tons of testimony about the trash and the garbage. And I can't count how many times I brought this up to you and showed it to you and said, take a look at this. And I brought it to you because I think what's important here for you to remember is that this evidence was changed. This evidence was altered. Whatever evidence could be used to exculpate Casey was destroyed, put intentionally into a dry room. You don't know what food is in there. All you know is they want to dry it out. They want to, and you were passed a Velveeta cheese with fingerprint dust on it. You remember that black powder? Fingerprint dust. They want you to know who cut the cheese, but they don't want any other evidence to come out as to what was actually in the trash of that car. And Mr. Ashton can do his little show all he wants and show them the garbage and say, where's the spit in here? Well, we could see there was spit there. Where's this? Could this create any smell? Well, of course you can't find anything because it was altered. It was destroyed. And that's not what a police officer's job is to do. That's not what crime scene investigator Vincent and Bloisy should be doing. They should be preserving evidence, photographing evidence, documenting evidence, so that you can make an intelligent and just decision, so that you can have the evidence you need to carry out and answer any question as to what was in this garbage, what chemical compounds could come out of it. And they went out and did the air test 6 weeks later from this. How absurd. How outrageous, how unjust could that be? Now, one of the things that I will point out to you in much more detail is the issue with the computers. And I will get into the detail of the state's, the very heart of their premeditation, as they like to call it, having to do with what you heard and how you were misled in a certain direction. But I'm going to get back to this when we cover that evidence. But this evidence will so infect the quality of their case like a cancer that you will have no alternative than to render a verdict of not guilty. Actually, Judge, I think this would be a good stopping point.
Okay, ladies and gentlemen of the jury, we're going to recess for lunch at this time. Please remember, do not discuss this case among yourselves nor with anyone else. Any additional instructions on behalf of the state or the defense?
No, sir.
Okay, we'll be in recess. Okay, you may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys. Both sides ready to proceed.
Yes, Your Honor.
We miss you, Mr. Baez.
I wish I could say the same. I do have one issue that I'd like to bring up.
Yes, sir.
I apologize, but I continue to see Mr. Ashton's facial expressions as I'm doing my closing arguments. And I would ask that he refrain from showing gestures or something, whether he approves or disapproves of what I'm saying. I think the court's been clear about its order, and I would just ask that
Wow.
that
With the signages, I can't see Mr. Ashton, but as I've made it quite plain and clear, we don't need any facial expressions of approving, disapproving, or anything else. Anything else?
ready to go.
Okay, for those of you who may wonder why
Sorry,
we
my
took so
cat
long,
is
remember we
attacking
had
my
to
dog. You hear me?
finish our charge
He's yelling.
conference. And unfortunately, the court reporter, while we were talking and munching on sandwiches during the charge conference, she was operating her steno machine. So we had to give her some time and some of the other court personnel some time to get a little something to eat. All right, both sides ready to proceed?
Yes.
Yes, sir.
And you've only used 38 minutes and 20.4 seconds of your 4 hours. So you have a long time to go, Mr. Baez.
Thank you, sir.
All right, let's return to jury. State recognized present of jury.
Yes, Your Honor.
Defense.
Yes, sir, we do.
Okay, members of the jury, did you heed all of my previous admonitions during your lengthy lunch hour? Mr. Baez, you may continue, sir.
Thank you, Your Honor. May it please the court, my colleagues in the prosecution. Good afternoon, ladies and gentlemen. I'd like to pick up where we left off, and we were talking about the actual physical evidence, whether it is or whether it isn't. I'd like to call this next phase the state's fantasy of forensics. And I want to begin with the trunk of the car and this phantom stain that the state has alleged is on or in the trunk of that car. I'm looking. We've all seen the photograph, and I don't see anything that would remotely resemble a stain of human decomposition in the trunk of this car. Now, again, this goes back to grabbing your emotions early on and hoping you'll see something that's not there. We heard evidence that there's no blood in the trunk of that car. We heard numerous tests. We heard Gerardo Bloise talk about how thorough he was in examining the trunk of this car. You may recall he said he hasn't had a car in his entire 30 years of experience where he has processed it more than he did this car. And you heard Heather Siebert from the FBI talk about when tissue decomposes, it still has cell material. And they could have gotten DNA if there was DNA in the trunk of this car. And they certainly took swabs. They certainly tried. They certainly did everything they possibly could to generate something to let you know and to prove to you that there was a body in the trunk of this car. The state wants to have it both ways. They want to say there's a stain when there is. Maggots, when all the maggots were in the trunk of, were in the actual trash bag. They want to give you all of this evidence to try and say and try and hope that if you stare hard enough, you'll either see human decomposition, a human decomposition stain, or some other figment of your imagination. Of course, by this point, you're already angry. Your emotions are riled up, and you just might see, if you stare hard enough, if you stare long enough, you just might see a stain in the back of that car. Well, that's not true. That's not evidence. Evidence would have been a DNA report. Evidence would have been something similar to what we showed you. Something, as you may recall Dr. Huntington saying, not even professional cleaners could get that stain out of the trunk. This car was 10 years old, had a previous owner, went through 3 owners in this family, had numerous stains that were there long before June 16, 2008, long before. And you heard testimony about that. You heard actual evidence about those stains. And all they want to give you is stare a little harder and you just might see it. It's a phantom stain. It's there, you just can't see it. And this is the stuff you must look at. Remember when I told you, this investigation reached the level of desperation. And that's what this is. This is a clear sign of nothing but desperation. Nothing but desperation. Now, I want to remind all of you that some of these boards have writing on it. And the law basically says that you must rely on your memory of what was actually said. So I may repeat certain things on this, but I want to be clear. Rely on what you heard in the courtroom, not about what I'm reading to you. Okay?
I should probably
now
go through my.
You may recall we had Dr. Neil Haskell come up and testify. Dr. Haskell and Dr. Huntington are both forensic entomologists, and they both talked about the bugs in the trunk of this car. Or should I say the bugs in the trash bag? Because that's what they both basically testified to. They both testified that the Magnesia scalarius is an insect that is just like a gnat, kind of like a fruit fly. What you see when you leave your doggy bag in your car for too long. What you see when you normally find trash.
Like a Hawaiian.
They are not exclusive to human decomposition. There were 0 early colonizers except that one blowfly leg. And you may recall even Dr. Huntington said, just last week I found a blowfly in my house. So it doesn't mean anything. And they are commonly found in garbage. And then there's this testimony about towels, the paper towels. Well, you heard Dr. Huntington say, you can't clean this up with paper towels. And you know, and you didn't hear any evidence of DNA or any blood found on those paper towels, because I guarantee you that would have been the first thing the state led with if they had. But they didn't give you any of that. Instead, they gave you more speculation upon speculation, guess upon guess. They want you to fill in the gaps with your anger and your emotion. That's what they want. And they're hoping that if you talk about maggots, you'll think dead body. Well, you heard Dr. Huntington and Dr. Haskell talk about these insect activity. It's amazing how much information you can get.
Thank you, maybe.
Right down to the time of death in some cases. Well, they had that opportunity on July 16th and would have answered all questions if they had taken DNA from those maggots. DNA feed, if a maggot is feeding on human tissue, it digests it. It can be extracted. And of course, none of that ever occurred in this case. No answers, no answers. Just more speculation and more speculation. Hardest thing in the world is to stand up here and talk about maggots in a case like this. Hardest thing to do is to question about maggots in a case like this. But it's necessary. It's a necessary fact that we have to confront to be able to expose and tell you what the actual evidence is, where the truth lies. And the truth lies that there is absolutely nothing in the trunk of that car that has anything to do with human decomposition fluid. So why? Why are these allegations being made? It's to make up for the lack of evidence, to have you guessing,
remotely,
to have you take that leap of faith into a place where you should not, and you cannot under the law.
What's up, Wavy Talk?
Now, the next thing the state did is they talked to you about hair. And they had Stephen Shaw, a young man, and Karen Lowe, both from the FBI. I think it's fair to say, by looking at a lot of the testimony that came across in this case, that the FBI laboratory is probably the most advanced crime lab in the country, and that their employees are trained extremely well. That is why they are scientists as opposed to advocates. That is why you saw more FBI people testifying for the defense than you did for the state of Florida. Why is that? Why did we have to call 10 FBI lab personnel for you to hear evidence? Why? If this is a search for the truth, why is important information being withheld from you? And that's because this is about winning and nothing else. Winning a high-profile case and nothing else. It's not about a search for the truth. And that's what you should consider when you look at how some of this evidence was presented to you. Both Stephen Shaw and Karen Lowe would only go so far. They told you that the banding that's found in the hairs that looks similar to this they cannot say it came from a dead body. And the reason for this is quite simple.
Well,
the reason is the science is just not far enough for them
that's
to
what
know.
I was going to say. Like,
and
this was
something
so
very
new.
interesting and unique happened in this case.
That was a bad
They
move.
conducted a study right after we took their deposition. When we went to Washington, D.C. to take their deposition, Stephen Shaw did his study on environmental effects on hair. Now, you may remember, this is only the second study that was ever done on environmental effects. The first one was done by a grad student at John Jay College. The second one was done by Mr. Shaw after I took his deposition. Trying to validate their science is not the same as science. This is not DNA. And that's why I get on this stand and say it came from a dead body, for no other reason. Because they know it. They know that the science is still in its ongoing phase. And they had similar effects that mimic post-mortem root banding. And what was interesting about this is, even the FBI analyst at the lab got these two wrong. So I guess it all depends on who's testifying in your case as to whether it's post-mortem root banding or not. Well, that's not science. That's not something you can rely on. And what's more important is neither one could ever testify as to how long that hair was in the trunk of that car. Could have been there for years. Could have been there for months. We don't know, and you don't know the conditions. But one thing you do know is that you're only talking about one hair. One hair. And how many times did we have to get Karen Lowe back? We had to bring her back to show you all of the examinations that she did. They took hair from the trunk. They took hair from the trash bag. They took hair from Casey's clothes. They took hair from her home. They vacuumed the trunk of the car. They went crazy trying to find more hairs so they could say, this came from a dead body. And they did find more hairs. You heard her say she tested hundreds of hairs and only one hair showed something there that could have easily been from environmental effects. Easily. Now here's the thing. There are several things, but if neither one of them individually can actually stand on its own, you shouldn't consider it. They're hoping they throw enough against the wall and see what sticks. That's what they're doing here. Let's throw it all against the wall and see what sticks. Right down to their cause of death. 1 week it was chloroform. Today it's duct tape.
Hey, if you're watching and you haven't hit the thumbs up button, it's free. If you could do that, that would be great. Thank you.
Let's make up our minds and say we prove to you that this case was proven beyond and to the exclusion of every reasonable doubt. How can you say that? How? It makes no sense. Then we get to chloroform. I have to tell you, when I first heard chloroform being mentioned in this case, I thought to myself,
yes, Amanda.
This has to be a joke.
Sustained.
Wait, why did she object to that?
Chloroform began in this case by Dr. Arpad Bas. And that's how it all started. That's how this issue came up.
We only have 5 likes and
And
100 people watching.
What happened was he testified that the reason they progressed was that the chloroform levels were shockingly high, unusually high. You all remember that. That was quite a moment in the courtroom where this forensic anthropologist, not a chemist, no matter how much his buddy, Marcus Weiss, wants him to be a chemist, he's not a chemist. I'd like to be a race car driver sometimes, and sometimes I drive pretty fast, but that doesn't make me a race car driver. Dr. Voss is not a chemist, but all the other chemists have different conclusions. We had to call the actual person who did the tests. The state didn't call Marcus Weiss because he would have come up here and he would have told you that all they did was a qualitative analysis, not a quantitative analysis. That's huge. That's huge. But what they want to do is have him testify about the levels when there are no levels. You can't determine how much is there because they didn't do that kind of test. So let's just guess. Let's rely on this guy who's selling a sniffer machine. Let's rely on him. But the very next witness from the FBI, a chemist, someone who is educated and experienced in that specific kind of test, came back and said, no, they were low levels, very low levels, consistent with cleaning products. And you have to remember, these instruments are so sensitive, they can take a drop of water and tell you all the chemicals that are in there. Fluoride, chloroform, any other type of chemicals that would be in a drop of water. They can certainly do it from any of these air tests. And that's exactly what they did. If you believe Arpad Voss, you have to believe Dr. Rickenbach was not telling the truth. They're completely different. Their testimony was completely opposites. They were polar opposites, both on the way they practice their science. One is a crime lab, a forensic crime lab that has strict standards, and a research lab that does research. They're explorers. They push the boundaries of science. And that's what Arpad Voss was doing here. Marcus Weiss wouldn't go so far, although he wanted to talk about how great his buddy was. And I knew he was not going to be a friend of the defense. You saw his testimony. He wanted to be evasive. He didn't want to be straightforward. He didn't want to answer my questions so you could get the answers you need. No, all he wanted to do was talk about how great his buddy was. But one thing he wouldn't do is tell you how much chloroform was in the trunk of that car. Dr. Michael Sigmund.
Don't bite me.
Another individual, another chemist from the National Center of Forensic Science, testified that the main compound was gasoline. And they want to say, oh, well, you know, the liner was removed. Well, the air is the air, especially if they're going to test something 6 weeks later. The person who conducted the air test and collected the samples in this case was Michael Sigmund, who is a state expert. He was hired by the state of Florida, not by the defense. He was hired by the state.
Hell yeah. Welcome, Alabama.
He was hired by the state. The only defense expert you heard from was Dr. Furton. But we had to call them all. We had to bring them to you because the state didn't do so. They wouldn't. Why is that? Is this a straightforward, straight up prosecution? Are they giving you everything you need when someone's life hangs in the balance?
Objection to the violation of paragraph 5 of the court's order.
Overrule at this point.
These are things you have to consider, the lack of evidence. You have to consider all of these things and take a look at it and wonder why some of these questions weren't answered. And why were these people hidden from you? Why? Is that justice? Is that a search for the truth? Is that what a citizen deserves in our country, in our state of Florida? Is that what someone deserves when facing trial for their life?
She was charged, Sonia. It's just a
I suggest to you that this lack of straightforwardness is unacceptable. And when the truth surfaces, it hurts a lot more than the single lie. Now, dealing with Arpad Voss, you heard that he had a financial motive. You heard about his patent for his sniffer machine.
A sniffer
This
machine.
device that he's trying to create to sell to law enforcement agencies across the country and even across the world. He has done some research, but he's not the only one. He had a guy in Greece tell you that he agrees with him. Well, we didn't see anybody from Greece testify up here. The other individual who'd done a lot of research in this area is Dr. Furton. You heard from him. And while I disagree with Mr. Ashton's characterizations of his testimony, he testified that there is no signature, there are no chemical aspects of decomposition yet. It's at its infancy stage. And this man will be much more willing to take the leap of faith because it hits his wallet. And his too. Some of his designs and some of the work he's doing is great. It's groundbreaking. It's excellent. But that doesn't make it science. That doesn't make it true. You also heard him talk about a thing called divining rods. I don't know if you remember that, but he said you can actually take a coat hanger and find a hidden grave with it. He said that. He said you can find a clandestine grave by going around with a coat hanger and that it's actual science. Well, if that were the case, what does he need a sniffer machine for? But this is the kind of nonsense, the kind of stretching of the imagination that Arpad Voss engages in. Maybe one day he'll be able to sell hangers and patent that idea. But this is the level of absurdity, the desperation that this case, that this prosecution will take it to. They'll take it to the next level. They'll ask you to see things that aren't there. And they'll ask you to imagine fictional science.
Welcome,
It's a fantasy of
Tennessee.
forensics, is what it is. A forensic
No
fantasy
problem, Sonia.
and nothing more. We have the most advanced.
Donna, because last month I was doing a theme of watch out for crazy broads, and she fit all of the boxes, and it has nothing to do with anything other than she is absolutely nuts. I'm just like, I'm staring at her, and nothing about her is normal, okay, should be accepted, but we can learn and learn how to spot these people that may or may not be in our lives or come into our lives at a certain point. And now you know what happens when, as Maybe says, evil things can come in pretty packages.
Crime fighting tools available to us anywhere in the world. And they couldn't find a single link from Casey to Kaylee's death. Not a single link. But yet they want to create things for what? The cameras? Because it's a high profile case? No, because it's about winning. Win at all costs, no matter how much it costs, no matter what it costs.
Counsel is violating paragraph 5 of the court's order regarding derogatory comments against counsel.
Sustained.
Argument as to jury.
Let's move on.
Now I want to take you to what I think the evidence showed in this case, where it reached its most outrageous level. And that is the computer searches. The state of Florida took this approach. This gentleman, Sergeant Stenger, a police officer, did in August of 2008 using a software called net analysis. He did a report, and his report came out. And this was on the main issue in this case, the chloroform. They were looking for chloroform and they got it. Okay? They got it. And this report comes out showing the size spot one time, one visit. But something really odd happened at trial.
She didn't get convicted.
Sergeant Stenger didn't testify.
She got
to his
charged,
report.
just not convicted.
In fact, he goes to a seminar a year later and tries out this new software called Cashback. So what happens? He can't get Cashback to work. And he tells the owner of the company, a guy from Canada, hey, I can't get this thing to work.
Karen Reed, people, I know you're watching. Tell me if this does not sound like something that the prosecution did during that trial.
I've got this high profile case and I need this to work.
Coco found
So
the
as you heard
box.
Mr. Bradley testify, that he stayed up 3 nights trying to get it to work. 3 nights. And finally he got it to work. And they come back with 84 searches for chloroform. And what was odd,
Blech.
when I saw that, it was a jaw-dropping moment for me. And it was a jaw-dropping moment in this courtroom because I know I couldn't have missed that. What? And it took, and I went back and we looked back and we finally realized the net analysis report. This man not only testified falsely
Jody would.
about what was there, he testified about somebody else's report, Kevin Stenger.
That's a great
And you'll remember
good
when I
question.
asked him about this report, he said, this is not my report. And I asked him, can you testify intelligently about anything in Sergeant Stenger's report? And he said, no. He said, no. This report that's in evidence, and you'll take it back with you,
I'm making
States
that a
Exhibit
poll.
166, was done Friday, June 3rd, 2011. You had already been jurors in this case. And he does this report. And the state of Florida calls this man to testify after this report had been done in August 2008 with an established piece of software saying something completely different. This is fraud. This is trying to pull a fast one.
Your Objection again to violation of paragraph 5 regarding
Sustained.
derogatory comments. Move to strike.
How do I want to
Motion
rate
to
this?
strike
Who
last-
would
you're
win?
instructed to disregard last comment.
I want to say a cat fight
This is not true evidence. This is not true evidence.
just because
This is not the truth.
they're vicious.
A human life lies in the balance. You're being asked to make the biggest decision of your life. You're being asked to take someone's life
Right.
if you feel the evidence deserves to be. And this is the type of evidence you're given. I suspect that when the prosecution gets back up, they'll ask you, or they'll tell you should rely on the lower number. Because this is the true number. And you know this is the true number because of the progression that we showed you. This was Facebook. 84 times was Facebook. I'm sorry, MySpace. MySpace was just 2 levels up. MySpace is not even on this report. How did that get missed? And I showed you, and when I called the man who wrote the report, we called him to expose it to you, to expose the truth. Why?
Hey, JP, there was a paternity test done, testing if Lee was the father, and he wasn't. So I think I proved you wrong. Sorry, buddy.
When the defense has no burden under the law, does the defense have to call witnesses, police officers, to testify, to tell you the truth, to bring the truth to light, so you can see and you can render a just verdict? This is outrageous. And you will see in Defense Exhibit 45, the progression of when someone typed it, MySpace in 84 times, 83, 82. And you
I
see
was
the progression.
addicted.
You see no such thing on this report. You don't even see MySpace. This is their premeditation. This is their murder case. And Mr. Ashton gets up here and says, we can only hope that she issued the chloroform beforehand. Hope? They weren't asking you, they're hoping they're going to get a conviction now? They're hoping that you'll buy the chloroform? They're hoping? You're not supposed to hope. You're supposed to prove cases beyond and to the exclusion of every reasonable doubt. Where do they get this stuff from? How can they ask you to do this? How can they come forward with this evidence, this junk that doesn't even work? And why wouldn't they have him do a report? He's the creator of the software. Why didn't he issue a report? Why? He's in Canada now. Nobody's going to prosecute him for perjury. This is a police officer who works here, and he didn't say a word about this report until we called him and had to show you that there are no such searches of being 84 times for chloroform. The extent of the computer is this: 3 minutes worth of time, 3 months earlier, that have nothing to do with this case and everything to do with the MySpace posting. The MySpace posting of Ricardo Morales. You heard evidence, ladies and gentlemen, that Ricardo Morales posted this on his MySpace at the same exact time that he was
What?
dating Casey Anthony. He also testified that he was dating her in March. March is the same exact month as these searches. If you don't know what chloroform is, and your boyfriend is posting things like this on his MySpace page, it beckons the curiosity of what exactly that is, especially to someone who's young. What is that? Is that true? Can that actually happen? It's not unreasonable for a young woman to decide to research something like this based on what her boyfriend is posting. And wouldn't you know, what is the first search before the very first chloroform search is?
I appreciate you, JP.
MySpace. Exactly where he posted it. MySpace. Now, then there comes the issue of Cindy Anthony. Well, we all knew Cindy Anthony in 2009 testified to doing these searches. We all knew that, both the state of Florida and the defense. That was something you needed to hear. And what the state of Florida decided to do is then go out and spend their entire rebuttal case to prove she's a liar. Well, I told you she was a liar the first day.
Her brother's
I
name
told
is
you how this
Lee.
family lies. That has been clear throughout this case. Throughout this case. But there's one thing you can't deny, and that is MySpace goes right before the next Google search, how to make chloroform. This is not true. This is misleading. And Ms. Jane Burdick, when she questioned Cindy Anthony on the stand, she said 84 5 times. She kept questioning her. 84 times you searched for chlorophyll? 84 times?
That was
When this report
intense.
Was in existence. Why? How could she do that? How can that evidence come before you? How is that truth? That's why you have more questions than answers. That's why situations like fantasy searches, fantasy forensics, phantom stickers, phantom stains, all of this nonsense, and no real hard evidence,
Coco.
no DNA, no fingerprints,
Sorry.
nothing. But she's a liar and a slut. Convict her on that.
Damn.
And she lied, and she didn't act the way she needs to. She made some stupid decisions, but let's make her pay with her life. That's what this case is about.
Don't bite.
An accident that snowballed out of control. And it's out of control. It's out of control right now. And it has been out of control since the moment this trial began, since the moment this case began. It's out of control. And it's true. Casey made some bad decisions and started this, but it doesn't have to be continued. It doesn't have to be presented this way. This case does not have to come out this way. The truth stops here. The truth starts here. The nonsense stops right now. It should have stopped the moment you all raised your hands and chose to be jurors in this case and took that oath. Every single thing, all of that nonsense should have stopped, but it didn't. And this is what they want you to render a verdict. This is sufficient reasonable doubt, ladies and gentlemen, for you to say, you know what? I don't trust this evidence. This is proof,
I agree,
conclusive proof
maybe.
that I don't trust this evidence. And on something so serious, when the law says I can reject part of it or I can reject the whole thing. It's just like there's an old legal adage that says, if you go to a restaurant and you buy a meal and you find a bug in your meal, you don't take the bug out and can continue eating. You send it back. You send it back. Something as so serious as your health, you would never risk that with. Now those are types of situations. That's in the situation you're right here in now.
How hungry am I?
Situation so serious that when you make that decision in the jury deliberation room, it is irrevocable. You can never take it back.
We love opinions
You
here.
can never say, oh my God, I made a mistake. You can never say, can I change my mind? Can I take that back? No, it's done. It's done. These types of decisions of reasonable doubt, that's why we have that standard. If this were a financial sheet and you had your entire life savings and you're about to retire and you say to yourself, I'm going to invest with this man because he's given me great numbers.
Sustain. Motion to strike.
While they're doing that,
These types of decisions
for my makeup,
are life-changing, unchangeable decisions.
I've had it.
And
I
this
just
type of
never
evidence
used it.
is reasonable doubt. That stain that never was is reasonable doubt. All of these aspects, the way this was presented to you is all reasonable doubt. And here's the thing. If you don't know what happened, that's it.
Yeah.
If it wasn't proven to you that it happened, that's it. It's over. It's not guilty on every count. Only the ones that were proven to you beyond and to the exclusion of every reasonable doubt come back. That's it. That's what our law is. And all the emotion and all the anger can never change that because it works the same for John as it does for Jane, as it does for Casey. That's how we have our society. Those are the laws we have chosen to make the law equal for everyone, equal justice under the law. That's what we have. And you've got to follow it. The law is your guide here. Not myself, not Mr. Ashton, not Ms. Jane Burdick, the law. And the law will guide you, and it already has been, and will in the deliberation room, that this is what they must prove. Not anything less, because we will not accept anything less. The fantasies continue with the phantom heart sticker. Where in the world did this come from? This is outrageous. A young, very eager FBI analyst, Elizabeth Fontaine, sees something on the duct tape as she's examining it. Something in the outline of a heart appeared on the corner. Okay? That certainly deserves looking into a bit further. Well, they then recover 30 feet away. You recall Mr. Murdoch, who processed the scene, had his computer with a computer program, and we called him to show you how far away this was found. And this looks nothing like the stickers were found at the home. Nothing. And this child had all kinds of stickers in her house. You're not going to find a small child like that without heart-shaped stickers in their home. There were also Mickey Mouse stickers. There were also Goofy stickers, all kinds of other stickers, a scrapbook that was used by Casey to document her child's life. And they tried to sell you that this thing found in an area where trash is dumped, okay? Trash is dumped there.
It was
30
also
feet away,
across
across
from
the street
a-
from an elementary school.
Yep.
How unusual, how crazy is it going to be that you're going to find a sticker attached to a cardboard, not attached to duct tape, 30 feet away? But that doesn't matter, because if you remember, the prosecutor, when they got up, their next question was, wouldn't you agree that this area was a trash dump? Playing on that anger again, playing on your emotions, trying to get you angry and say, yeah, that heart sticker was there. Well, why did they hide her from you? Why did the defense have to call Lori Gottesman? You remember, she used the VSC machine. She's a document examiner for the FBI that showed us all the different things that they do to find and uncover things with documents and things like that. And she saw no sticker or sticker fragments observed on any of the items. None.
This is what I'm
It
saying.
didn't exist.
That's what I'm
It has
saying,
nothing
Savvy.
to do with this case. This has nothing to do with this case. But if you lie on your anger, if you rely on your frustration, your desire for blood, then yeah, maybe you can make this square peg fit through the round hole. Maybe if you squint your eyes hard enough, that sticker looks a little bit like one of these. This is outrageous.
Outrageous.
This is the quality of their case. This is the quality of the evidence put before you. But that's all that, these are some of the things that we were only be able to uncover. If this investigation was focused, open-minded, not just arrest her within 24 hours, we'll get the evidence later. That's what happened here. She was arrested within several hours, arrested for child neglect, and they went out and got the evidence later. Okay, bring that car over here now. Forget all 7, 8 cops who were there that night. Today, it smells like a dead body. Forget everybody who saw it and smelled it, but today it smells like a dead body. Let's get rid of the trash because we don't want anybody thinking this was trash, this smell. If they're going to be this sneaky with this type of evidence, how much can you trust the rest of them?
Objection, violation of paragraph
It's
5.
not a violation of paragraph 5.
Sustain.
Let's stretch the truth here a bit further. How is this even presented to you?
Ooh,
How does this even,
I think maybe
what about all
we'll like this.
the beer bottles found next to the sticker? Why weren't they presented? What about, well, maybe we could dust those bottles for fingerprints and see who the killer was. Why not? It's just as reasonable. It's far away, but it doesn't matter. It was out there. That's the kind of evidence that you have to render your verdict on. Stick this in. And then we come to Dr. Jan Garavaglio, the medical examiner. She told you that she did an autopsy on the remains. This child had no broken bones, no evidence of prior trauma, no evidence of trauma at all. And she did it, and she sent out all of the toxicological exams that she could to try and make this case fit. They all came back negative. You heard the test for chloroform, negative. The test for Xanax, negative. All of these other drugs, negative, 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 negative.
Bye, Donna.
Cause of
Thanks for
death,
stopping by.
unknown. And that's where the science ends. That's it. And that's where we are here today. How did Kaylee die? You would think that you can get a medical examiner to come and talk to you about medicine, about science. She has a little leeway with the manner of death. They want to tell you it's a homicide without telling you how.
Welcome,
Why is it a
member.
homicide? Well, because I said so. Well, these are her 3 reasons. The injury was not reported to the authorities immediately. You don't need to be a doctor to know that. The body was hidden in a wooded area. Well, you don't need to be a medical examiner to do that either. Duct tape appeared to be applied to the lower face. Appeared. You don't need to be a doctor to know that, to render that opinion either. These are all opinions that have nothing to do with what this woman was trained to do. Nothing. Absolutely nothing. A person on the street riding a bicycle could give you these same facts and say the same thing.
I think that's
This is not
pushing it.
science. The science she used was straight up. They can't establish the cause of death. And everything else came back negative. Everything they suspected. And as Mr. Ashton said, everything they hoped for was not there. And you remember, Fury Melich got up here and he testified to you. We did 3 search warrants on that house. We found no printing paper. We have found no paperwork having anything to do with chloroform. We found no receipts for purchases of chloroform. There were no purchases for chloroform found on this computer. They didn't find any chemistry kits. They didn't find any containers containing chloroform. They didn't find any ingredients making chloroform. They didn't find anything whatsoever having to do with chloroform. Nothing. But they're hoping. Let's hope. And Dr. Garavaglia gives you this. Well, if that wasn't enough, of course, you had Dr. Schultz, whose real purpose was to tell you and to get you more angry about how her remains were treated afterwards. But he did say no trauma to the bones.
Okay.
Mr. Fantasy Man, Dr. Warren, who for some reason showed you a video of a smiling Casey and a smiling Casey with some duct tape that he got off the internet. He Googled it, got that photo, stuck some duct tape on it on Photoshop, and there you go. There's your new murder weapon of the week. That's how she died. Well, that's not evidence. And he himself said, the only reason I suggested is that to show it could have happened. Well, she could have been shot, but they don't have a video of her getting shot, even though they could have done one. She could have died any number of ways, and they didn't show you videos of that. He was up there being an advocate, not a scientist, and showed you that video for one reason and one reason only. And you know what it is. Dr. Schultz testified to the same thing, but Dr. Schultz didn't have the same opinion as Dr. Garavaglia. Dr. Garavaglia said it was homicide. He had no opinion on either one. She jumped in because this was a high-profile case. He was the first medical examiner, board certified, fully capable of handling this case, but yet she's the big shot, and she comes back into town and takes over. And because of her relationship with the media and law enforcement. That's it. The politics that the medical examiner played out at the medical examiner's office played out in this case, and you got to see it with these two. We presented to you, and we were fortunate enough to have one of the most experienced medical examiners in the country, Dr. Werner Spitz. And Dr. Spitz did a full autopsy. They can say all they want. And if Dr. Spitz had not found anything, that would have been a different story. But he did. He found actual physical evidence, physical proof that Kaylee's remains were not found and did not decompose in the manner in which the state or Mr. Kronk tried to tell you that they were. Those photographs are not indicative of how Kaylee decomposed and where she was and what position she was in. This is the physical proof. The semantics of was it dirt, was it brain matter? I think a man who has 60,000 autopsies under his belt, the man that our country turned to for the commission for President Kennedy and the Reverend Dr. Martin Luther King, that man I would tend to believe over an anthropologist. I think that's his qualifications.
Counsel expressing his personal opinion.
Sustained.
Judge. You can look at his qualifications and decide for yourself. You can look at whether he's more qualified than Dr. Garavaglia. And it's quite obvious, he is. What Mr. Ashton tried to do when cross-examining him was not question him on his science. No, he wanted to question him on the facts. He wanted to question him on how much of the police reports he had read. Well, the police reports didn't do the police didn't do the autopsy in this case. They might have for Dr. Garavaglia, they might have influenced Dr. Garavaglia, but this is a man of science. who actually did a complete autopsy to check, to see what exactly could have happened to Kaylee. And he did say one other thing. He did have one very important finding. He told you that when you open up a skull, and if a person has died of suffocation, there is a discoloration in the back of the ears. That was not in this case. He testified to that. And he told you that it doesn't always happen, but it certainly wasn't in this case. Well, that also eliminates one of the state's theories. It's actual physical evidence. It's not hoping. It's not guessing. And it's certainly not something Dr. Garavaglia did when she botched this autopsy. Why not open up the skull if you're trying to get to the truth? Why just look through a little hole and think that you can be able to determine what's there, when obviously there was something there that was relevant, something there that could help you, that could explain to you, this isn't the way they're saying it is.
What are you talking about, Peggy?
You have to ignore this completely if you buy their duct tape theory. He tried to, Mr. Ashton tried to get him to talk about things outside of science. Well, explain to me how someone could put the duct tape on there. There's a million ways. It doesn't necessarily mean a person did it.
Oh.
You've heard people referring to this area as a swamp. You've heard the state say it was underwater. Well, water is going to move around the duct tape. You also have the issue with Mr. Kronk. Rolling skulls dropping out of bags. They're outside of bags, inside of bags. What's going on here? You have all kinds of different things. And you also got to see the photographs of the duct tape lying flat on the ground. And then at the medical examiner's all the way there. Now, initially you might say, well, that's a leap. I can't believe that evidence would be manipulated that way. But I think we've seen through the course of this evidence that that's not so far-fetched. Is there evidence of it? No, I won't go that far. But it's certainly a possibility. And if you're going to entertain fantasy forensics and other possibilities of the state of Florida, you can certainly entertain that. But we will not ask you to do so. We think you need to rely on actual physical evidence, actual true evidence, not nonsense. Something you can see, something you can look at and know exactly what is true and what's not. Not some fantasy. Now I'd like to talk about the defense case a bit.
Look at Maybe. She's so helpful.
And the judge is going to instruct you that this is the law. I've told you, I've repeated it many times, but he will tell you that the defendant is not required to present evidence or prove anything. And that's simple. It's a constitutional guarantee afforded to every citizen, every single one of us, no matter who we are, no matter how much money we have, no matter what position we hold, we all share this inalienable right. This is a right of ours. And despite any overtures that we must do so is completely untrue. And you will have the opportunity of the law to guide you in that area. And that's what Judge Perry is going to tell you. Now, I told you in the beginning of this case, that Casey reacts the way she does and lies because of the environment she was brought up in.
Blah, blah, blah.
The
You lost
dysfunctional
me.
family, the secrets and the lies. And I told you about this photo. I showed it to you in opening. And you heard it testified to numerous times in this case. George says she looked this way because she was working out a lot. Cindy said the complete opposite. She was sedentary. She had even stood here and looked over at Casey, could clearly see she didn't look like this, and asked her to turn to the side. Turn to the side, I can't see. I don't think you can believe that they didn't know she was pregnant.
Yeah.
And I don't think you can deny Lee Anthony's powerful testimony. The only member of the Anthony family that didn't get impeached in this case was Lee Anthony. And Lee Anthony said it straight. I confronted my mother about it, and she told me to let it go. Forget about it. You saw how hurt he was.
I can totally see it too.
The bizarreness of that entire situation you heard about. The lies that were testified to up on this witness stand by both George and Cindy Anthony are clear. They took an oath. Everyone in this courtroom, in this process, has taken an oath. My colleagues, myself, the judge, you guys, and every witness who took the stand. And any witness who gets up there and tells a lie does not have the right to violate that oath. Does not have that right. And you can reject their testimony. You can reject it all. It's like that plate of food. The state wants you and talk to you during their closing argument.
Hey, if you guys are enjoying the content, now would be a great time to make sure that you've hit the thumbs up button. Thank you so much.
About the 30 days and all of the things that George and Cindy did. Well, mainly Cindy. In fact, George didn't do anything. You heard about that. But you heard of all these stories about what Cindy said. But by the end of this case, they're impeaching her. They want you to know she's a liar. But please believe what she said for us. That's what they're trying to, those are the goods that were being sold here in this trial. Believe her when it's convenient for us, but don't believe her in others. That's unacceptable. That's not truth. And that's not what you render a just verdict on. Casey has issues. And these issues were there long before Kaylee was ever born and long before June 16, 2008.
Okay, all right. You know what?
I want to show you.
I will ban him.
The world that Casey Anthony lived in, that you heard testimony in this case. You remember her imaginary friends. We had Zanny the nanny from 2006. She's
so
a perfect 10.
Thank you, maybe, for helping.
She
me.
used to date Jeffrey Hopkins. Remember how much amazement Mr. Ashton found and how she could remember these things? She has long black hair, but got it cut several times over 2 years. She has a beautiful smile, straight white teeth. She drives a Ford Focus, and her family is wealthy, and they come from New York and the Carolinas and Miami. Jeffrey Hopkins, the trust fund baby. He also appeared in 2006. He's a couple years older than Casey. He worked at Nickelodeon, and he had a child named Zach. You may recall the Anthonys invited him over for barbecues numerous times, and he never showed up. You had Zachary Hopkins, his son, who used to play with Kaylee. You had Samantha Fernandez, Zanny's sister, and Gloria Fernandez, her mother. You may recall I asked how Cindy talked about her having heart issues. And then, of course, you have Juliette Lewis, who was Zanny's roommate. Now, you may recall Cindy testifying that her and Casey sat in the parking lot of Universal Studios for an hour and a half, waiting for Juliette Lewis to appear. Can you imagine an hour and a half sitting in a parking lot talking about this girl that's going to appear who never shows up? Not 10 minutes, not 20 minutes, an hour and a half. It's like going to the movies and sitting there and waiting. And she never appeared. And this has nothing to do with Kaylee's death. This is something that just doesn't add up. This is something that's just not right. This is the world that Casey lived in.
So
Juliet had a daughter named Anna.
Since this is a get ready with me and a trial stream, I'm going to stop momentarily and let you guys know. This is great for the winner. It's a lip conditioning polish, and it gets off all the dead skin. So if you're someone that's extremely prone to chapped lips, or you feel like your lip products are not staying as long as they should be, it's a great idea to do something to exfoliate your lips and get the dead skin off. And if you go to the video description and you click on the link that says like 10% off, order here, there's a link and then there's a promo code. You enter that. It's the lip conditioning polish made by Senegence, and I end up using it like once a week throughout the winter, and already I feel like it got all the dead skin off. All you do is just like, I don't know, scrub it against your lips and wipe it off, and you're all set and your lips feel a lot better. All right, guys, let's get back to it.
Annabelle. Cindy knew all about Annabelle, Kaylee's playmate. You heard about Raquel Farrell, another roommate of Zanny's. She worked at Universal too. Eric Baker, who could have
Wait,
been
Who was her
Kaylee's father,
husband?
but he died in a car accident, in a motorcycle accident. And Kaylee has a stepbrother somewhere in Kentucky. Her fictional bosses, Tom Manley and Thomas Frank, event coordinators at Universal Studios at Extension 104, which does not exist. Her office at Universal Studios that does not exist. Her office that she took police officers down the hallway to the left, across the street, and got there, and she couldn't go any further. It's at that point, at that moment, that the police should have seen and realized there's something wrong with this girl. This is not just someone lying to cover up a crime. We need to handle this investigation in a different manner. If you found a drunk guy on the street who just lost his job and he's staggering all over the place, you don't treat him the same way you would someone who's completely sober. You realize as a police officer, you have to take a step back and you have to be a professional police officer
Wait,
and deal with
I'm sorry,
individuals
guys. I'm sorry that we have to stop the stream for this. Maybe I pressed the button to ban him. I am a absolutist rather when it comes to the First Amendment, but what he was saying is personal to me, which we haven't gotten there yet. So if that is why Debbie left, please let her know that I banned him.
have issues as well as individuals that do not. This is what they do on a daily basis.
I agree.
And and all the signs were there.
Planted the seed.
Everything
out.
was there. Everything she was saying just didn't add up. And Mr. Ashton says, well, she didn't get a chance to carry this on or take off. Casey had plenty of opportunity to hop on a plane and go. She could have told George and Cindy Anthony,
Welcome,
you will
Stacey.
never see your granddaughter again. End of story, and been done with it. That's a lie. Those are actions consistent with guilt. Those are somebody fleeing the jurisdiction, not someone with a alibi that has an expiration date on it. People weren't going to just stop asking for Kaylee. That wasn't going to happen.
That's
This
really
world here,
frustrating.
you wonder why this case got so crazy. And you look at the situation here, you look at the facts here, and the world that Casey lives in, and you realize that if a person lives in this kind of world, these facts make more sense. This cover-up makes more sense. These unhealthy coping skills make more sense. That's what Dr. Carrioff was telling you. If you're a healthy person and you've got a sound environment, you will be able to grieve. Although everybody does it differently, you will be able to grieve and get some semblance of life. But if you have issues, if you don't have a healthy environment that you live in, it can go to all types of extremes, which would include going out dancing, which would include lying, which would include this fantasy. All Casey was doing, if you look at the situation, is continuing what she knew best, where she felt safe. Remember what Yuri Mellich said and put in his police report? She went somewhere where she felt safe. That speaks volumes. It speaks volumes in this case. I'm not proud of the way Casey behaved. I don't think anybody here can justify her actions, but they do not constitute murder. And you can take a look at this world and understand a little bit better. Understand where it all comes from. You understand the why. As opposed to the state's theory, where she's a loving, wonderful mother one day, and then I'm gonna go party on a Monday afternoon. Even though there's no party or no club to go to, even though Tony Lazaro said he liked Kaylee, he enjoyed being around her, that this was her motive, that's nonsense. That's absolute nonsense. Yes, at first glance, you would say Casey's lies are nonsense. But when you look at it in this perspective, you look at it through the whole picture, you understand that it's not nonsense. It's not right. It's certainly not right by any standards, but it makes sense. It makes a lot more sense. She now wants her freedom? Is that what you do to get freedom? You kill somebody? That's outrageous. That's nonsense. Nobody's gonna come looking for little Kaylee? She's gonna get to party every day and every night? That's nonsense. That's complete and total nonsense. She had no motive. Casey treated Kaylee well. She loved that child. And not a single person, despite the thoroughness, despite using every law enforcement agency available to them, they couldn't find a single person to come in here, take that stand and say, you know what? Casey was a horrible mother. I saw Casey strike Kaylee. I saw Casey do this. I saw Kaylee do that. Casey do that. I said, you heard Tony, the guy who enjoyed her being around, and you heard him say something too, something else. Remember the time where he said Kaylee was running to the pool and how Casey had to run and stop her? Everywhere you look at, there are signs of what actually happened to Kaylee. And that was a perfect example that Kaylee loved the pool. Casey was as protective as she could be. And on that occasion, Casey stopped her from drowning on that day and running into the pool. Obviously, she would have been there and could have saved her. But that's all you heard. That's all the evidence that was presented to you. That Casey was nothing but a good mother, despite their best efforts to parade as many of our friends up here and shot girls and everybody. And everybody said the same thing about Casey. She was a considerate person. She was a kind person. She treated me with respect. She cared for others. This is not consistent with a person who's a murderer. This is not consistent with a person who engages in child abuse, aggravated manslaughter. None of that makes sense. And the reason it doesn't make sense is because it's not true. The reason you don't have that evidence that they're desperately trying to find is because it's an unprovable case, because it's not true. That's why, despite all the efforts they tried, they couldn't give you the answers because they're not true. Now, I used an example during my opening statements of what I told you was going to come out in this trial, dealing with Kaylee in the swimming pool. You heard, as the evidence was presented in this case, that Cindy and Kaylee went swimming on June 15th, the day before, the night before, June 16th. And I told you, I don't know if Cindy's going to admit to leaving the ladder up. Well, she didn't do that. She says she took it down. But thanks to the state of Florida, they got to show us how truthful Cindy Anthony really is. How much guilt would she have knowing that it was her that left the ladder up that day? The denial that she must be in, the denial that she displayed when she testified in this case 6 months earlier, that she thought Kaylee was still alive. Remember that. They had a memorial, they televised it, they held it in front of the world, and then they cremated her. And then she comes in here 2 years later and says, I think Kaylee's still alive. Well, I understand why she said she took the ladder down that day. But what's important too is you remember that door. You remember this house had no safety locks, had no child safety locks, and Kaylee could easily open the door. So if she can do that, if they were that neglectful in that sense, you can understand how the ladder would probably be brought down. Sometimes, sometimes not. Now,
let's not use the N word there, buddy.
You heard Cindy say that on the 17th, of June, that she goes to work and actually tells people, someone's swimming in my pool. Well, why would she do that? That's an odd thing to tell your coworkers, isn't it?
They are crazy.
Someone's swimming in my pool. I saw the ladder up. We're always very sure. What are the coincidences that she would go in on the 17th and talk about the day Kaylee dies and says, someone was in my pool yesterday? And this happened long before the police were called. This is not a fact that you can ignore. You heard both George and Cindy talk about how she could get out of the house very easily. In fact, we ended up showing you proof of it, which is in evidence. And you heard George testify that Kaylee would wake her up in the morning and say, "Jojo, swim, Jojo, swim." This is a child who loved the swimming pool. That door had no safety locks on it. She could get out quickly. She could get out easily. And if for some reason she wasn't being watched that day, that morning, when both Casey and George were home, something happened.
You know what? I'm going to
She's reported, Kaylee's reported missing on July 15th. The very next day, actually within 24 hours, Cindy tells Detective Melich about the swimming pool. You remember that when I questioned Detective Melich, he said that he was getting calls during the Universal Inquisition when they were in the Universal Studios conference room with Casey. You heard the tape. And he left the room because Cindy was calling him left and right, desperately. And he spoke to Cindy, and Cindy told him about the ladder and the swimming pool. And he didn't, and the shocking thing that you may all remember is he had the opportunity to go back in there and ask Casey, "We know what happened. Tell us about the swimming pool." And he never did. He never investigated this case as an accident. Never. He never pursued that. And that's why this case turned out the way it did, partially. Because law enforcement didn't want to keep their eyes open, didn't want to look at every possible alternative, didn't want to consider that.
Hi, thanks for watching. If you could please do me a solid and hit the thumbs up button and make sure that you are subscribed to my channel, both of which are free. That would help me immensely with my algorithm and getting this out to more people. I hope you are enjoying the rest of the Casey Anthony trial.
There was something wrong with this girl. Instead, they had a murder case. And that was it. That was all they were interested in, was evidence of murder. There's nothing sexy about a drowning. There's nothing interesting about a drowning. And they didn't care. Now, we were able to uncover something that was highly unusual. And that was finding an actual photograph of Kaylee opening that sliding glass door. Everyone has hundreds of, most parents have hundreds of pictures of their kids. But how rare is it that you would have one of her actually open?
Oh, we've seen this.
But we found one. This child was heavily photographed. She was loved. Casey took hundreds and hundreds and hundreds of pictures of Kaylee, even in mundane little moments like this. This was her precious child. There's the proof that she could easily get outside. There's the proof that she was big enough and strong enough to open the door. You can't get anything better than that.
Dun, 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 dun. I don't want to dance during this part, though. Thank you, baby, so much for the support of the stream.
Short of a video of what happened. And if that wasn't enough, we were able to find photographs of a year earlier of how easily Kaylee could get up the ladder. And what's so odd about this is you can see how often she was photographed. Every little moment captured. And look at how soft Cindy is holding her or touching her. She's on her own. And look at what Kaylee's doing. Kaylee's diving into that water. This is what she loved to do. This is what she wanted to do all the time. And you can discount Cindy Anthony's testimony, but these photographs tell the truth. There are documented moments in time that do not lie and clearly show that there is a reasonable hypothesis of innocence. It is reasonable that if there are no child safety locks and she could get out, and you had the incident with the ladder the day before, and Cindy was swimming the night before, it is extremely reasonable that she could have drowned in the pool. And that's where the state fails. They must rebut each and every reasonable hypothesis of innocence. They cannot rebut this. They can't do it. It's impossible. They can say all they want about chloroform and duct tape and where the duct tape was or where it wasn't, whatever they want. The issue here is, how did she die? That's why, again, we're back to that one question. How did she die? Where did she die? Did they present one single piece of evidence as to where Kaylee was when she passed away? Zero. When did she die? Why? Because you want to go party? They want to give you the who without the where, the how, or the why. It's impossible. This case, if you look at the law and you look at the facts, is relatively easy for you to decide. It's a tough decision to make because of the seriousness of it all. But factually, it all makes sense. And this is the only explanation that makes sense. And it makes sense because, as I said from the very beginning, it's not the commonality of the tragedy here. It's the uniqueness of who it happened to. And that's why we're here. Because these people are different. This girl is different. And this is why she behaved in this way. And this is really the only rational explanation of all of this madness, of all of it. And that's because this is what happened to Kaylee. And the moment that the state failed to rebut this, and they did, because they didn't present any evidence to rebut it, it was an impossible task. As you know, Dr. Garavaglia said, cause of death, unknown. That's it. They have the right and the ability to charge her with whatever inappropriate acts she may be guilty of, but they do not have the right to overcharge her of murder or manslaughter or aggravated child abuse when there is no such evidence of it. Improper disposal of a body, whatever they want, none of these crimes are before you. None of them, except the most serious, the ultimate penalty, all of these things. And I think you all know the reasons why. We've lost our senses here. Now, I want to talk about the duct tape now. And it's strange how you would have one piece of evidence that can tell you so much.
It's like magic.
Actually two pieces of evidence that say so much about what may have happened here, and so many lies that surround it. Did you get a clear answer from George Anthony as to the gas cans and the duct tape? You can ask yourselves that.
Thanks for being a
You can
member.
ask why he made certain statements.
Mountain Mama.
You recall Linda Tonelli, the woman who worked at the command center and said George used duct tape. He brought duct tape to the command center. And I'd like to re-show you this video if I can before we go any further. Gas cans and duct tape. Look at that duct tape. It's right there, almost the whole roll. And Mr. Ashton was correct when he said this is rare duct tape. This hasn't been sold since 2007 and was in very little quantities. You probably have never seen duct tape with a logo on it. It's always gray and silver. But you may recall when shortly 10 seconds after playing this video, George Anthony took the stand, and I asked him, where'd that duct tape come from? And his answer was, I don't know. There were a lot of people at the command center. Could have been anyone. He wouldn't even admit that that was his roll of duct tape. Completely denied it. He even denied the location of where this video was taken. You heard the judge enter in a stipulation into this case by both the prosecution and the defense. We all agreed it was at that location at that time manned by this person. And he got up there and said, nope, it wasn't there. It was at another place. He can't lie at all. He can't tell the truth at all.
What's up,
And he's
Florida?
confronted right there and then with this duct tape, but he wants to pass it off on somebody else. Then we had this issue with this photograph. Now, I'll bet you remember the first time I cross-examined him on this, I had some issues because it was the state's case and the photograph was not entered into evidence. The state did not use George Anthony to introduce this photograph. So when I cross-examined him, I was shut down.
Objection, Your Honor.
Sustained.
Sustained.
Motion to strike granted. Disregard the last
I
comment.
feel like this is too bright.
He was not
of a
cross-examined
blue.
on this topic. But he said something very interesting. He said, sir, that photograph you're showing me, I was shown other photographs during my deposition that was not this gas can. You remember we got into the whole debate about the different, is it the round cylinder one? Is it the old one, the one you've had for 20 years? And then when it was our case and the photograph was now in evidence, and I showed him his deposition transcripts, he went and looked at all the exhibits
Maybe if I mix
and then
them.
said, yeah, that's the one they showed me during my deposition. But he told you under oath that he was shown some other photograph, not this one, and played all kinds of games with this gas can. This is not a game. It's not a game at all. But yet he lied to you about this gas can. George Anthony lies when it's convenient for him. He lied to Mr. Ashton when he was taking his deposition. You may recall, give me the transcript. You may recall during Mr. Ashton's testimony, during Mr. Ashton's cross-examination, he said, you remember we sparred during the deposition? And I impeached him on this actual testimony, where Mr. Ashton said, but it is, so it's your testimony now that when they took it on August 1st, that it did not have duct tape over the vent.
I
And
will be
George
right
said,
back.
didn't have any duct tape over the vent. And when it came back to me, or at least the last time I saw it, now it had duct tape on it. And I didn't put it on there. But is it your testimony here? Under oath, Mr. Ashton has to remind George Anthony, he's under oath, that you have a specific recollection that when the police officers took this from your home on August 1st, 2008, that piece of duct tape was not on the can. Please answer out loud, yes or no. It was not on the can. It was not on. Lying. Here's a photograph. August 1st, 2008. The duct tape's on there. But when he's sparring with Mr. Ashton, it's not on there. Cops must have planted it. Why is he lying about that duct tape? Why? He knows that he's the only one connected to the duct tape. He knows that he's caught on video by the media, hidden behind the donation jar, that duct tape was his. And you heard Cindy Anthony testify that George was the only one that had a roll of duct tape. And we get back to June 24th. Why is he reporting this gas can missing? Why is this gas can so important to him? The only connection, the only direct link to Kaylee, to her remains, is this duct tape. Yes, you have other items, but the only one that it ultimately connects to is George. If this is their murder weapon, as they claim, they can't hide behind the duct tape. It only connects to him. Casey's in jail she's been in jail for 2 to 3 weeks before that entire roll of duct tape is photographed by the media. Look at these facts, look at these events. The 24th, he issues a police report and reports him missing. The 15th, she's reported missing. He doesn't say a word about this alleged argument. Remember the argument over the gas cans in the trunk of the car? Here's your fucking gas cans. Well, on the 17th, a detective goes and inspects the shed. It doesn't say anything about that. Hey, by the way, I had this fight with my daughter. She wouldn't let me near the trunk of the car that smells like death. And here are the gas cans. Why don't you take them and fingerprint them? He doesn't say a word about them. It's not until near August 1st that he tells them about it, and they collect it. And they take this photograph. Then the first week of August, he's photographed by the media inadvertently, and all of the duct tape's the same. We're not talking about fantasy forensics anymore. We're talking about cold, hard evidence. evidence that points to one person and one person only. He could get up here and lie all he wants and dance around the truth, but the truth is the truth. And depending on who's asking the questions, whether it's this laughing guy right here or whether it's myself.
Objection. Approach the bench.
I gotta put my headphones in. Sorry.
Let the record reflect that the defendant is present along with counsel for the defendant and assistant state attorney. During this recess, I took an opportunity to go and
Beat some
view
ass. Sorry.
the video of the segment that Mr. Baez was talking and Mr. Ashton's reaction
It's
and
there.
Mr. Baez's corresponding response. Needless to say, that response on behalf of Mr. Ashton and Mr. Baez violates this court's order.
Damn. Second time for
now,
Jose.
Both sides would like to take the time to go look at it. I will ask them to pull it up and you can look at it.
Oh.
And then I will proceed to do what I'm going to do. Because I, with the state order of defense, wish to have an opportunity to view the video clip. Unfortunately, videos sometimes show it the way it is.
I'd love to see it, Judge. Me.
It's brief enough. I will ask Ms. Levy and I would ask in session. Ms. Levy find a place where they can go see it and bring it up.
What in the world?
This court will be at ease until the parties get a chance to look at it.
Hold on, bad kitty.
Whatever you want to say it in open court. There'll be no more sidebars, folks. Enough is enough. Whatever you want to say it in open court.
Oh, let's go. What are we deleting? What's going on? Actually, I don't care.
So that we can have that in mind as we do this.
Only me and me alone will know that. I have constantly told both sides from the outset when I first took over this case. I personally gave each one of you the 9th Judicial Circuit courtroom decorum policy, which is enacted by administrative order and has been in place. If I can remember, I signed this order in February of 2003. I gave everybody a copy. More specifically, item 12.
More specifically,
Counsel shall admonish all persons at counsel tables that gestures, facial expressions, audible comments, or the like as manifestations of approval or disapproval during the testimony of any witness or at any other time are absolutely prohibited. There have been this accusation throughout the trial that it has been going on back and forth. I have told you on numerous occasions I spend very little time watching the attorneys. I assume that you are all professionals, that I don't have to watch. You're all charged with the responsibility of following the law. So maybe I am misinformed when I think you will follow the law. But I'm beginning to see
Daddy
that
mad.
orders or anything else may not mean a hill of a bean to any of
Bye,
you.
Peggy. Have a great night.
So go look at it, and I'm going to do what I need to do.
I trust your judgment about whatever it is you saw, and I don't need to see it.
Mr. Mason, your side still wants to see it. Ms. Burdick, you want to see it? Okay.
I'm sorry, I can't hear counsel. I do want to see it has nothing to do with trusting in the judgment, it has to do with taking his hand. I got what's going on.
Well, they'll let you know as soon as it's available.
What are we doing? Ah,
Okay, court will come to order.
I allow
Both sides
myself
had
to
an
get
opportunity to view the
distracted.
video clip.
And then I'm like, what?
Anything the state would like to say, followed by the defense.
Your Honor, as I viewed the video, I appear to be smiling behind my hand. That is what I saw in the video. I wasn't laughing. I wasn't nodding. I was doing what
Send
I
'em
could
both
to
to
make sure that
jail.
my expression was not seen by the jury. If I exceeded this court's order, I apologize. But I was doing my best to make sure that nothing I said or did was seen by the jury. That's my observation of the tape.
Defense?
I have no other comments other than I would not request that Mr. Ashton be held in contempt because of his facial expressions. I think this case has been highly emotional for both sides. And all I really request is that it stop because of the serious nature of what's going on. I also apologize for getting caught up in the moment as well and making those arguments. But I think after 3 years of working with Mr. Ashton, I do not wish that upon him in any way whatsoever. And I as well have my apologies to the court.
Anything anybody else wants to say? Okay. I will accept that for now, but as I told both sides, if it happens again, the remedy will be exclusion of that attorney from further participation in these proceedings. As I told you at the bench,
It is.
there are at least 3 attorneys on the state side. I don't know whether Mr. George was going to participate in closing arguments, but it'll be either Ms. Burdick or Mr. George. And it'll be Mr. Mason, Ms. Sims, Ms. Medina, or whoever else y'all have over there, along with some other things that will be quite unpleasant. Enough is enough.
You're right, Edward.
Because of the delay, I will instruct the jury in the morning because we still have these final charges to go over. And I take responsibility for that since should have brought you back on Saturday afternoon to make you go over this charge conference. But I took y'all at y'all word that y'all would agree, and 30 minutes would be enough. Anything else? So when we finish closing arguments, then we will stay here to get these charges charged. I don't think it will take long. They're just about done.
Hey, don't forget to hit the like button, please. That helps the algorithm a lot.
All right, let's return to
Thanks,
jury.
guys.
As laid out throughout the course of this trial, this duct tape only points to one person. There's some doubt here. There's some issues here. There's some things that just do not add up. There's also something that you learn towards the end of the defense case, and that is the way the Anthony family had buried their pets. It's odd. It's different. There is a pattern there that each member of the family testified to, except George, again, had a little amnesia. George, the person who actually does the burying, who does all the work, seemed to forget, but yet Cindy and Lee clearly remembered. Why, instead of rebuttal of impeaching Cindy, did we not dig up that backyard? Why did George Anthony never tell police about the way they buried their pets? 3 years go by, and there's no mention of it. There's a chance to save his daughter's life. Mr. Ashton said, why would someone use 3 pieces of duct tape? Well, you recall Mr. Murdoch testifying that one was found 6.5 feet away. You recall seeing it attached to the hair of Kaylee, which would be the top portion near the top of the bag. There's any number of scenarios of what could have happened in 6 months. There's significant movement of bones where the state clearly brought out, one was found under 4 inches of muck, as they described it. That can move, but a piece of duct tape can't. I submit to you, ladies and gentlemen, that that's not reasonable. And it's also not reasonable to accept the constant lies and unique circumstances surrounding George Anthony and this duct tape. Now, I told you from the very beginning, I am in no way, nor are we in any way suggesting that George Anthony killed Kaylee. There's no evidence of that. There's no evidence of any murder in this case. And that has been our positions from the very beginning. We would never point the finger at someone that doesn't support any evidence. This was an accident that snowballed out of control. Whatever happened afterwards has nothing to do with the crimes charged. They have absolutely nothing to do with that. Mr. Anthony has on numerous occasions had the opportunity
Thank
to
you.
come up here
Thank
and
you
tell
very
the truth
much.
about these items. But given every single opportunity, he lied. He was impeached by the prosecution during the deposition. He was impeached here. He played games with the photograph. He danced around the truth and just refused to be upfront and honest. There's one thing you can see in George Anthony, and that is that this man doesn't have an ounce of paternal instinct in him. Not an ounce. Where he got up here on numerous occasions and almost with a bit of joy testified against his very own daughter. I don't know a father in the world who wouldn't fall on the sword for his child, who wouldn't attempt to try and protect her from the jaws of death. But not
Gotta
George
love
Anthony.
Edward.
Even Cindy Anthony tried, and you saw that. Lee Anthony, at times, was resistant, but you didn't see an ounce of that from George. George cares about George and no one else.
George cares about George.
Those were not the actions of a father. Throughout the course of this trial, as he testified, he didn't act like a father once. There were times where he actually smiled. There were times where he thought it was funny to spar with me. And there were times where he broke down and did displays of affection. But I submit to you, his displays of affection are not exactly very genuine. We had
You're not alone, Ben.
this young lady come and tell you about his displays of affection.
A lot of people
He told you
won't publicly admit it.
that
but
she had a brain tumor and he was going there to console her. There's
she
not
had
a tumor.
brain tumor?
There's nothing involved. She didn't have a tumor. It's
A
3 years
tumor?
later and she's still alive.
She had the
She
tumor?
came here and testified. She doesn't have a tumor. And he went there to her apartment at night and during the day when he was claiming to be working to console her. He's got a woman at home that needed consoling. Cindy Anthony needed consoling.
Howard Richards.
He wasn't home consoling her. He was consoling her. The state tried to impeach her about, oh, well, you sold your story. Yes, she did. And we brought that out from the very beginning. But there's one thing that's certain, is that she kept their relationship private until the police came knocking on her door, until it was already out there and made public. That's when she ended up selling her story, not before. She didn't expose George Anthony and say, I had a relationship with him. And by his own admission, he knew there was a guard at that gate that saw his coming and goings. He was a high profile person, couldn't get around, couldn't deny ever being in her apartment because she would have been the next person on that stand. He was going to her apartment to console her
Wada.
for some fantasy brain tumor that didn't exist. He came up here and he lied to you.
I also have this.
Oh, I'm just being a nice guy. George cares about George, not about his wife,
George.
not about his daughter, not about his family, about himself. And that's what this is all about. When you read it, it's all about himself. It's a self-serving, self-preservation document. Now remember, this is January. His relationship with his mistress is now over. Cops are coming around a little too often with search warrants, and they collect that gas can again after returning it. The gas can with the duct tape, which he can't seem to tell the truth about. And they're coming around, and they're asking questions, and they're getting his fingerprints, The walls are getting closer and closer to George Anthony. So what does he do? He gets a 6-pack of beer with some with some blood pressure medications and claims to commit suicide. This whole thing is about, oh, I'm sorry, I'm this, I'm that, you were the best. That's all George is about, himself. He had a gun. The only reason he got a gun was to get Casey back in jail, knowing full well that there could not be any firearms in the house. This is an ex-police officer. This is someone who knows better, who the person from home confinement said, listen, these are the rules. The second they're broken, she goes back to jail. He didn't care. It's because George cares about George. If he really wanted to kill himself, he certainly could have. And it would have taken a lot more than a 6-pack of beer and some blood pressure medication. This is a self-serving document. It's more of George Anthony's lies, and it's more of George protecting George. Calling the police on these gas cans on June 24th is George protecting George and George throwing Casey under the bus.
That was the stupidest thing I've ever heard of. I'm not gonna lie.
You saw the text message that he sent. He sent Miss Holloway, I need you in my life. Him and Cindy, he doesn't write Cindy and I need you in our life. Cindy's not going to her apartment at night. Cindy never went to her apartment. Cindy wasn't consoling her for her brain tumor, but he was. And before any of this, then he goes up.
I should have done this earlier before we started the second segment of his closing argument, but I just wanted to say thank you to my mods. Having 3 in here at once makes me calm. So I appreciate you guys. Thank you for everything that you do. And if you are watching and you see the mods, they're the ones with the blue wrenches, make sure to say thank you. Thanks, guys. And hit the like button.
And denies ever saying that this was an accident that snowballed out of control. He's telling her she's dead. And still showing another face to the media and the public. And he's going around doing all kinds of media appearances. Within 48 hours of his so-called suicide, he's in front of the cameras again. If there's one thing you've learned about this family and its dysfunction, is that they don't mind putting on another face. Lies are what pumps and what lives within this family. And I told you that in the very beginning. She was raised that way, raised to lie. Is it a surprise that she has this fantasy world? Is it a surprise that she has all of these imaginary friends? Is it a surprise that she turned out this way, knowing the lies and actually seeing them firsthand? And mind you, fortunately, they kept coming up on the stand again and again and again. So you got to see them on different days and you got to hear them change their stories and do different things. But the fact of the matter is, they raised their hand, swore to you, I will tell the truth, the whole truth, and nothing but the truth. And they lied. So now, as their own daughter stands trial for her life, you're supposed to rely on that. You're supposed to believe in that. And these are only the lies that were uncovered. What about all of the other things that could have been investigated and never were? How is it that they didn't get his cell phone activity during that time? How is it that they can't tell us the comings and goings of that? We have the most advanced technology available to us. If we don't use it and you don't go digging up things you don't want to find, you're not going to find them. And you're not going to have the information you need to render a just verdict. That's not justice. It's not justice, especially when you're pouring everything you can directed at only one person and you're not looking at the entire situation. No, it shouldn't have turned out this way. Absolutely. But they should have done more. They should have looked elsewhere. They should have opened that net. They shouldn't have been walking around with blinders. They shouldn't have been trying to put square pegs in round holes. And if they had just kept an open mind, they would have seen the rest of what was going on here. They would have seen that the truth wasn't exactly the truth and that there was more to the lies.
He just has to look down now and not just cry.
You heard Dominic Casey and Jim Hoover. Let's get their pictures up. Take the stand. You may recall both of these were private investigators working for the Anthonys.
I should actually write something in the chat.
And you heard something very interesting, and you saw a video of where they went out searching in November. You may recall Dominic Casey was the one that maybe provided us with a little comical relief throughout this trial. A strange man, to say the least. And his partner, Jim Hoover, when they went out and searched off of Suburban Drive. And not only searched, videotaped. For the very first time, they were looking for a dead Kaylee. And Mr. Casey says, well, it was a psychic that sent me out there. A psychic that was introduced to him by Cindy Anthony. And you heard Cindy Anthony get up there and deny ever sending him to the woods. And you heard George Anthony say that once I saw that video, he never went and asked Dominic Casey anything about it. He never said, hey, what were you doing out there where the remains were found? This is his private investigator who's working for him and his wife, and he never asks him. You may recall we showed you the email. It's Dominic Casey. And this is Jim Hoover. You may recall this is the location off Suburban Drive in the abandoned house where they were. And I asked him, you know Orlando's 101 square miles. Out of the 101 square miles of Orlando, this is the spot that they searched. And it's circled. You remember Yuri Melich came up here and circled this item right here as to where Kaylee was found.
Hey,
That's where they searched.
Washington.
And you heard Yuri Melich say that Cindy said she had her people walk that area. Remember, he took the stand, and then Cindy got up and denied it. Well, Cindy denied it first, and then Yuri Melich impeached her. Why is she lying? And then you heard Lee Anthony impeach his mother 30 seconds after she left the stand. In fact, it angered Lee so much that he stopped taking time off from work because they were looking for a live Kaylee originally, and now all of a sudden they're looking for a dead Kaylee. And you heard him. He said, I had enough. We got into an argument over it. I confronted her. This is a young man talking about his mother.
Yeah,
impeaching
but
her 30 seconds
there's a
after she
lot of
got off the
yelling in
stand.
that house.
They knew where she was. Casey was in jail. They knew where she was. And they were out there searching. What do you think the odds are that they would search at the same exact spot where she would be found a month later? What are the odds in having that video? Can you even count that high? How odd is that? Is that a coincidence? Is this a coincidence too? Is this a coincidence too?
God damn it.
Add them all together, and you've got something very suspicious going on. Very suspicious. And it has absolutely nothing to do with Casey. So, where's the truth in all of this? Where? It's not in the forensics. Where? It's not on their testimony. And these are the state's star witnesses, which one of them they had to impeach at the end of the trial.
Wait, who was impeached? George?
And remember, Kaylee was found with no socks or shoes. It's one fact I forgot to bring up while I was talking about the pool.
Talked about
That's
how
consistent
they always
with
put
someone
her
who was at home.
shoes on her.
She was at home when she died. She didn't have any socks or shoes on, and they didn't recover any shoes off Suburban Drive. You remember CSI Welch? I asked her two questions. Did you find any socks? And did you find any shoes? And she was wearing shorts that didn't fit her anymore. Hadn't been worn in over 6 months. And she had pull-ups on. And
She was probably
hadn't worn them clothes in a long time. Things are just not adding up here. Things just don't make sense. It is so difficult for you to find the truth. If it is difficult for you to find the truth, then this case is not proven. There is reasonable doubt. And remember what I told you about this case in the very beginning. Reasonable doubt lives here. It's throughout the case. It's right here. It's with these individuals. It's with those individuals. It's everywhere. You can't trust this evidence. You can't. When the state rested its case, we had no burden and we could have closed up shop there, but you didn't have enough information. You didn't hear from Carrie Owen from the FBI, Madeline Montgomery from the FBI, who tested the hair and found absolutely no drugs, found all the club drugs and tested for all the club drugs they could find and found none. And she said it was very sensitive, that they had a very sensitive measuring tools. The state wants you to talk about it's meaningless. Wouldn't have been meaningless if they found drugs. It's only meaningless when they don't find it.
You need a bath.
Heather Suber, the DNA analyst, who tested all of those items, the trunk, the car, her other items throughout the case. Marcus Weiss, Stephen Shaw, Maureen Bottrell, the soil analyst, who went and got every single pair of her shoes and didn't find any soil from the scene in her closet, and also those collected. Michael Sigmund, who did the air samples. Karen Lowe,
Hey,
Michael Rickenbach, and Lori Gottesman. 10 different people, 10 different state experts we had to call. So you can get all of the evidence. So you could see.
Hey, if you're watching right now and you haven't done so already, please make sure to hit that like button, the thumbs up. It helps the algorithm significantly, which pushes this video out to more people. Thanks. Bye.
That evidence either inculpates someone or it exculpates someone. And the reason they couldn't prove this case is because it wasn't true. Look at all of these. Look at all of these tests that they ran. No fingerprints on the duct tape, either at the scene or even on the gas can. No fingerprints on the duct tape at the scene. No fingerprints on the laundry bag. No DNA on the duct tape. If it was wrapped around her face, suffocated her to death, as the state claims, why isn't there DNA? Degradation? That's not enough. You heard Dr. Eichenboom, Mr. Eichenboom testify about that. You heard Heather Subert also testify. They wouldn't have tested it if it couldn't have been on there. The FBI searched for this. It came back negative, but it had another partial profile on it. One that they contaminated and another one on the sticky side. That, remember, was the 17 marker that excludes Casey, and more importantly, excludes Kaylee. If Kaylee had decomposed all over that duct tape, there would have been cell material on there. There would have been some DNA. We solve cold cases every day, 20, 30 years later, with DNA evidence. But 6 months, we can't solve a case? We can't find DNA on some duct tape? Duct tape's it's one of the best ways of getting this type of evidence. Not only DNA, but also fingerprints. And you didn't have that. No DNA on the paper towels. No DNA in the trunk. No blood in the trunk. No sticker on the duct tape at the scene. No chloroform on the car seat. No chloroform on the steering wheel. No chloroform in the bones. Remember, they searched, they did all kinds of toxicological examinations from the saline wash, from the bone marrow, from also from her hair. Nothing to match their case. Nothing that adds to their theories, to their hopes. Remember what he called it. They only hope. Their air tests, their chloroform, no quantitative analysis, the toxicology exams, all of these drugs, negative, 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 negative. No prescription, over-the-counter, illicit drugs in the bones. No hairs exhibiting characters of decomposition out of the other hundreds of hairs that they checked. The soil examinations, all of this stuff, the shovel, everything came back negative. The greatest crime lab in our country, all of this came back negative. As I told you in the opening statements, she's dumb enough to leave her child off the side of the road, just 19 feet, but she's smart enough to outwit the greatest crime lab in the country. That doesn't sound right. Doesn't make sense.
Well,
It
when you
goes
put
on
it
and on.
like that.
No tissue on the duct tape. Nothing. No maggots in the trunk outside of the very few that fell out of the bag. Everything else was in the bag. No blowflies in the trunk except that one leg.
I need to
But
put this
remember,
on,
there
so
were
I'm going to
75
mute my
in the bag.
camera.
Well, how'd they get in there? 75 early colonizers in the bag, but not one of them made it into the trunk, or at least only a leg got in the trunk, and it was in the trash bag. And remember that paper towel had marijuana. Remember the fatty acids that Arpad Voss tried to say was adipose here, but yet had marijuana also. That doesn't make any sense. That's nonsense. How ridiculous can you get? No discoloration inside the skull. Remember Dr. Spitz, you'd be hard pressed. We were very fortunate to have someone as qualified as he was to come here and testify before you, to be able to tell you about this issue and how if someone dies of suffocation, you would have that. No trauma, no fractures. The list just goes on and on and on. No prior injuries.
We have 50
Nothing.
likes.
No cause of death.
You 50 likes?
It adds up to only one thing. If you look at all of the evidence here, it only adds up to one thing. And that is, she died by an accident. This was an accident that snowballed out of control. Now, again, the defense has no burden here. Defense didn't have to call these people. In the presentation of the evidence that you got from the prosecution,
Yes.
included this
50
person.
likes.
this person, this person, this person, this person, and this person. And I would be willing to bet that most of you probably don't even remember any of them. But they failed to call this person. Do you even remember what these people talked about? The man who finds the body is never called by the prosecution.
Counsel's violation as to number
Sustain,
4 in the court's pretrial order.
sustain, continue.
Defense called Roy Kronk to show you that there were some very suspicious circumstances surrounding his discovery. We never suggested to you in any way, shape, or form that he had anything to do with Kaylee's death. We never said he packed up her remains and took them home. But there's one thing we did say, and one thing that is uncontroverted, and that is he knew where she was and had control of that for at least 4 months. If you look at this up, this is what I showed you at the beginning of this trial, and this is what actually came out. At approximately 1 p.m., he's there with his coworkers on August 11th. He tells his friends, hey, I think I see a skull here. A skull. But they get distracted by the snake. Forget the snake. They forget the skull and concentrate on the snake.
Where's
and he never
Tex
says a word about it to
when
his
we need
coworkers
him?
ever again.
To talk about the snake.
He goes home that afternoon, and calls 911 at 4:28 in the afternoon. And he tells them, I see something round and white. He's describing a skull. They don't find anything. Nothing happens. So he calls again.
I think
On
he's a
8/12.
weirdo.
And he gives even a more comprehensive description. You have the 911 calls, so you will be able to hear them. Well, you heard them. He starts giving more of a description. And he says something very interesting. He says there was a tree there that had a fallen tree that looks like somebody had cut it. Now, if he's 30, 40 feet away, like he said, came here and testified to, how would he know so much details that someone tried to cut this tree? Then he says this, there was a white board hanging over it. There was no white board recovered.
Yeah, we don't want to spread it.
This, I suggest to you, was a marker where he may have hid her remains under the tree. The tree that took two people from CSI to move away. You may recall them testifying that. Well, how heavy is this tree? Is it too heavy for someone who weighs 100, 105 pounds soaking wet? Not so heavy for a man who weighs about 250, 300, well, 250, he's about 6'1", 6'2". These remains were hidden. We all saw how close, the 19 feet. From here to the witness stand, maybe a little further. From the side of the road for 6 months. But there's this white board there that no one finds, no one photographs on December 11th. What happened to the white board?
Thank you.
Who moved it? Not Casey. She's been in jail. This is in August. She's already in jail. In the short time she was out on bond, she was under house arrest, and the media, 10 media trucks parked outside her house. So somebody moved that whiteboard. Somebody moved that tree. At the very least, you must reject whatever was found there, the conditions of which it was found. Because as all crime scene people testify, you never get a second chance at a crime scene. You never get a second chance. If you want to get reliable information from a scene, it cannot be contaminated. It cannot be staged. If it's staged, it's useless. It's pointless to review it. Because whatever you see, you must reject. And that's what happened here. On the 13th, a police officer meets him there. Deputy Kane comes out and meets Roy Kronk to show him, so he could show him where the bag of bones are. They didn't find it. She was not found on August 13th when the police officer went out there. And all Kronk could say is, well, he wasn't very thorough. Well, it's 19 feet away from the street. And remember, there was about, as Mr. Murdoch pointed out, there was about 6.5 feet of grass. If you're this close, how can you not tell the officer, it's there, it's right there? No, the officer was rude to me. Okay, let him be rude. And just as the prosecution pointed out, why not grab the bag and go down the block and say, news media, here it is. I found her. Give me the reward. I've got a story for you. Why let the rude officer treat you that way? Why not point it out? Something is wrong here. Something very shady. And $255,000 is a motivation for someone. And he admitted it.
Hell yeah.
I asked about the reward. I said I won the lottery. He said all of these things. And he also called his son in November. You heard his son say, my dad told me he found Kaylee. Brandon Sparks had no reason to come here and lie to you and testify against his father. He wanted to have a relationship with his father. They were estranged and they were just starting to build that. He completely impeached his father's testimony. And not only did he impeach it, Mr. Kronk impeached himself. He admitted to you on December 11th, when he happens to be urinating for the second time, 4 months later, he finds her remains. He tells the police in 2 different statements, I lifted the bag up about 4 feet off the ground and the skull dropped out. Well, that's not consistent with what the police found. And they went back to him on the 17th, and that's where he changed his story. You heard him say it, I changed my story. 2 different statements. And what's glaring and what's missing here is on the 11th, when they ask him, so do you have anything else that's important that you want to add? He doesn't say, yes, I called you 4 times 4 months ago. He doesn't say anything. He keeps that quiet. It's not until they go back and he knows they've got the 911 calls. They've got those previous crime line tips. My story is different. I better play ball. Yeah, the skull didn't drop out. It didn't roll out of the bag. It was there. Changes his complete story. Now I submit to you, ladies and gentlemen, how can you trust it? How can you trust anything at that scene if it's staged? Any of it. We know by Dr. Spitz has proven that it was not as they found, her skull was not as they found it. We have Kronk lying about the skull rolling out. And remember, in August, he's doing all these 911 calls and talking about a skull. The skull is outside of the bag. But yet on December 11th, it drops out of the bag. Well, who put the skull back in the bag? Somebody had to. It's in his own sworn statements. And it's not until he changes it that he admits to that. But those statements are etched in time. There's nothing that could be done. And you know now that he changed his story. And you also know now that those remains were hidden. Those remains were in a bag. This man is lying. How can you rely on any of that evidence? In your deliberation, you cannot trust this evidence. You can't trust this scene with all of
He
this.
sounds
going on.
guilty. Have you seen him? He looks
just can't.
guilty. Not very
There's something not right here. And again, reasonable doubt is breathing and living in this case. And it's living right down to the very end as to when they find her. And if it weren't for the defense finding Brandon Sparks, his own son, you wouldn't have had that information. If it weren't for the fact that we called Mr. Kronk to testify, you wouldn't have had that information.
Tamara,
You
dude,
wouldn't have had any of this knowledge when making a
super
decision
sketch.
to take someone's life, when making the decision to convict someone of murder, aggravated manslaughter, aggravated child abuse. You wouldn't have had any of this information. None of it. Information that you can see is critical, clearly critical.
I was literally just looking at my hair color. This is my natural hair color. Okay. All right.
We keep getting back to that one central question, and that is how she died. And right now, as you sit here, you must certainly have more questions than answers. And the judge will instruct you on what the law is and how it must be proven. And there's no way in looking at all of these circumstances that you can say that this case was proven beyond a reasonable doubt. There's just no way. And there's various reasons why this is such. It began with part of the cover-up. It also concluded with part of the information and the investigation as to where it was carried out. To find her guilty of any single charge, any single one of them, you have to have an abiding conviction of guilt. That's what you have to have inside of you. You have to know that this case was proven. You have to know that these facts were proven. And you don't have that. And however tragic this case is, you cannot continue it. You are the ultimate deciders of what the facts are. Now, Mr. Mason is going to come up and show you the different charges and explain to you how the law will be applied in this case and how we suggest that you look at it and how the judge will instruct you on it. I thank you all collectively and individually for all of the attention that you have given us.
I want everyone to
and the
be able to say
prosecution,
what they
and how you've
think
been able to keep an
and
open
not
mind
feel bullied in
despite
here.
every
So
reason
I
not
love
to.
that you guys are doing that.
I know that it has not been easy. This prosecution knows as well. And there have been times where emotions have gotten high. But you're here to fulfill an oath. You've labored tremendously over this journey.
No, Debbie.
And we're going to ask you to render a verdict of not guilty on these charges because they simply were not proven. And they're simply not true.
Lovely penmanship.
Just look at what they have and what they don't have. All the fantasy forensics in the world don't make it so. All of the lies that you've had to swim through don't get you any closer to the truth. You can't get any more serious than this. The stakes cannot be any higher. And we ask that you use the law as your guide. Thank you.
Mr. Mason.
Oh, look at this.
We'll take a stretch break. Yeah. We'll take a 10-minute stretch break before Mr. Mason starts.
Thank you, maybe not. Oh, ho, ho, ho. Always a good day when you have a dog. Always.
State recognized presence of jury.
Yes, Your Honor.
Defense.
Yes, sir.
Mr. Mason, you may proceed, sir.
Thank you very much. I know that you all would like to spend another 10 or 12 hours listening to lawyers. I can see it in your face. But unfortunately, you're not going to get to do that, at least from me. but we'll spend a few minutes. And I begin thinking about where we are and where we've come from since May the 9th
Let's try
in
to
Clearwater
not
to
do
now.
politics.
And we're about to put on your shoulders
Talking about Casey.
the most solemn responsibility that you individually or all of you have ever had to face. And all I can say about that is you agreed to be able to do it. And I hope you all survive it with good senses and pride in what you do, just like we will, hopefully. And I begin my comments. I want to devote just a little bit of some philosophy. A very dear friend of mine named Milton Hirsch, an author, and in fact a judge in South Florida, advised me of this parable, and it's always fun to go through. History records that on May the 19th of 1790, the skies over Hartford, Connecticut turned from blue and sunny to black and stormy with such speed and dramatic force that the people believed the end of the world was at hand.
That's beautiful, maybe.
The Connecticut House of Representatives was in session at the time. Some of its members dropped to their knees in prayer as others clamored for adjournment. The Speaker of the House, a Colonel Davenport, rose to his feet and restored order with these words: "The day of judgment is either approaching or it is not. If it is not, there is no cause for adjournment. If it is coming, I choose to be found doing my duty. I wish, therefore, that candles be brought." Today is Judgment Day in the United States, as to this Constitution. Tomorrow will be Judgment Day, as to the Constitution. Every day in which an American stands trial for his liberty before a jury. Every day in which an American is arrested or his home or property searched. Every day in which a voice is raised in speech or song. Every day in which a vote is cast or counted. Every day in which a newspaper is printed or read. Every day in which a lawyer is asked to defend an unpopular man or an unpopular cause is Judgment Day for the United States Constitution. We can cower before the storm, or we can light candles. Well, let us light some candles. On this eve of the 4th of July, the anniversary of the freedom of our country and the beginning of a constitutional government, there are some things that you're going to hear about that are extremely important.
Okay.
And that is
sir.
the constitutional rights and constitutional protections that afford the freedom to each and every one of us in this room.
He's speaking my
And
love language.
interpreted with some very special rules for Casey Anthony. Now, when I finish, my colleagues from the state attorney's office,
He drives me
all
crazy.
times, will either together or divided up in some fashion, will stand and they will present arguments to you. And when they're done, I guess probably tomorrow morning, as I'm understanding it, Judge Perry will then read to you the instructions of law that you are required by your oath and required by the law to follow. And I can tell you now that there are going to be some questions asked about those, because in truth and fairness, we hadn't been able to get all together to finalize what it's going to be, but we're working all hard on it. You, at least, however, will not have to memorize it. You will be given 12 sets of these typewritten instructions so you can read them and discuss them, argue about them, try to understand what they mean. And I know, actually, that you will be able to, because despite how long it's been, I remember all the process of the jury selection. And I believe that you all have the cumulative and individual abilities to analyze and to resolve your questions regarding those instructions. So I'm going to tell you what some of them are. And one of the ones that governs about everything that's going to happen in this case is an instruction that is entitled, when you get to them, plea of not guilty, reasonable doubt, and burden of proof. And I do not intend to belabor all of that now, but there are some things that control the major lighting of candles that we're going to do in this case. And that is, Casey Anthony is not required to present evidence or prove anything. And you may remember
That is true.
that concept was discussed with you in Clearwater, not just by lawyers asking questions, but Judge Perry looked to the side to each one of you and discussed that with you. And every one of you understood and agreed, I accept that. Each of you accepted the constitutional principle that is one of the cornerstones of our freedom I'll say it again. The defendant is not required to present evidence or prove anything. And you must remember that concept with every issue that you discuss when you're back there in the jury room. You can get caught up in emotional rhetoric. You can get caught up in conflicting positions amongst you. But no matter what it is, the defendant is not required to present evidence or prove anything. Said another way that you must carry with you throughout all the discussion is that the burden of proving every required element in this lawsuit rests with my colleagues from the state attorney's office. And they don't shy away from it.
Debbie.
They've accepted that. That's their responsibility.
No colluding
Never
in here,
forget,
please.
no matter what the issue is, they have all of the burden and there is none over here.
At least wait for Peggy.
Because that is what separates our constitutional government and freedom from so many others in the world. It is your duty to absolutely ensure that those rules are respected and honored through every stage of your discussions. The court will tell you that every element of the offenses is required to be proven beyond and to the exclusion of every reasonable doubt.
Oh,
every
Feeding
reasonable
time.
doubt.
I gotta mute myself, guys.
And if the state of Florida fails
Same,
in that
Georgina.
burden of proof as to any element of the offenses, then you are required, like it or not, emotional or not, it is your solemn sworn duty. You are required to find the defendant not guilty. And that goes to every
First
single
Amendment.
element of each charge in this case. Only if it can be said in your conscience, in your intellectual honesty, that the state has proven the elements beyond a reasonable doubt, may you consider finding the defendant guilty. So, with every issue that is raised, burden of proof, no burden, reasonable doubt. That'll help you get through it. The court is going to tell you that it is your province to weigh the evidence, not the sparring between the lawyers and not the stacks of 366 pieces of something and boards and whatever else. You, jurors, are the ones who weigh the evidence and decide what evidence is reliable, what evidence you are skeptical about, what evidence you don't trust. It's out of the lawyer's hands. This is for you to decide. And the court is going to give you some guidance. I mean, we don't just look at somebody and say, well, I don't like the looks. Well, that guy's too old, or he can't hear, or whatever the issues are. You look to some rules to guide you on the evidence, such as, did the witness seem to have an opportunity to see and know things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Oh my, we've seen a lot of issues about that from that witness stand in the last 6 weeks, perhaps. Did the witness have some interest in how the case should be decided? You know, like being able to.
Whenever I say, like, this is driving me crazy, my father-in-law will say, "Oh, it's not a short drive."
Make some money
It's not a far drive.
or
Thank
something
you.
like that.
Thank you for correcting me, son of
Did the
said
witness's
man.
testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? That's, you heard the term from time to time, objections and arguments and stuff about impeachment. And that's what we call it when you catch somebody changing their story that they said sometime before under oath in a deposition. You have the right to believe or disbelieve all or any part of the evidence of any testimony of any witness. 100% of the people that sit in that chair, you have a right to believe all or none That's what a jury is about. Otherwise, we use a computer with all these little things, machines going around. I don't know. Maybe I'll live long enough to see we won't even have humans as jurors. We'll have some kind of machine inside for it. But for now, you get to weigh and judge the credibility of every single witness. The court's going to give you an instruction about expert witnesses. Remember all the people we had talked about, go through this and that. And the judge, you declare them an expert, and the judge will tell you, ladies and gentlemen, so-and-so is an expert in this or expert in that. And you can consider that. However, you're also going to be told that, like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. So just because they may have met a criteria, a threshold to be anointed by Judge Perry as an expert doesn't mean you got to buy it. You may or you may not. That's part of being a jury. Now, thinking back to your oath, your discussions with Judge Perry in Clearwater, we now are going to talk about the elephant in the room. And I know what it is, and you know what it is.
I don't know.
My client, Casey Marie Anthony, with the advice of counsel, made her decision to not testify in this case.
Thank you.
I didn't reach my age and try cases this long and not know that's still on your mind. But you swore an oath as jurors to rise above bias and prejudice and media impact and so on. The judge will tell you as follows. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as admission of guilt or be influenced in any way by her decision. Again, you must not view this as an admission of guilt or be influenced in any way by her decision. A promise you made, and a promise that must be kept if we're lighting candles for our constitutional rights and freedom. No juror should ever be concerned that the defendant did or did not take a witness stand to give testimony in this case. Burden of proof, no burden, beyond a reasonable doubt, and don't dare think that you can consider the fact that she did not testify. As fundamental a right as we have.
Here to do.
Born in the Constitution, in the history of our country since we've had the Constitution.
Get me all riled up and patriotic. I wish I could show two things at once.
Order, I'm going to discuss a subject that you will have to consider. Counts, you didn't hear a whole lot about, but counts 4, 5, 6, and 7. When you see the indictment, you may remember from Clearwater talking about it and the reading of the indictment. Allege that Casey Marie Anthony made false statements to Yuri Melich. Now, you know who Yuri Melich is. You've seen him on the witness stand a dozen times. She made some false statements to him in different times and places. And the court is going to tell you that the instruction of the law is you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, is what it says, whether when the defendant made the statement, she had been threatened in order to get her to make it, and whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. I'll call your attention to some of the evidence on this. You may remember a recording made where she was questioned by 3 detectives in a small room that was described as about a 6x8 room. I think they even put pictures in to show you this tiny little room. And you remember, if you will, hearing those detectives yelling at her. 2, 3 at a time, like some TV show, not allowing her to answer, berating, arguing. So You may also remember that in the initial part of it, interesting enough, there was a dispute among the law enforcement officers. You had a sergeant say she was not handcuffed, she wasn't arrested, and then young Mr. Everlyn comes in and said, "Yeah, she was handcuffed. I did it." Put her in the cage of Sergeant Acevedo's car, and the prosecution then retorted by asking, "But she was free to go, right?" Okay, so the bottom line is, when you consider those things, consider those counts, consider whether or not the law has been met. If she voluntarily made those statements, if she wasn't under pressure, coercion, duress, not being threatened, not in a small room with 3 detectives, and she made a statement and you say it was false, then find her guilty of it. But the law says if she was not freely and voluntarily making those statements, you should disregard them. And if the statements are gone, so are all the counts.
Very interesting, sir.
The initial charges, the main charges in this case, of course, are first-degree murder, which requires the government to prove some things that are obvious. Are we arguing that this unfortunate child is not dead? Of course not. It's a tragedy. All has never been an issue in this case. So, but it's on there. You may wonder why do they do that? Kaylee Marie Anthony is dead. Well, okay, yes. The death was caused by the criminal act of Casey Marie Anthony. Now, caused by her. Well, what act? What act? You will also hear, and you will read the instructions as charged in the indictment, that this was done by a premeditated killing. And or alternatively, you will be able to consider whether or not there was a felony murder underlying that, and have fun reading the instructions on that. We're trying to make them as clear as we can. And the bottom line is, there's 2 theories. The main thing is, what act? The judge will describe and take the time, and you'll get it. What does premeditation mean? I'm not going to belabor it. You'll also be given instruction on dealing with the offense of felony murder of the first degree. And that is, once again, that Kaylee Marie Anthony is dead. And the death occurred as a consequence of, and while Casey Marie Anthony was engaged in the commission of aggravated child abuse.
My Lord. It's a whole lot of words.
And we've been here, I'm not sure what day of the actual trial this is. The only thing I'm real clear about it is Sunday afternoon.
842 days.
Where, what, how, when, and why is the evidence of aggravated child abuse? All of the witnesses that took the stand didn't know anything about Casey Marie Anthony. Confirmed that she was a loving, doting, devoted mother. She was a young girl. She's only 22. My shoes are that old. The child was well fed, well nourished, well taken care of, bright, had no evidence whatsoever of any prior trauma of any kind, no torquing of joints, no twisting of bones, no closed fractures, nothing. Or, the law says, that the death occurred as a consequence of, and while Casey Marie Anthony was attempting to commit aggravated child abuse. And that Casey Marie Anthony was the person who actually killed Kaylee Marie Anthony. All the emotion, all the suspicion in the world doesn't prove it. Burden of proof, no burden, beyond and to the exclusion of every reasonable doubt. You will get an instruction hoping to help you understand what is meant by aggravated child abuse.
Is it will a through?
One of the parts of that that's being added to it is a definition of willfully. Not unintentionally or not accidentally, but willfully causing child abuse on Kaylee.
Please no
I
distraction.
may not indeed
Go.
have been able to hear everything. You may have noticed, as we both have on our tables, as does the judge, special computer where she sends me what's being said. So when I can't hear it in the acoustics of the room, I'm sitting there trying to read it. And I never heard nor read, in this case, any evidence of child abuse of any kind.
Sorry, guys. Please do
I'm not going to further belabor all of those instructions because you'll have them to read, but I'm not done. It's not that easy. The instruction is going to tell you that you may
Yes,
find a
ma'am.
reasonable doubt based on the evidence or the lack of evidence. Now, Mr. Baez went through a lot of things with you about what is or is not evidence. And forgive me if I repeat some of those, but I had made a list of issues that I thought were not proven in this case. You have the absolute right, of course, to disagree with me or say, yeah, that's right. And to think of some others on your own, which I know you will. So I'm going to run through it just real quickly, just to give you an idea what we're talking about on lack of evidence. This is a criminal case. Those charges. No fingerprints on the duct tape anywhere or on the bags or on the bags or anything that were searched and seized by warrant from the home. Interestingly enough, we learned that the infamous gas can with the duct tape, no duct tape, had been wiped clean. No prints. Toxicology tests.
You
Dr.
cannot use
Goldberger,
my mouse,
part of
cat.
the forensic team doing the autopsy studies for Dr. GRWM, was charged with the duty of seeking to find chemical evidence of chloroform and several other drugs or poisons. Zero.
Oh, I'm sorry.
Found zero.
Please don't bite me. Don't bite me.
Mr. Bias did talk about there being no DNA. It's 2011. The case occurred in 2008. It's not new. The only profile of DNA evidence, as you heard a little while ago, excluded, meaning that not the defendant. DNA evidence, as you heard, if you remember how much fun it was to listen to, is to try to say that this DNA evidence matches you, or not you, individual, I mean you, a person, somebody else. It's a statistical probability.
A
If there
statistical
are
probability.
these markers on these alleles, as were shown to you, the more there are, the higher the probability. And the general rule, I think they testify to, if I'm wrong with that, forgive me, that when there are those 13 markers, then the probability of that person, subject that gave that DNA, not being the one matching to
5
that,
subs.
it's like 1 in 14 quadrillion. That's 15 zeros. But if the DNA has one, just one marker that the subject does not have,
Sorry.
that means it's excluded. Cannot be. And the FBI confirmed that the profile they got from that tape excluded Casey Marie Anthony and the child. There was no evidence of decomposition found at the recovery scene. The entomologists talked about what must have decomposed somewhere else. It wasn't here. No bugs, whatever. No other evidence of it. Mr. Bias pointed out to you there were no bugs on the trunk, only in the trash. The issue of chloroform was brought up from the beginning. What a media baby this was. And I must remind you about this evidence. Dr. Michael Sigmund is the one who extracted 2 bags, Tedlar bags of air from the trunk of the car at the same time, in the same way, at the same place, and took one to his lab and sent one to Dr. Vass's lab. Dr. Sigmund's lab says major compound was gasoline, and then there was some small trace of chloroform, which he also said is everywhere.
Well, for
Everywhere.
you.
And the opposing side said, oh no, we had this shockingly high level. We don't know how much, but it was shockingly high. And as Mr. Bias said, Dr. Rickenbach said, no, very, very low. Search warrants at the house 3 times. Yeah, you know, they,
Sorry,
in the
guys.
common
I
sense
have
experience, you know,
rheumatoid
the police don't
arthritis,
call up
and
and say, by
all
the
of
way,
a
we'll be there
sudden,
at 6:45 when the search warrant be ready. Search warrants are issued constitutionally through a legal process and orders by a judge, and the law enforcement officers go, surprise.
it's
And they
not a
searched
sexy thing to talk
They Anthony arrested. And they searched it all, as you recall, seeing pictures. They searched everything. They found no chloroform, no bottles of ingredients, no papers related to it, nothing. So then the issue, one says, what does all this chloroform mean? Was it, at some point in the case, is it chloroform used to poison this child and to knock her out and kill her? Or was it chloroform that was ultimately
Raise your hand if this trial made you Google chlorophyll and chloroform. I'm willing to admit it. I wanted to see the differences.
alleged to be found from the decomposition suspicions from the trunk of the car? Not both. And there's no evidence of what it was. So, but it sounded sexy for the media. The heart-shaped sticker deal, Mr. Bias. Laboratory analyst at the FBI says she saw an image of a part of a heart shape on the corner of duct tape, the language I recall. But when she went to take a picture of it, poof, it was gone. Poof, it was gone. And then, of course, they brought in as evidence some thick item attached to a piece of cardboard, which when it was presented to you, I don't know what number it is, but it was separated, and that had been found across from the school in the distance from this child. Mr. Bias talked about numerous other things, the searches comparing shoes and the shovel and so forth. Let's talk about some other things. Unusual in a murder case or any criminal case. Not even a hint of a claim that there was any form of admission of wrongdoing attributable to this defendant or any confession. No witness anywhere that she did anything to this child. None.
Stop.
3 years of investigation
Stop.
and however much money.
Don't
None.
me.
Why would she kill this child? There's no evidence of a motive to kill this child. Am I hearing him suggesting that she wanted to party? Well, she did that anyway. She had babysitters. The boyfriends liked this child. Everybody had a good relationship. Why in the world with the mother that you see in the video? Why in the world with the mother that's been so devoted to this child, trying to protect her and take care of her, wake up one day and say, well, I think I'll kill her? You learned about trace evidence and you learned about all the scientific stuff. What we didn't learn about was anything to link any wrongdoing, as example, to the inside of the car. The steering wheel cover, the car seat, anywhere inside at all. Yet we're told that, somebody did like that, DNA or some skin cells or move this chloroform or whatever is alleged is used as a weapon somewhere. None. I suspect that you, individually, collectively, can make a much longer list than I did, sitting here quickly, of the things that there's no evidence of. I don't know what the odor was or what there wasn't, but I was certainly intrigued to learn that at least 7 law enforcement officers on the hunt did not smell any decomposition or strong odors in that automobile. I remember Mr. Simon Birch, I suspect in Australia or New Zealand, didn't find out, tow truck guy, said that he had a history of 6 or 7 or 8 prior experiences of decomposing humans from suicide or otherwise in cars that he had repossessed. But in this one, there may have been a little odor, he says, but with that experience and that consciousness and talking to Mr. Anthony about his missing daughter and grandchild, neither he nor George called the cops. Instead, he takes the trash out of the trunk and says, this is your source of the smell, flips it over the fence for the dumpster.
Can we get 3 more?
All of these
subscribers,
things
please?
start mounting up reasonable doubt. This business about this tape as a murder weapon on the guess of probabilities could be How many times did you hear somebody say could be, might be, maybe? And today's opening statement by Mr. Ashton, he said on several occasions, in all likelihood, the characterization that he made himself about something, in all likelihood. Well, in all likelihood doesn't quite make it. Let's talk about what burden of proof really requires and how it means and how you can think about it. You may have other definitions and other, can you see them? You've seen it before. Sir, ma'am, all of you. If you have if you go and you listen to the rest of the arguments and the evidence and you talk about things, you just discuss it. Oh, sorry. Can you all see it? Okay. You may have an absolutely abiding belief now or tomorrow or whenever that is not guilty. That's easy. Not guilty. Done. You may decide it's highly unlikely that she's guilty. Okay, good. But all these mean not guilty. You may decide that it's less than likely, unlikely, possibly not, may not be, perhaps. All these you'd be thinking, well, you know, I'm not sure, but you know, maybe she's not guilty, possibly not, maybe not be, perhaps she's guilty. Also means perhaps she's not. Suspected. You might suspect that she's guilty. That's not proving guilt beyond a reasonable doubt. That's not here. Possibly guilty. Possibly guilty. In all likelihood, possibly guilty. Probably guilty, moving up the scale. You have probably guilty of something. Guilty of what? Probably guilty of something, but probably guilty of what? Still not beyond reasonable doubt. Guilt likely, you may say. What? You know, I'm confused, I'm a befuddled, this is a bad deal, all these sort of things come together. Maybe guilt is likely. That's not beyond a reasonable doubt. Or I got a strong belief in guilt. No, no, and no. Unless the state has proven to you beyond and to the exclusion of reasonable doubt, then whatever these other, if these are your evaluation thought processes or others that may be in your own mind similar to that, there's only one answer. It's not guilty. It's not guilty because the state hasn't proven guilt. Now, there are a few things in the world that are absolutely subject to clear proof in our life experiences. Very few. People can talk about 100% this, 100% that, like Dr. G. The only thing I know that people are going to do, what 100% are going to do, is die.
I agree.
Anything else is 100%. We used to say taxes, but we know better than that now. A lot of people are not doing that. That's why we have a system that says the state has to prove beyond a reasonable doubt everything. And if they fail to do that, then no matter what you may think in this continuum, strong belief, guilt likely, probably going on down the line, your obligation is to, wait a minute, they haven't proven beyond a reasonable doubt. If they don't
At a
prove beyond
bare
reasonable doubt,
minimum, she should have called the cops.
this is not
Bare minimum. Like, let's
one of the
be
things I
real.
was just also thinking about, going back to that list of evidence. This bothered me because I don't know the answer. I don't know the answers to a lot of things here. You don't either, I'm sure. Mr. Bias was talking about Mr. Kronk. Why? Another question for you. Why would an uninvolved citizen, after calling the police about finding the skull,
Ooh, good point.
in a situation
Anthony.
that is really just hundreds of feet around the corner down the road from Anthony residence where all cameras are and so forth,
Hi, maybe.
nationwide lookout. Y'all remember that? Said so during jury selection. Why in the world would the man sit silent for 4 months?
Yeah.
I do not know the answer to that. I do not know how it is that he testified that he took his meter reader stick and put it in the right orbital socket of that skull and lifted it. Yet the claim is that it was found embedded in the leaves and muck. Or was there in fact some repositioning, some posing, or something to make a case? Dr. Schultz said there was no tape on the nose. Dr. GRWM said there was some tape in the vicinity of the mouth. She concluded that the manner of death was a homicide on totally circumstantial evidence because she said so emotionally no child should have tape on her face. Well, there's no evidence that she did. Remember all the stuff, all the DNA, all the no. And Dr. Warren, who did the superimposition photo stuff, said it could have. So we have, in all likelihood, we have a could have, we have in the vicinity, may have. This is not a could have, may have, so forth. This is a charge of murder in the first degree and serious other charges of aggravated manslaughter and aggravated child abuse. We all know you accepted, and I close with this.
We just need 3 more subs to hit
You have a duty.
1,500.
I have been doing this for many years. I'm an idealist. I believe firmly in the integrity of our courts and in the jury system. Ladies and gentlemen, the reality is a court is no better than each of you sitting before me on this jury. The court is only as sound as its jury, and the jury is only as sound as the men and women who make it up. I am confident that you will review without passion the evidence you have heard, come to a decision, and restore Casey Marie
What
Anthony
is
to her freedom.
this?
And you will do your duty. I will not claim origination for that. Some of you watch so many movies. That's from Atticus Finch to Kill a Mockingbird. I do not get the chance to get up again and talk to you. So I ask you to do this. Pay the same respectful, intelligent
Was ist
attention
das?
to my colleagues, whichever gets up next. Realizing that we got to sit over there. I have to sit over there and squirm because I can't get up. Can't get up and say no, but. So I ask you to consider this. Any and every time an issue is raised that piques your curiosity and you haven't been satisfied that the evidence proves it beyond a reasonable doubt, ask yourself,
I
what would
want
Mr. Mason
to. Yeah.
argue about that or say in response to that? And you do it. And then you do your duty. You light your
Yeah,
candles
we will.
for the Constitution and you do your duty and you find Casey Marie Anthony not guilty because they have not proven her guilt. Thank you very much.
I might pull up my other computer.
Okay, we'll take a 5-minute break before we
Screen.
proceed to the rebuttal argument by the state of Florida.
To get your feedback on some items.
State recognized president of the jury. Defense.
What we do?
Okay, members of the jury, the time is now approximately 6:36. I've had the court deputy inquire, and I'm going to make an executive decision to recess for the evening. Some of you are doing fine, and some of you are tired. I want all of you bright-eyed and bushy-tailed. Been a long day yesterday. It's going to be a long day tomorrow. We're close to the end. Again, I'm going to ask that you not to discuss this case among yourselves, nor with anyone else. And we will see you where we will start at 8:30 tomorrow morning. Members of the jury, you're hereby excused. You may be seated. We need to complete the charge conference. I need to
Hello.
read over the final copy, which should take me about 15 minutes. And then we'll go ahead and complete the charge conference.
What's a charge
There was a
conference?
request made by the state of Florida. As I told you, I do not want to guess at the answer. I don't know the answer.
Okay, let me.
It shouldn't take us long to do the charge conference. Whatever authority you have for that proposition, email it to me by 9:30 p.m. tonight. And I will look at.
I'll draw the request, check council doesn't use them, that's fine.
Oh, the
Okay, we'll be at ease.
got
I
it.
can go down and get
Every state
instructions,
says it differently.
and then we'll complete the charge
Okay.
conference. Okay, we'll be at ease.
Charge conference is
Murder, first degree. Note the added language
Verbiage
that the state
on
has
the
requested, which the defense has
instruction.
objected to. The defense can object to that portion and then indicate whether or not there are any additional objections.
Your Honor, we object to the deviation from the standard jury
Okay,
instructions
well,
within
that's
this
cute.
instructions. Other than that, we have no objections, Your Honor.
Long day, folks.
Just taking a temperature, seeing where we're at. Making sure it's still just the charge conference.
The merger doctrine?
And you need to read that in conjunction with the special finding as to count 3.
Okay.
Read over
Yep,
those 2.
We're
and
going
Sing out when you're
to
finished.
finish this up.
You may be seated.
And I have this at 1.5 times speed. So
Hey, good morning. Let
it
the record
won't
reflect that the
take
defendant is
a
present
full
along with
2
counsel for the
hours.
defendants, assistant state attorneys. Both sides ready to proceed?
Sir.
Okay, have you received the copy of the final instructions? Okay, before I will give them, you'll have an opportunity to make sure they are in proper form. So we have an opportunity just to double check them. Mr. Baez?
Yes, sir. I just wanted to clarify one issue with the state's rebuttal argument. We, of course, objecting to the court allowing them to now split up the arguments after the court had ruled previously that the only argument that could be split up would be their initial argument and not the rebuttal. I certainly want to, I guess, make sure that this is just not a second closing argument as opposed to a rebuttal where, since Mr. Ashton during his initial closing argument actually covered quite a broad range of topics. And I wanted to raise and renew our objection to that. The remedy that they seek, they received when they objected. So that would be just our argument that we would like to lay out for Your Honor.
Okay. If they exceed what rebuttal is, the objection is simply objection, improper rebuttal, and won't take long for a ruling. It is rebuttal. That's what it's for. Of course, at the very end, there's a little latitude to briefly tie it all up, but it is rebuttal and solely rebuttal. Okay, let's return to jury. Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? The state recognized presence of the jury.
Yes, sir.
Does the defense?
Yes, sir. We did.
Yeah, buddy.
Rebuttal?
Last day.
Good morning and happy 4th of July.
Oh my God.
Ms. Drainberg and I are going to
Nuh-uh.
both speak to you at this rebuttal portion of our argument. We're going to discuss different topics. I want to begin by discussing the science in the case. Defense counsel issued a very appropriate and aggressive attack upon the science, but I want to take a more measured and complex approach. Science can't be understood by simplistic concepts or easy phrases. The best way to understand the science in this case is to look at it and first look at what the scientists agree on and then what they don't agree on. And basically, the way it works is it's up to you to decide with an expert, as with any other witness, what part of his testimony you believe or don't believe. And in a dispute between experts, it's up to you to decide which one you believe. And you may reject both. You may find one more credible than the other because of experience or because of just that what they said makes sense. So it's totally up to you to decide what you believe from what the experts have told you. But I think it might be helpful to start out kind of isolating these areas sort of by subject matter.
Is
The
it
first one I'd like to start talking about is
Ouch,
the
stop
experts you heard on the
biting
subjects of forensic anthropology and forensic
Stop it.
pathology. Those are sort of related fields. Those are the medical examiners and the forensic pathologists, the people that look at the remains themselves and what they told you. You essentially heard in this case from Dr. Jan Garavaglia, who is the chief medical examiner of the District 9 Medical Examiner's Office here in Orange and Osceola County. Dr. Utz, Dr. Utz was the gentleman who first took custody of the remains, who removed the duct tape and talked about that. You heard from Dr. Schultz, who is the forensic anthropologist, who works out here at the University of Central Florida and is a contract consultant for the medical examiner's office here. You heard from Dr. Michael Warren, who is the director of the Pound Human Identification Laboratory at the University of Florida. And you also heard from Dr. Werner Spitz, who was the defense's expert called on that subject. Now, what do all of them agree on? Well, all of them agree that, number one, there is nothing in the bones that tells us anything. They all agree. There is no traumatic injury to the bones. There's no breaks. There's no fractures. There's no injuries. There's no nothing. Just looking at the bones, they all agree that there's nothing to tell us how Caylee Anthony died. Everyone agrees to that. The other thing they all agree about that is significant in this case is that because of the way the human body decomposes, there are two parts of the head that should not be together. That is the mandible and the skull. Dr. Spitz even said, remember he talked about when you picked up the skull, the mandible would stay on the ground. They're not connected. Once they decompose, there's nothing to keep them together. And what they all also agree about in this case is that when Caylee Anthony's body was found, the skull and the mandible were still in what they refer to as anatomical position. In other words, it was in the same position it would have been had the flesh and tendon been holding it.
Let me turn this on.
Where they disagree is on why that was the case. Dr. Utz, Dr. Garavaglia, Dr. Schultz, and Dr. Warren all told you that the only thing that could have kept that mandible in anatomical position is the tape. Remember, Dr. Warren told you, and he's, I would submit to you based on what you've heard, the most experienced of the four in forensic anthropology in skulls. He's told you that the only other time he has ever seen a skeletonized, fully skeletonized body with the mandible and the skull in anatomical position is in Sarajevo, in the skull of a person that was duct taped. So they have told you that in their opinion, which again, you may accept or you may reject, that that tape had to have been on that skull before she decomposed. Dr. Spitz presented you with an alternative. And I discussed that alternative with him at length. His alternative was that someone had come along at some later point for some unknown reason and reached down and picked up the skull off the ground, then picked up the mandible, took them someplace, put them back together, and duct taped them to hold them in place, and then returned them to the scene. You heard the cross-examination of Dr. Spitz about that scenario, and it is up to you to judge whether that scenario is reasonable or makes any sense at all. When I pointed out to Dr. Spitz that his scenario of the skull being returned was inconsistent with first of all, the deterioration of the duct tape, and second of all, most importantly, remember I asked him about, well, the person would not just have to put the skull back, they would have had to have draped pieces of hair over the skull. And remember what his response to that was? His response to that was to accuse the medical examiner personnel of doing it. And then when I showed him the photograph of the skull at the scene, undisturbed, with the hair in exactly the same place, he accused the sheriff's personnel of doing that. It is up to you to decide which of those two expert opinions you find more credible. And I submit to you, based on the evidence that you heard, that Dr. Spitz's version of events is incredible and non-credible. And I'll get to later in my remarks that it actually is also inconsistent with the very theory that the defense has been presenting to you in the other parts of their argument. We'll get to that in a little bit later. The other area that they disagreed on was the appropriateness and necessity of sawing open Kaylee's skull. Dr. Spitz told you that in direct that it was a violation of protocol for Dr. Garavaglia not to have sawed open Kaylee's skull, and that it was, in his word, sloppy.
I think it was sloppy. I don't think
on
it was
cross-examination, however, when challenged,
a rule,
even with his own book to demonstrate where that protocol was set down, he was unable to do so. When asked if there was any
so I was asked why I'm speeding through the prosecution's rebuttal. I made sure that, to make a long story short, we started at 1.25 speed, and then with the defense, I did 1.5. And now that it's 6:30 p.m. Eastern, and I've already been streaming for 3 hours, I would like to finish this trial tonight. So the best way to do that, in my opinion, especially during a rebuttal, is to increase the speed. So it's not a matter of me not being fair, because I just did it for the other guy, but that's how the cookie crumbles.
Protocol he was aware of dealing with skeletal remains that required such an act. He admitted there wasn't. In response to that, we called Dr. Michael Warren back again, the director of the Human Identification Laboratory, to tell you that, in fact, it is not protocol. In fact, it is contraindicated to open a skull unnecessarily. Because there may be times when there may be some particular artifact that cannot be otherwise appreciated. But generally, no, skulls are not open. It is not sloppy to fail to do so. In fact, it is dangerous to open the skull, particularly a child, because when you do that, the skull breaks, as Dr. Spitz did. Remember, I asked Dr. Spitz, you broke the skull, didn't you? And he was like, I don't remember that. And I showed him the photograph where the skull is fractured, and he didn't seem to remember.
I have plenty.
And I would submit to you that,
You're
based
not
upon
wrong.
what you have heard in this case, that Dr. Spitz's claim that the autopsy was done improperly is not credible. The other issue that they disagree on is this issue of the supposed, and this was sort of my shorthand term, but brain dust or brain residue.
Mhm.
He referred to it as like dust in the skull. He says that there was this residue in the skull that he could tell by looking at it was remnants of the decomposition of Kaylee's brain. And because of the position that he could tell that that the skull was on its side.
Sorry, I believe
He acknowledged that he took a sample of it,
This
that he
man-
doesn't know if it's ever been tested or not. So
Dr.
we brought in Dr. Bruce Goldberger
it's
from the University of Florida, who washed the inside of the skull,
10 out of 10
tested it,
times.
and told you that there is no decomposition product inside that skull. So he did the test that Dr. Spitz said he couldn't do because he didn't have a laboratory. And we now know that it's not what Dr. Spitz thought it was. So Dr. Spitz's whole theory of that proving that the skull was on its side has now been disproven. You'll also recall in cross-examination, I pointed out to Dr. Spitz that the arrangement of the hair mass was not consistent with his theory of how the skull decomposed. That, in fact, remember we talked about how if the skull is on its side, the hair mass is going to fall to the side. It's not going to fall evenly.
Guys, I feel like he just talks faster and it's really difficult for me, which it kills me to have to do this, but
Blah, blah, blah. And you can look at those photographs. You'll have them all back in the jury room. You can look at them and you'll see. I also asked Dr. Spitz an interesting question that counsel somewhat criticized me for asking. He acknowledged that in determining the manner of death, it is absolutely essential for a forensic pathologist to know about the events leading up to the death or disappearance of the victim. It's common sense. He said, yes, you have to know that. You have to know as much as you can about that. So I asked Dr. Spitz, well, what did you know? What information were you given? What research did you do? He said, well, I went to the house. Well, what do you remember from the house? Just that there was a pool. That's all he remembered. Well, what did you know about the events, leading up to her disappearance, et cetera? Well, there was something about a nanny. That's all he knew. I would submit to you that his fund of information about this case is not sufficient to make his opinion credible in this case. That in fact, the evidence in this case shows that the medical legal investigation of this case was thorough and complete, and that the testimony of Dr. GRWM and Dr. Utz and Dr. Schultz and Dr. Warren is credible and is worthy of your belief. Now, let's talk next about the entomological evidence. It wasn't a big feature of the case. It wasn't huge, but counsel referred to it, so let's talk about it. You heard from two entomologists. One was Dr. Neil Haskell, been practicing in this field, has been a leader in this field for, I think he said, 30 years, practicing in forensic entomology.
come here.
He told you two opinions, essentially. One about the car and one about the scene. You heard from Dr. Timothy Huntington, who has been practicing in his field since he received his PhD in 2008. A very bright young man, and I don't mean to denigrate his education or his sincerity. But the fact of the matter is you have to decide who you find more believable. Someone who has been practicing the field for 25 or 30 years, or someone who's been practicing the field for 3. But again, there are things they agree on. They agree on this very important fact, that the evidence at the scene where Kaylee's body was found indicates that the body initially decomposed in some other location from which the early colonizing flies were restricted. That's what Dr. Haskell told you. Dr. Huntington said he agreed that wherever Kaylee's body was for the first few days of decomposition, those early flies could not get to her. And then she was taken and dumped there in that field, in the woods, in that swampy area that you heard described by so many people. They both agree that that occurred sometime in June or July 2008, based on the entomological evidence. In that they agree. So what Dr. Haskell said about the scene, Dr. Huntington agrees with. Where they diverge is in the single issue of whether the trunk would have excluded the early colonizing flies. That's the only place that they disagree. Dr. Haskell, with his 25 years of experience in the field, has told you that in his opinion, the trunk is a source that could have excluded the early colonizing flies. Dr. Huntington, who candidly admits that he has never in his career dealt with a dead body in a trunk in a real world situation. But based upon some experiments, applying conditions completely different than in this case. Remember, that's the pigs in the blanket comment that we make. That based upon that experiment, and that experiment alone, he renders the opinion that the trunk would not have excluded the early colonizers. Again, it is up to you to decide which expert is more credible or which you believe, or to believe neither. It is completely up to you. But the important thing is on what they agree. That body decomposed someplace else, that it was somehow, either by being wrapped or being stored, was in a situation where the early flies could not get to it. and that from June or July through December, it sat there in the woods. On that, they agree. All right, let's go to the area next of the chloroform. Mr. Baez had a nice big poster about that, had all the experts or people that talked about chloroform. What is important to understand in evaluating the various people who testified about chloroform is to understand, first, what they were testing, and second, what their perspective was. Now, remember, Mr. Baez made a good deal of comment on the adjectives used by Dr. Voss and Dr. Weiss versus the adjectives used by Dr. Rickenbach. But one thing you have to understand in assessing those adjectives is their perspective. Dr. Voss and Dr. Weiss are used to looking at environmental air samples. Remember, Dr. Weiss told you that he's looked at environmental air samples from all kinds of different, fuel, car exhausts, environmental conditions, industrial, all different areas. And he's told you that based upon that experience, that he felt that the amount of chloroform he was seeing in the sample from the trunk was high, was surprising because of what his experience is. Dr. Voss's experience is similar. What he's looking at is samples from dead bodies, and he's seen many of them. He told you that based upon what he has seen in decomposing bodies, and he has occasionally seen chloroform in those cases in very small amounts, but compared to that, what he saw was shockingly high. But taking away the adjectives, the important thing is more to say, what did they actually find? Dr. Weiss and Dr. Voss told you that the chloroform they found in the trunk air sample in the can was somewhere in the low parts per million range. And Dr. Weiss gave you an excellent explanation of the idea of quantification. He said quantification would not have meant anything in this case because even if you quantify the amount of chloroform in the being given off by the carpet, it doesn't mean anything in terms of the amount of chloroform that was there a month before, because chloroform is volatile. It evaporates. So it wouldn't mean anything. But he does say, and Dr. Voss says, that based upon the qualitative analysis and the comparison between the amount of chloroform and the limit of his machine and the controls, that it was somewhere in the low parts per million range.
Man.
Dr. Rickenbach from the...
Guys, really quick, look at this. I don't want to show you the whole screen, but look at that. In the last 48 hours, 87,000 views just in the last 48 hours. Isn't that crazy? Okay, that's all for now.
FBI tested a similar sample out of a can, but also tested the actual spare tire cover in this box. Now remember, he received it in this box, not sealed, not in a can, not in plastic, in air permeable cardboard.
Hell yeah.
And what was interesting that Dr. Rickenbach told you is that he actually found chloroform, the technical chloroform, even in that. Remember, he told you he was surprised. He couldn't believe he found it because chloroform is a volatile and this is not sealed. So he said the fact that he found anything on that was pretty amazing. But remember, what he told you was that he found a much greater amount of chloroform in the sealed can. Remember, I think I had him put some numbers on a board, and it was in terms of percentages of the control. The control was 100 parts per million. In this item, I think he's put it at 0.08% of the control. In the can, it was 5% of the control. And again, he has said, and we will tell you, that is not a quantification. It is not a precise quantification. It's not intended to be a precise quantification. But what's interesting about it is the rough estimate puts it in the low parts per million. The same thing that Dr. Voss found. Now, to Dr. Rickenbach, who is used to looking at chloroform in its liquid form, that wasn't a lot. But he told you, this is the first time I've ever found chloroform in any kind of solid object. Every time I've looked for chloroform, it's been in the liquid form, in adulterated liquids of some sort. Okay, it's being investigated. But even he said that he found detectable amounts of chloroform coming from the carpet in Casey Anthony's car. Nothing he'd ever seen before. And that's the significant thing about these witnesses. is they all told you the same thing. This is the first time we've seen this. Actual detectable amounts of chloroform coming from a carpet. And remember what they told you. Dr. Rickenbach agreed. The amount of chloroform in these items is far less than the amount of chloroform that would have been in that trunk a month before, because chloroform is volatile. It evaporates. It fills a space until fresh air comes in. Remember, this car was aired out by the Anthony family for hours on the 15th going into the 16th. So the chloroform that would have been there before it was opened up, when it was at the tow yard, was far greater than anything these people found. And ladies and gentlemen, I would submit to you that there has been absolutely no evidence to explain where it came from or why. Dr. Sigmund, who was the gentleman from UCF that did his initial testing of the sample, he told you that he tested the trunk 4 days after that item was removed. 4 days, it had been gone for 4 days. And yet even 4 days later, he was able to detect, even with his equipment, which he said is not as good as what Dr. Voss used. It's not as, it doesn't capture as much. Even he was able to find detectable amounts of chloroform in the trunk of that car, which shouldn't have been there. There shouldn't have been any chloroform in the trunk of that car, but it was there.
Let me look, Maddie.
The Dr. Sigmund also told you something that was very interesting. He told you that while chloroform can be created by incidental contact between chlorine bleach and organic materials, that doesn't happen in a vacuum. That when that does happen, other compounds are created. And those compounds have not been found in this case. All that's been found is chloroform. No chlorine. Remember, I asked Dr. Furton, there's no bleach stains on that spare tire cover, are there? No, there's not. There's no, the issue was brought out that some cleaning products have small amounts of chloroform in them. And I asked Dr. Furton, were any of the other constituent components of cleaning products found? No, they weren't.
Only 6 votes, so.
All that was found in the examination of
Over on
that
that
carpet
stream.
and that spare tire cover were the components of decomposition and chloroform. In that, all the experts agree, including those called by the defense. Let's talk about now another subject as far as the air examination, which is the odor of decomposition.
I mean, it's still not a widely grasped science.
The defense's primary attack upon Dr. Voss is that he has developed a device which is designed for use by law enforcement and the military. And that if by some miracle that device were to be purchased by someone in the private sector, why they would want to, I can only guess, that Dr. Voss would split with the other inventors 15% of whatever minimal royalty that Oak Ridge National Laboratory might get. That's the impeachment. That's the criticism. You saw Dr. Voss testify in this case, and you have to judge his credibility. I submit to you that Dr. Voss is an unapologetic geek. He loves what he does. I mean, when have you ever seen a scientist on the stand in a criminal case say, and this is the cool part, Dr. Voss is an unapologetic science geek. He loves the challenge of solving scientific questions. Whether it be, how do you detect a body by the odor of decomposition, or whether it's maybe divining actually does work. You know, counsel sneered at him because he has the scientific curiosity to wonder if something as bizarre as that might actually have a scientific basis. Maybe he's right, or maybe he's wrong. But to say that you should disbelieve him because he has that scientific curiosity, I would submit, is inappropriate. You know, judge him by what he said. Judge him by who he is and what his experience is, and judge him fairly. But getting back to that point, when you actually boil down what Dr. Voss said and what Dr. Furton said, they really don't disagree that much. They both agree that the science of human decomposition odor has not developed to the level that there is a signature set of compounds that show human decom. They both agree with that. They both agree that the chemical signature from this car is consistent with a decompositional event. Dr. Furton said, yes, I believe that those chemicals are from a decompositional event. So does
Kate,
Dr. Voss.
nobody wants
Dr.
to
Furton
argue.
agrees that it's possibly human.
We're copacetic here.
That's what Dr. Voss says.
Everyone.
They don't really disagree that much
ideas.
on much of anything other than the final conclusion.
It's very
Because Dr.
chill.
Voss told you that when you combine the science with his experience and what he
You
smelled
don't
in
need
that
those
can,
vibes.
the odor that he has smelled for 30 years, I asked him, do you have an opinion based upon all of that as to whether that odor was from human decomposition? And his answer was, I can find no plausible other explanation. And I would submit to you that Dr. Furton's other explanation is not plausible. You know, counsel in direct wanted to just have Dr. Voss talk about the garbage from a photograph without talking about what was actually there. But I wanted Dr. Furton to actually look at the garbage.
Usually when I address people like that,
Because I wanted you to
everything's
see
cool and copacetic.
what was actually there. In his closing remarks, counsel made a claim that I would submit to you is completely unsupported by the evidence. He told you that these officers removed something from the garbage. That is absolutely unsupportable in the evidence in this case. There's no evidence of that. In fact, the evidence is completely to the contrary. The officers testified they removed nothing from that garbage bag, that there was no food there then, there is no food there now, and all the imagination in the world is not going to create it. The only thing in that bag of an organic nature, similar to food, was a small bit of remnant of cheese that I passed around for you to look at. And Dr. Furton admitted that
You won't be attacked.
cheese in that bag
We don't do
could
that.
never create an odor that would still be detectable by Tim Huntington, the defense own expert, 2 years later. The myth of the garbage has been disproven. That smell was not from garbage. It was from Kaylee.
That's it.
The defense presented, well, let's talk about DNA for a minute. The defense presented DNA non-evidence. The defense called a DNA expert from the FBI to testify that she tested for DNA on various items and there was none. And she told you that she didn't expect to find any. That DNA decomposes just like every other part of the body does. And that she had no expectation of finding DNA on the tape that had been out there on the body for 6 months. The defense called, Dr. Eichenblum, who really just testified. And remember, he is the witness who provided us with a report 2 days before he testified. The judge instructed you on that and that you could determine that in judging his credibility. But all Dr. Eichenblum really said was, well, I think I might have been able to find something. I mean, that was the essence of his testimony. I think I might have been able to find something, but I might not.
The biting cat.
That's it. That's essentially what he said. But even he admitted that the two things that were absolutely the most destructive to DNA are moisture and heat. And that it was highly unlikely that any DNA could be found on the duct tape. I mean, think about it. If there's no DNA on the face to which the duct tape was attached, how can there be DNA on the duct tape? And they admitted that. That was non-evidence. It didn't mean anything. The defense called 10 other witnesses to basically talk about non-evidence that the witnesses themselves admitted was meaningless. It doesn't mean anything. The fact that there's not dirt on a shoe doesn't mean the shoe wasn't in the place. We could go on and on with that. It just doesn't mean anything. The last area of forensic evidence was the hair examination. The hair examination, you heard from Karen Lowe and Stephen Shaw. Stephen Shaw was recalled by the defense, and we went through that PowerPoint with you about his research. Those witnesses are not going to come up here and tell you more than the science will absolutely support. What they told you was that there is this artifact that has only been seen in hairs taken from decomposing bodies, that despite all of their efforts to recreate it from living human beings, they have been unable to do so. Since they don't know exactly what causes it, they're not going to tell you that it couldn't happen any other way, but just no other way they can think of. And that testimony, ladies and gentlemen, has not been refuted in this case. To say that there is no evidence to connect Casey Anthony to Kaylee's death ignores all of this evidence. I want to go to the next issue I want to discuss with you is the issue of reasonable doubt. It is up to you to decide whether a doubt which has been proposed by counsel are reasonable doubts or whether they are speculative, imaginary, fanciful, and absurd doubts. So I'm going to go through some of the reasonable doubts proposed by counsel and subject them to a little bit of examination. The first area I want to discuss with you is the duct tape. Counsel went to great lengths to connect, as we already had, the duct tape in this case to the Anthony home. On that, we agree. That duct tape on Kaylee Anthony's face came from the Anthony home.
Maybe do your thing.
But here's, so the argument then goes, well, George Anthony, having somehow discovered this drowning, which we'll talk to a few minutes ago, there's no evidence actually happened, for some reason decides to dispose of the evidence of this completely innocent accident. And for some reason that no one can even propose, decides to put duct tape on Kaylee's face. Now, getting past the fact that there's just no conceivable reason why anybody would put duct tape on the face of a dead child. I said it before, people don't make accidents look like murder. That's absurd. And nothing has been presented to you to make that any less absurd.
Sustained.
Moves to strike, Your Honor.
Motion to strike granted.
You have heard nothing in the evidence in this case to make that proposition any less absurd. Now,
Overruled.
but let us propose that we ignore all of that absurdity and say that George Anthony has.
Paragraph 6 of Your Honor's order.
Do they need to kiss and make up again?
Overruled at this point.
And let's suppose that George Anthony has, in fact, placed Kaylee's remains in the wooded area on June 16th of 2008 and placed duct tape over her mouth. The defense then asserts that on the 24th, for some reason, he deliberately notifies law enforcement about this gas can with the duct tape on it, implying that in some way he is attempting to implicate his daughter in something for reasons which are completely inexplicable and not mentioned anywhere in the evidence. But he creates this issue about this duct tape by reporting that it's stolen. He gets the can back. No photographs are taken of it by law enforcement back in June when it happens. It's just reported. There's no way of knowing from that report whether duct tape was on it or not. It's just not mentioned. But somehow the defense wants you to believe that that was part of the plan. That was part of his insidious plan to somehow implicate his daughter in something for some reason. They then tell you that when Kaylee does turn up missing and the police are there searching, that George doesn't tell them about the gas can incident. If George is concocting a nefarious plan to implicate his daughter in this accident, then why doesn't he tell the police that first day? And counsel made great point of the fact that he didn't. But if counsel is correct, then he would have. He would have done it. Of course, why he would give the police a piece of evidence implicating himself as much as anybody else, again, sort of begs the issue. But anyway, so we go on. So the police take the item, which at the time they have no idea has anything to do with anything.
God, could you
Photograph it and
imagine
then give it
getting
back to him.
divorced to this guy? Oh.
So at this point, George Anthony takes the can back and sticks it in the garage for 4 months and doesn't do anything with it. Doesn't try to connect it to the police. He just lets it sit there. And then in December, when the body is found, the police find the can with the duct tape in the garage. George doesn't point it out to them. They find it because remember, George isn't even there. They find it and they take it into evidence. So what does this nefarious criminal then do? He takes the very same roll of duct tape, which connects him to this death, and he uses it to display posters. Does any of this make sense? None of this makes sense.
Well, nothing.
To assert that George Anthony's use of the tape on the posters for his missing granddaughter is patently absurd. It doesn't make any sense.
Paragraph 6, move to strike.
The reason that it doesn't make sense is because it's not. I submit based on the evidence true.
I feel like
George Anthony had absolutely no idea that roll of painted duct tape had anything to do with the death of his daughter, of his granddaughter. He
coming in here and being like overly aggressive in a situation that absolutely doesn't need it. You are not being attacked. No one is questioning your intelligence. We all have the ability to say and think what we feel, but we are polite and we are non-combative about it. So I love that you are a part of this chat, but maybe if that's your approach, maybe this isn't the chat for you. If it is, then I'm happy to have you. But I don't like bad vibes in something that I've worked my ass to build up. So I hope that you can respect that. Thank you.
He had no idea because he wasn't involved, just as he told you. You know, counsel showed you the big poster with the pictures of Kaylee walking into the pool and said that this hypothesis has not been rebutted. Well, I respectfully disagree. Because, ladies and gentlemen, the two people that counsel asserts were present when that happened were George Anthony and Casey Anthony. And George Anthony testified on that witness stand the first day of this trial. It didn't happen. And as Ms. Burdick will point out to you when she speaks to you in a few moments, Ms. Anthony also was given the opportunity to adopt that and rejected it twice. That has been refuted by the evidence in this case. Counsel also asserted to you that this crime scene was quote unquote staged. And here's the interesting part. He tells you on the one hand that George Anthony is connected to the tape. Remember, he said in opening, follow the tape. But then on the other hand, he tells you that Roy Kronk is connected to the tape. Remember, Dr. Spitz told you that somebody came along later and took the skull and taped it. And in opening statement, the defense counsel told you that person was Roy Kronk. So they both got the tape, this rare kind of duct tape. Roy Kronk, who has no connection to the Anthony family other than reading their meter once, who's never been in their house, who's never been in their garage, who have no way of knowing what kind of duct tape they have. So which is it? Who put the duct tape there? Counsel has argued to you that the crime scene was staged.
Thank you.
Could I have State's Exhibit 82 published to the jury, please? You'll recall this is a photograph of the scene out there on Suburban Drive as it was found on December the 11th of 2008, before anything was disturbed. This is in its pristine form. And I would submit to you that looking at this scene, it is clear that the only thing that has staged this scene is Mother Nature herself. This scene is covered in leaf litter. There is a 2 to 3 inch pile of leaf litter surrounding the skull, as testified to. There are vines literally growing over everything in this scene. There are vines, you'll see in photographs, growing through everything in this scene. This scene is staged by Mother Nature and no one else. This skull has not been moved for 6 months. Pardon me, maybe a little bit less because the animals might have moved it before it decomposed. Mr. Defense counsel told you in opening statement that Roy Kronk took the remains home and kept them. We presented the testimony of Dr. John Schultz, the forensic anthropologist who was in charge of the collection of the remains. And we went to great length with him to show you where the remains were found and in what groupings. The reason that was important was because the grouping of the various bones demonstrates how the body was disarticulated during decomposition. Remember, he talked about how there were certain areas where the ribs were found because the trunk would have been removed as a connected group of organs as it decomposed, that the vertebrae were found separately because that would decompose separately. The bones showed evidence of
It makes me so happy. I'm so glad. Congratulations to everyone that got a number.
the bones showed evidence of animal activity, that they'd been chewed on. We didn't tell you that just to offend you or to make you mad. We told you that because it is essential for you to understand that these bones were not scattered by Roy Kronk. They were scattered by animals and by acts of nature. Could I have 207, please, in evidence?
Oh my God. Really, Frank, right now? Thank you.
Again, you can see from this photograph a little bit closer up of where the skull is. This skull has not been moved for months. It is surrounded by the hair, which has fallen directly from the top of the head. You can see it all around, pretty much evenly distributed around the skull. This is where the skull has sat since the hair and the scalp decomposed and fell off. And it hasn't moved since, at least not much. Could I have...
I watched this one too, and it still makes me mad. The girl in Kentucky, she did not commit the murder, and her fingertips are on that duct tape. I don't care what anyone says.
The duct tape is partially covered by leaf litter along the sides.
She was convicted.
Remember, when you see the next photograph, you'll see this. The duct tape actually goes around the jaw and the skull.
I have very strong feelings.
This has been here so long that the leaf litter has actually covered parts of the duct tape.
Rebuttal, Your Honor.
Overruled.
Could I have 218, please? In this photograph, you can clearly see that the duct tape wraps around the mandible. It didn't just get washed there by water.
All right, I'm going to
It's there because that's where Casey Anthony put it. It's there. The jaw is in place because the tape is there. Could I have 220? You can see in this photograph where the tape has now been lifted away from the skull, from the mandible, excuse me, that there are strings from the tape that actually go under the mandible. It's not a coincidence. It's not an accident. It's not water. That's because the tape was placed over her mouth and her nose before she decomposed. You can take it off now. The scene was not staged. It appears as it does because of the forces of nature, the forces of water, forces of animal, and the forces of decomposition. And any suggestion to the contrary, I would submit to you, is conclusively refuted by the evidence in these photographs. All these photographs you will have in the jury room with you. They're in a notebook. They're separated by sort of subject matter, so you can go right to them, look at them, take as much time as you like to look at them. And when you've done that, you're going to see that this crime scene was not staged. It was not moved. That duct tape has been on Kaylee's face since the day that she died. Just as the state's experts told you. The state did not call Roy Kronk in this case because Roy Kronk testimony about what he did on December the 11th, 2008 is embellished. Roy likes to spin a good yarn. But what Roy said he did on December the 11th isn't possible. We didn't put Roy Kronk on to tell you a story that the evidence indicates just isn't true.
I mean,
And I would also submit to you that Roy's claim that he just happened upon that scene for the second time is equally uncredible. That doesn't mean that he staged the scene, that he stole it, all that stuff. What it means is that Roy likes to spin a good yarn. I submit to you, based on the evidence, what occurred in this case is that Roy found the skull, as we know he did, back in August. He tried to report it 3 times, and he got blown off and said, to heck with it. I'm over this. Maybe it really wasn't. But then he starts communicating with his son. He starts telling his son, hey, I know where the skull is. And his son is impressed. He's trying to get this relationship back with his son. And he thinks, wow, wouldn't it be great to impress my son?
That's a
So he
good way
goes
to
back
put
the
that.
scene, and it's still there.
Lawyers be
And Roy becomes a hero.
lawyering.
And Roy tells a very, very dramatic story about lifting up a bag and the skull rolling out, and it's dramatic and it's wonderful and it's fun, but it isn't true. Roy found the skull all right, absolutely, but not the way he said. It's just impossible. But that doesn't make Roy Kronk a morally bankrupt individual who would take a little girl's skull home and play with it. The judge is going to give you some legal instructions, and I want to talk about a few of them, the most important ones. The judge is going to instruct you on the main charge here, which is murder in the first degree. There are 2 ways to commit murder in the first degree. One is called premeditated murder, and the other is called felony murder. Now, we get up here and we argue to you what scenario we believe the evidence supports. And in this case, we've told you that we believe the evidence in this case supports the scenario that Casey Anthony chloroformed Kaylee so that she would not suffer, placed duct tape over her nose and mouth to end her life, and then disposed of her body. But you can come up with whatever scenario you want. I mean, it's up to you to put these facts together and decide in your own mind what you think happened. And that's important in this circumstance. There are 2 ways to commit murder in the first degree. The important thing is for you to know the following. During your deliberations, in order to find the defendant guilty of murder in the first degree, the state must convince you beyond a reasonable doubt of the defendant's guilt of either premeditated murder or felony murder.
Your Honor, I will object to this statement of the law.
I'm reading directly from the jury instruction.
Overruled.
Either premeditated murder or felony murder.
Kitty.
While you must all agree that the state has proven first-degree murder beyond a reasonable doubt, you need not be unanimous in your opinion as to whether that finding is based on premeditated murder or felony murder. In other words, what that means is that as you each individually assess these facts, you don't have to necessarily agree whether it's premeditation or felony murder. You can think it's both. Some can think it's one, some can think it's another. The important thing is that you all agree that it is first-degree murder in some form. Premeditated first-degree murder is a fairly simple concept. It just indicates the 3 elements are that Kaylee is dead, the death was caused by the criminal act of Casey Marie Anthony, and that there was a premeditated killing of Kaylee Marie Anthony. Killing is defined as killing is a killing after consciously deciding to do so, and there is a more full description the judge will give you. Our position is that the facts in this case show beyond a reasonable doubt that this was a premeditated murder of a young child. But we know that you can reconstruct these events in any way you want. So you also need to know what felony murder is. Felony murder has 3 elements. The first is the same, that is that Kaylee is dead. The second is the death occurred as a consequence of and while Casey Marie Anthony was engaged in the commission of aggravated child abuse, or she died while Casey was attempting to commit aggravated child abuse, and that Casey is the person who killed Kaylee. Now, aggravated child abuse is defined by 2 elements. The first is that the defendant knowingly or willfully committed an act of child abuse upon Kaylee, and in so doing caused great bodily harm, permanent disfigurement, permanent disability, or permanent disfigurement, and that Kaylee was under 18, which there's no question that she was. Child abuse is defined as the intentional infliction of physical or mental injury upon a child, or an intentional act that could reasonably be expected to result in physical or mental injury to a child, or active encouragement of another person to do that. The reason that we talk about this is you can postulate a number of different
Under Brooks.
Overruled.
a number of different hypotheses in this case. Some might say, well, maybe Casey put the duct tape on Kaylee to keep her quiet. Maybe she was being loud. Maybe she put it on to keep her quiet and put it on too tight, and Kaylee died by accident.
still.
I would submit not really consistent with what we have here, but someone could think that. The reason I bring this out is because if that is what you think happened, that is felony murder, as the court will define it for you. That's felony murder, because it is the intentional act that could reasonably be expected to result in physical or mental injury to the child. So if that's something that you're thinking about, just want you to know that's also first-degree murder.
Of the law, Your Honor.
Overruled.
Or if you choose to believe that she used the chloroform to sedate Kaylee so that she could spend time with her boyfriend, as bizarre as that seems, but let's say that she used the chloroform in the trunk of the car to sedate Kaylee so she could go have a good time with Tony on the 16th, and that Kaylee accidentally died. It's still first-degree murder, because that act is aggravated child abuse, and if she dies as a consequence and a result, it's first-degree murder. So regardless of how you put these facts together, and again, I submit to you that the one that makes the most sense is that this is premeditated, because it is. But any way you slice it, any way you put it together,
It is.
Casey Anthony is guilty of murder in the first degree in this case. I want to talk a little bit about George.
Oh, George. It's my ex-boyfriend's name. His name is George.
You have seen hours of videotapes of conversations between George Anthony, sometimes with Cindy and Casey, and sometimes just with Casey. Those give you a window into this relationship between them. An unguarded, unvarnished window into the relationship between these three people. Is there anything in any of those conversations that shows George Anthony as anything other than a loving father
Come back up
and a
if
loving
you're not
grandfather
invite me.
who is out of his mind with worry over Kaylee and perplexed as to why his daughter won't tell them something? Throughout all of these conversations, he is supportive. He is helpful to Casey. He's loving to her. She even says to him on more than one occasion, when he expresses some guilt about not having been a better father, she says to him over and over again, "You were the best dad. You were a great dad. You were a great grandfather."
Yep. True.
There's nothing in any of those tapes that would suggest in any way that he's setting her up in some bizarre fashion. Most of her more frictional relationship is with her mother.
Oh God, yeah.
Most of the arguments, to the extent that they occur, are with her mother, not with her father. You know, remember the thumb? George is the thumb. We're the five fingers and George is the thumb. It's almost a little silly in a way, but George is not this Machiavellian, self-interested monster that counsel has suggested. The last time George Anthony testified, Mr. Baez brought up the suicide. You recall
Mr.
that
Baez
he asked Mr. Anthony, didn't you attempt to commit suicide? Mr. Anthony said that he did. Mr. Baez asked him, well, didn't you express some guilt in the suicide letter? That's, of course, before you actually would have had a chance to see it. Now, of course, Mr. Baez seems to be telling you that it wasn't really a suicide attempt. It was just a couple of beers and some blood pressure medication. That's not what George Anthony said. George Anthony said he took blood pressure medication and medication he was given for anxiety by a psychiatrist. He took everything he could find because on January 22nd of 2009, he wanted to die. He wanted to be with Kaylee. That's all he wanted. He was tired of all of it. He was tired of the questions. He was tired of not knowing. He just wanted to be with his granddaughter. And you cannot read this letter and not see that this man was in pain.
Oh, that's what I was going to say earlier.
You can even
He has
see
great
the effects of the
penmanship.
drugs and alcohol as his handwriting deteriorates through this letter.
Why you got to
This
be an
is not-
asshole?
Some self-serving, deliberately created manifesto of innocence. This is the cry of a man who just doesn't understand the world anymore. He doesn't understand what happened to his granddaughter. He doesn't understand why his daughter won't tell him. He just doesn't understand, and he's just tired.
I said what I said, man. It was beautiful handwriting for a guy.
Kaylee Marie, I miss her. I miss her. I want my family back. I sit here falling apart because I should have done more. She was so close to home. Why was she there? Who placed her there? Why is she gone? Why? For months, you and I, especially you, always questioned why. I want this to go away for Casey. Happened. Why could she not come to us, especially you? Why not Lee? Who is involved with this stuff for Kaylee? Before that, he says, I blame myself for her being gone. You know, for months, as a matter of fact, for a year or so, I brought up stuff only to be told not to be negative. To denigrate that pain. by suggesting
Absolutely.
that is an insincere, selfish, self-serving statement, I believe belies the facts. I'm going to sit down now, and Ms. Drain-Burdick will address some other areas in the case. I just want to end by thanking you for all of your sacrifices and all of your time, and to wish you well in the decision that you're about to make. Thank you.
Okay, ladies and gentlemen, the jury will take a 15-minute one, special. Okay, we'll take a 20-minute special recess to the hour of 10 o'clock.
I don't see anything. Maybe
You may be seated.
Got rid of it before I could see it and go.
Let the
ham
record
on his
reflect that
ass.
the defendant is present along with counsel for the defendant, assistant state attorney. Both sides ready to proceed. Mr. Baez?
Yes, sir. I just have a brief issue that I need to get on the record.
Yes, sir.
It relates to the issue dealing with the computer searches. You may recall that there was an issue as to the number of times that the chloroform website was visited, the sci-spot/chemistry/chloroform. Mr. Bradley testified based on a report introduced by the state of Florida that was actually compiled by Sergeant Stenger. This was the second report that was compiled a year later using a new software program in which they were having problems with. And the net analysis that was conducted on August of 2008 showed the identical website visited only once, and that 2 columns below was 84 times for MySpace, which did not show up on the cashback report. It is our understanding that the cashback report contains false information, and we have placed the state on notice that the testimony that was elicited was false. And we would ask at this time that the state of Florida, during the rebuttal argument, clarify that false testimony and advise the jury of its falsehood.
Response from the state?
Mr. Baez has already made his closing argument to the jury, Your Honor.
That's wild, Willa.
Folks, I don't know what you're saying is whether it's true or whether it's false. The only thing I can say is if there's evidence of false testimony, then you need to file an appropriate motion at the appropriate time.
I'm
And,
sorry. I apologize, but
I will take a look at it and see whether or
I
not
need to hear that back.
it is proven to be.
This
You may be seated.
Sorry.
Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney.
Defendant.
Both sides ready to proceed. Mr. Baez?
Yes, sir. I just have a brief issue that I need to get on the record.
Yes, sir.
It relates to the issue dealing with the computer searches. You may recall that there was an issue as to the number of times that the chloroform website was visited, the sci-spot/chemistry/chloroform. Mr. Bradley testified based on a report introduced by the state of Florida that was actually compiled by Sergeant Stenger.
Okay,
This was the second report that was compiled a year later using a new software program in which they were having problems with. And the net analysis that was conducted on August of 2008 showed the identical website visited only once, and that 2 columns below was 84 times for MySpace, which did not show up on the cashback report. It is our understanding that the cashback report contains false information. And we have placed the state on notice that the testimony that was elicited was false. And we would ask at this time that the state of Florida, during the rebuttal argument, clarify that false testimony and advise the jury of its falsehood.
Response from the state?
Mr. Baez has already made his closing argument to the jury, Your Honor.
Okay.
Folks, I don't know what you're saying is whether it's true or whether it's false. The only thing I can say is if there's evidence of false testimony, then you need to file an appropriate motion at the appropriate time. And
Yeah, I'm not.
I will take a
seeing
look at it and see whether or not
things that you guys
it is proven to be false.
were talking about.
But at this stage, there
We're
is,
talking about.
I can't chase after arguments. So
Yes, sir.
file appropriate motions and we'll cross that bridge when we get to it. Anything else?
No, sir.
I did just see maybe
Okay,
immediately
let's return to
delete
jury.
something. She's like a fucking hawk, man. You don't mess with her. Bad Kitty's not far behind.
Okay, the state recognized president of jury. Defense,
Yes, sir, we do.
rebuttal.
Let's go. Let's get this over with. Guys, my streams never go this
Good morning,
long,
ladies and gentlemen.
except for when we are finishing up a trial.
When Judge Perry took that break for 15 or 20 minutes, I kind of felt like that guy that gets called out onto the field to kick a last-minute field goal once his
problem.
teammate has
Thanks for saying
taken the
sorry.
ball down to the 1-yard line. And of course, I'm ready to go, and the other team calls a timeout. So there are some advantages and disadvantages, I suppose, to being the last person to have a say on this subject. The advantage, of course, is the obvious one that nobody gets to say anything after I sit down except for the judge on the law. The disadvantage, of course, is that you've been sitting here listening to attorneys tell you what they think the evidence shows for 5, 6, maybe even 7 hours to this point.
That's
And I
dumb.
recognize that you all are ready to begin the job
I
that
can
you have been
confirm.
here doing for almost 2 months. On May 9th, we packed our bags and spent 2 weeks in Clearwater. You have made a greater sacrifice in packing your bags and spending weeks here. And as everyone else before me has indicated, I thank you as well. But I ask that you do indulge me for a few moments to get our final thoughts on the issues that have been presented in this case. I promise that I won't be dragging
Come
out
on,
evidence
girlfriend.
or posters or pyrotechnics. If anything, that's not my style. When I came up here in May
I know, I was just thinking about
and stood in
like,
front of you
sex on the
for
beach.
probably over a little over 2
Can you
hours
type that maybe.
and told you what the evidence in this case would show,
Some stupid
meant what I
fruit
said.
cocktail.
I didn't make promises to you that the state didn't keep.
Sounds good.
I meant what I said.
Why are you yelling, man?
And through the testimony of dozens of witnesses, hundreds of exhibits, the state of Florida in this case has proven every element of every charge in this indictment against Casey Marie Anthony. Mr. Baez, defense counsel, started his closing argument explaining what his biggest fear was in this case, and that it was that you would be making decisions based on emotion. I would never ask you to do that.
You missed
Co-counsel
the part of the stream where I
Has not
admitted.
asked you to do that.
Two
The judge
people
will
in
instruct you that you cannot do that. And although this case is certainly emotionally charged, we won't ask you to make decisions about the facts of this case based on anything but the testimony that you have heard from the witnesses and all of the exhibits that you will be able to consider once you begin the job of deliberating this case. Want to know what my biggest fear is?
My back breaking.
My biggest fear, and I do not, under any circumstances, mean this as an insult. My biggest fear is that common sense will be lost in all of the rhetoric of the case.
Did
That
she just insult them?
you won't step back and take a look at the evidence as a whole.
She's like, I'm going all in. Just gonna
You got to
piss
look
him
at the
off.
big picture here. Co-counsel, in his opening argument to you yesterday, talked about rabbit holes. And after he sat down,
Sustain.
my fear is that you won't look at the big picture. We spent 2 weeks in Clearwater
Oh,
questioning all of you, looking for people who would still be able to see the forest for the trees.
what the fuck?
Overrule at this point.
In his closing remarks, Mr. Baez
Coco, be nice.
used
to
words
Pearl.
like liar, perjurer, fraudulent. A trial in a criminal case is supposed to be a search for the truth.
I agree.
The truth is what is the cornerstone of the criminal justice process, both for those who are accused and those who are the victims of crime. It is lying that perverts that process. So during an argument where the most well-documented liar ever seen in a courtroom accuses everybody of perjury, of fraud, of lying, the irony is rich indeed.
Your Honor, violation of paragraph number 5 of this court's order and move to strike.
Overruled.
He really made Judge Perry mad.
As we have come to find out, accusing others of lying is classic Casey Anthony. When Casey Anthony wants to divert attention away from herself, she accuses others.
Overrule at this point.
As we have heard from the evidence,
I don't think so.
Ms. Anthony has spent years lying, has spent 31 days. Mr. Baez, in his argument to you, suggested those 31 days mean nothing.
Oops. Coco, don't bite me.
A lie told convincingly is still a lie. The defendant, through counsel, has accused Yuri Melich,
Overrule at this point.
Jason Forgy, Gerardo Bloise, Dr. Voss, many of the witnesses that have come forward in this case of being liars.
There we go.
In his statement, he indicated that the Orange County Sheriff's Office is desperate or was desperate
It's okay.
in this case. And if there was anything that the individuals working for the Orange County Sheriff were, it was desperate to find a little girl. In July of 2008, whether or not she was alive or dead, the men and women of the Orange County Sheriff's Office labored for hours in an effort to find her. They were joined by the FBI for law enforcement agencies all over the country, the Florida Department of Law Enforcement,
did a
Texas
job.
EquiSearch, citizens, people who had no other motive than to find Kaylee Marie Anthony. But it was a lie. It was all in vain. Even the defendant's parents and her brother were searching in vain. You know,
Hello,
false allegations
Scotland.
of child abduction are
I
nothing
know
new.
that wasn't a Scottish.
And invariably, as in this case, it turns out that the perpetrator is a family member. The allegation of a false abduction diverts resources away
Earl, he'll be back.
from the perpetrator,
I'll give you a piece of pizza.
diverts attention away from the perpetrator,
Your Honor, improper argument.
Overruled.
buys the perpetrator more time. And you will remember one of the things that
That's what
Casey
I'm
Anthony
saying,
said to her
Daniel.
mother when she picked her up from her boyfriend Tony's apartment was that she just wanted another day. She wanted more time. She was trying to buy time. When she told her brother about the kidnapping, she was trying to buy time. Time to concoct another lie, another story, and to divert attention away from herself.
Nice.
In his argument, counsel put up pictures of all of the law enforcement officers who were at the Anthony home that night, suggesting there was no smell in the car because they took no action. That first night, July 15th of 2008, the police did not think Kaylee Anthony was dead. At that point, they had no reason to believe Kaylee Anthony was dead. There was no reason to connect any smell in the car to
Have you met
Kaylee
that
Anthony
family?
being dead.
They're all crazy.
The defendant was telling them she was alive, that she was somewhere else. She was asking for their help in finding her. So much so that this episode that Mr. Mason talked about of Ms. Anthony being handcuffed was ended like that. Because the members of the Orange County Sheriff's Office were there to help. They weren't there threatening her to give a statement.
Let's take a moment and think about what she's saying. She's throwing, as a prosecutor, mind you, she is throwing the local police department under the bus. Think about that. That's pretty heavy. She's going to have to live with that for the rest of her career. I'm sure she has.
They were there to help. The next day at Universal Studios, there were 3 long-term detectives who were there to help. If you listen to Ms. Anthony's statement again, they say to her,
Yelling at me.
you have 3 detectives here who want to help you, who will expend the resources to find your daughter. Why are you lying to us? These aren't involuntary statements, as would be suggested that you should just throw out. These are statements suggestive of a consciousness of guilt on Ms. Anthony's part. She was buying time, like she had done with her parents, her brother, her friends. The 31 days are really meaningless. Did I hear that?
Doesn't matter.
Did I hear a version of that?
Her calling it out is ballsy.
Counsel suggested that the detailing of what Ms. Anthony was doing during these 31 days had more to do with the state trying to prove that she was a slut. Did I hear that?
Yes, ma'am.
Nothing could be further from the truth. Initially, the Orange County Sheriff's Office, in an effort to help her, was trying to backtrack and find out where she was and what she had been doing because she told them she was conducting her own investigation. Really? They were using her cell phone records to try to track down this Zenaida to find Kaylee Marie Anthony to help the defendant. But as they backtracked, as you found out, it had become and did become more and more apparent that the defendant was lying about everything. If you go back and look at her 4-page written statement, the only true statement on there is that Kaylee Marie Anthony was born on August 9th, 2005. That's it. Every other statement on that form is a lie.
Hi, pretty pearl.
You've heard during this trial, and it's been suggested to you in closing argument by the defense, that everybody grieves differently.
They do.
Well, that may certainly be true.
It is.
Everybody grieves differently.
I don't think they grieve like Casey, though.
Responses to grief are as varied as the day is long, but responses to guilt are oh so predictable.
Did that offend you, Pearl?
What do guilty people do? They lie. They avoid. They run. They mislead. Not just their family, but the police. They divert attention away from themselves and they act like nothing is wrong. That's why you heard about what happened those 31 days. Not to try to convince you to hate Casey Anthony, but to show you that what she was doing during those 31 days was in no way indicative of grief, was in no way the response to someone whose child has died by accident. Counsel said, well, she could have hopped on a plane and left the jurisdiction. The classic signs of running away. Ms. Anthony did not have options. In those jail videotapes, you did hear, and if you listen to them again, will hear her say, this was a time of desperation for her. And her father was like, what? Desperation? What are you talking about, desperation?
They were so dumb. I'm sorry.
She had no option to go anywhere except away from her family. That's who she ran from, because those are the people who would be asking her all the questions. The friends are easy to placate. They're not really paying attention to her life. If she's telling them, my mom's crazy, or my parents are getting a divorce, or my dad had a heart attack.
Sustained.
That was a good objection.
She was running from her family during those days. The people who would want to
I
know
agree with that.
more than just as a passing reference, where's Kaylee?
Objection. The court sustained my objection, and counsel's continuing on that argument.
Argument is changed. Continue.
The defendant's actions and responses during those 31 days answer for you the only real question left at this stage of the proceedings. And that is, who killed Kaylee Anthony? The question is no longer, where is Kaylee? You will remember in my opening statement, I asked over and over again, where is Kaylee Marie Anthony? We know where Kaylee Marie Anthony is.
Non-rebuttal.
Overruled.
Margaret,
The question is no longer what happened
Yeah.
to Kaylee Marie Anthony.
I
We
tried
know
to find that out today. I was
What happened?
unsuccessful.
Kaylee.
It's a great
The
question.
question is, who killed Kaylee? For the longest time, Kaylee was alive. Nobody killed Kaylee. Kaylee is alive. Until her remains are found. As I told you, as I warned you about in opening statement, as the facts and circumstances,
I think the better question is, what did he cost before Casey, and what does he cost now? It's like Alan Jackson. I know Alan's done incredible work in his career, but like before Karen Reed and after Karen Reed.
Changed over the course of time. The defendant's lies changed. They got bigger. They got better. They involved more people. Mr. Baez, in his closing statement, would have you believe that there must be something wrong with Casey Anthony because she has, quote unquote, imaginary friends. Those weren't imaginary friends.
Which is crazy.
Those were lies. Every one of them was a lie. Ask yourselves, a lie designed to do what? A lie designed for a specific purpose. To get Casey out of a jam. So for the longest time, Kaylee is alive. Until her remains are found.
We're playing.
And then, of course, the lie can't be Kaylee is with the nanny. She's alive. She's been kidnapped. I had nothing to do with it.
May we approach?
No.
The lie must change. I told you in opening statement that it would. So now the theory
I really like him. I do.
is that there was some sort of accident. Well, you know from the evidence in this case that Kaylee Anthony's death was no accident. First off, the Orange County Sheriff's Office proposed to Casey Anthony on July 16th of 2008, maybe your baby died by accident.
Ma'am, why are you yelling? My Lord.
I had to sit down with mothers who rolled over in their babies accidentally. I've had to sit down with mothers whose kids have drowned in swimming pools. I've had to sit down with mothers who had boyfriends who beat their kids to death, who felt horrible about what happened, and then I've had to go to the help them try to explain to their families, okay? And then I've also had to deal with people who had done horrible, unspeakable things to children, and then lied about it, and lied about it, and lied about it, okay?
Every single day.
Now I bet you somewhere in there, I probably know somebody who maybe made a mistake, but continued to lie about it. Maybe they weren't such a bad person, but maybe the whole world didn't see it that way. Maybe their family didn't see it that way because they kept lying about it. And then when it finally came, and months down the road, or days down the road, when they finally decided to come forward, okay, people passed it. You told me that you lied to me the last time. I don't listen to what you have to say. Don't talk to me anymore, okay?
In his closing statement to you, counsel suggested that the Orange County Sheriff's Office had murder on their minds, that they didn't want to consider that this was an accident.
And
You heard right there. Was this an accident, basically? I've dealt with tons and tons and tons and tons of people. I've seen it all. Was this an accident?
I gotta say something. All right. She wants the jury to hear. Okay. So one thing that I resonated with in the Jodi Arias trial was the prosecutor constantly berating and yelling at her. Say what you will. I think that she's guilty. I think she is doing the time that she deserves. I think all the things. But I never, ever respond well to people speaking to me that way. I shut down. I'm a millennial. I'm not a Gen Xer. So take what you will with that. It's a trauma response. I stop listening. I completely think of other things. I am doing whatever it takes to not focus on whoever is yelling at me like that. Especially in situations like this, if it's not my parents, if it's not my boss, like if it's just some broad in this situation, you've lost me. I don't know if there were people like me on this jury, but take that for what it is, because I have the balls to admit to it. This doesn't work on everyone. I am one of those people. You would have gotten a lot further having rational, like, non-combative, tough discussions with me than just yelling. So, thanks.
No, Kaylee is alive.
Yes, tell us.
The defendant's mother suggested the whole accident scenario involving the pool specifically on August 16th of 2008. Can we hear that, please?
Well, someone just said that Kaylee was dead this morning, that she drowned in the pool. That's the newest story out there. Surprise, surprise.
Surprise, surprise. So when Kaylee Anthony is found dead on December 11th of 2008, surprise, surprise, it's an accident.
I appreciate you saying that, Howard Richards.
No person would ever make the accidental death of a child look like murder.
Yeah.
The defendant's actions during those 31 days and her response to this are completely inconsistent with what people do 100% of the time. You heard Dr. Garavaglia say 100% of the time when a child is involved in an accident, somebody tries to save them. They want them to live. They call 911.
Thanks so much.
They anguish over the death of a child, especially if you want to accept this testimony that Miss Anthony was an amazing mother. Who did you hear that from? How was that defined? Her friends? People who don't have kids, that have other lives, that have seen 2 seconds of interaction? The questions in
Whoops. Oh, yes. I have enough time to run to the restroom. I'll be right back. You may have to listen to Pearl snore. Ma'am. Oh, oh no. Oh, wait. What happened? Good Lord. Hold on, guys. Thank God I noticed that. Here, let me go back.
this testimony
Okay.
that Miss Anthony was an amazing mother. Who did you hear that from? How was that defined? Her friends? People who don't have kids, that have other lives, that have seen 2 seconds of interaction? The questions in support of, what did you think about Casey Anthony's relationship with her child, were things like, did Kaylee run to her mother? Of course she did. Every baby loves their mother. They have every reason to. Their love is unconditional. Of course she's going to run to her mother, just like she ran to her grandparents. Well, Casey provided food and shelter and clothes for Kaylee. That makes her a great mother. No, that makes her a mother. maybe an adequate mother. But in reality, the food, the clothes, the shelter were provided by her grandparents. That's why Kaylee was healthy and happy and well fed and well taken care of and nicely dressed. Look at her room. Look at their backyard. What amazing parent acts with complete indifference to the accidental death of their child? You heard from the defense own expert an example of an amazing parent, a woman whose child died, and she wanted to go to the child's gravesite because that child had never been in a storm in the dark alone. That's an amazing mother. A mother who tried to protect her child, even in death. If this truly was an accident in the pool, Kaylee Anthony would have been found floating in the pool, not floating in a swamp down the street. If this was an accident that George Anthony knew about, he told you, we wouldn't be here today. I wouldn't be here. They wouldn't be here. She wouldn't be here. You wouldn't be here.
Overruled.
If he was home, as they suggested, when there was an accident in the pool, he would have called 911. He would have tried CPR. He would never have scooped up his granddaughter and put her in a bag and threw her in the woods. Never. No paternal instinct. Did we watch the same jail videos? Mr. Ashton has covered this, but did we watch the same videos? Mr. Anthony said he would trade places with his daughter in a second.
This has been argued by Mr. Ashton.
Sustained.
This argument cannot be followed to any logical conclusion. The way these remains were disposed of shows complete indifference to the child. It speaks volumes about how the person who disposed of her really felt about her. Can we look at the picture of the playhouse, please? This is how George and Cindy Anthony felt about their granddaughter. They built her a playhouse in the backyard. George Anthony landscaped it for her, put a little mailbox out there for her with her name on it. Put
Oh
a
my God,
stone
that is
base.
so cute.
Overruled.
Put a stone base under that playhouse so that Kaylee wouldn't have to sit on the ground in case it was wet. So that Kaylee wouldn't have to sit on the ground where an insect
What does that mean?
could crawl on her. On those jail videos, you heard Mr. Anthony over and over again trying to get Casey to talk to law enforcement, to the sheriff's office, to the Federal Bureau of Investigation. If he was so diabolical that he was trying to cover up something, why would he want his co-conspirator to talk to the cops? That makes no sense. I'm trying to engage in a cover-up, but I want you to talk to the cops.
So,
Not
There were
only does the
many.
disposal of those remains speak volumes
I'll type.
about how Casey Anthony felt about Kaylee, the phone call that she made to her parents the night that she was arrested, July 16th of 2008.
Non-rebuttal. It's the second closing argument.
Talking
Overruled.
Oh, sorry. Okay, I'm ordering. I got it by
Hello?
a new tripod.
Hello, this is a free call from Casey. An inmate from the Orange County Correctional Center. For a rate quote, press 7. To accept this free call, press 0. To obtain a customer, this call is subject to monitoring and recording. Thank you for using Global Tel Link.
Casey?
Mom.
Hey, sweetie.
Well, I just saw your nice little cameo on TV.
Which one?
What do you mean, which one?
Which one? I did 4 different ones, and I don't know. I haven't seen them all. I've only seen 1 or 2 so far.
You don't know what my involvement is and stuff?
Casey?
Mom.
What?
No.
I don't know
I've
what your
had
involvement
this
is, sweetheart.
conversation with my mom.
You're not telling me where she's at.
Because I don't fucking know where she's at. Are you kidding me?
Casey, don't waste your call to
No.
scream and holler at me.
Waste my call sitting in, the jail?
Whose
And
fault
where
is-
bunks are?
Whose fault is you're sitting in the jail? You're blaming me that you're sitting in the jail?
Not
Blame
my
yourself
fault.
for telling lies. You mean it's not your fault? What do you mean it's not your fault, sweetheart? If you'd have told them the truth and not lied about everything, they wouldn't.
Do me a favor, just tell me what Tony's number is. I don't want to talk to you right now. Forget it.
I don't have his number.
We'll get it from Lee because I know Lee's at the house. I saw Mallory's car was out front.
Well, this was like the first day,
It was
right?
just on the news. They were just live outside the house.
I know they were.
Well, can you get Tony's number for me so I can call him?
Do you guys do that? Sound like crying. I think it might be my husband. Are you crying?
Hey, can you give me Tony's number?
I can do that. I don't know what real good it's going to do you at this point.
Well, I'd like to talk to him anyway.
Okay.
Because I called to talk to my mother, and it's a fucking waste. Oh, by the way, I don't want any of you coming up here when I have my first hearing for bond and everything else. Like, don't even fucking waste your time coming up here.
You know, you're making it real tough for anybody to want to try to, even if it's you with giving you
See, that's
somebody's
just
phone number.
every single
You're not even letting me finish.
Well, Let's go ahead.
You're asking me for Tony's phone number so you can call him, and then you immediately want to start cussing towards me and saying, don't even worry about coming up here for all this stuff and trying to cut us out.
I'm not trying to cut anybody out.
I'm not going around and around with you. You know, that's pretty pointless. I'm not going to put everybody else through the same stuff that you've been putting the police and everybody else through for the last 24 hours and the stuff you've been putting Mom through for the last 4 or 5 weeks. I'm done with that. So you can tell me what's going on. Christina would love to talk to you because she thinks that you will tell her what's going on. Frankly, we're going to find out. Whatever's going on, it's going to be found out. So why not do it now?
There's nothing to find out. There's absolutely nothing to find out. Not even what I told the detective.
Well, you know, everything
I have
she's
no
telling
clue
them
where
is a
Kaylee.
lie.
If I knew where Kaylee was, do you think any of this would be happening? No.
Anyway, you only got a couple minutes of this, so I'm not going to let you
For the
completely
love of
waste your
God,
Christina.
someone
She thinks she can get through.
No, I want Tony's number. I'm not talking to anybody else.
Hello.
Hi, I'm glad everybody's at my house. I'll have to call you later. I'll have to call somebody to get your number. Do me a favor, get my brother back because I need Tony's number.
Okay. Is there anything I can do for you?
I'm sitting in jail. There's nothing anybody can do right now.
Well, I'm just trying to be.
Oh, I know you are, honey. I absolutely know that you are, and I appreciate everything that you're trying to do, but I'd like to call Tony. He's not at my house, is he?
No, no, it's just me and your parents and Lee.
Okay, well, can you do me a favor and get my brother back or get the number from him, please?
Does Tony have anything to do with Kaylee?
No. Nothing.
Okay, so why do you want to talk to Tony? You probably don't want to tell me, do you?
Huh?
You probably don't want to tell me, do you?
What do you, I didn't hear what you said.
I said, does Tony have anything to do with Kaylee?
No, Tony has nothing to do with Kaylee.
Oh, so why do you want to talk to him? You probably don't want to tell me.
Because he's my boyfriend, and I want to actually try to sit and talk to him because I didn't get a chance to talk to him earlier because I got arrested on a fucking whim today. Because they're blaming me for stuff that I never would do, that I didn't do.
Okay. Well, I'm on your side. You know that.
Oh,
Right?
I know that. I just want to talk to Tony, get a little bit of.
Casey, you have to tell me if you know anything about Kaylee.
Sweetheart,
if anything happens to Kaylee, Casey, I'll die. You understand? I'll die. If anything happens to that baby.
Oh my God. Calling you guys? A waste. Huge waste. Honey, I love you. You know I would not let anything happen to my daughter. If I knew where she was, this wouldn't be going on.
So how come everybody's saying you're lying?
Because nobody's fucking listening to anything that I'm saying. The media completely misconstrued everything that I said. The fucking detectives told them fucking bullshit. They got all of their information from me, yet at the same time, they're twisting stuff. They've already said they're going to pin this on me if they don't find Kaylee. They've already said that.
Well,
they arrested me because they said that.
Yeah, because they said that the person that you dropped Kaylee with doesn't even exist.
Because, oh, look, they can't find her in the Florida database. She's not just from Florida. If they would actually listen to anything that I would have said to them, they would have had their leads. They maybe could have tracked her down. They haven't listened to a fucking thing that I've said.
Do you know that whoever has Kaylee, nobody's going to get away with this? Nobody.
I know nobody's going to get away with it, but at the same time, the only way they're going to find Kaylee is if they actually listen to what I'm saying, and I'm trying to help them, and they're not letting me help them.
So how can I help them find her? The best thing you can do, baby, is listen.
They need to look up her information in a New York database, in a North Carolina database, other places that she's lived outside of.
Hey guys, if you are watching, thank you so much. I really appreciate it. Please make sure that you have hit the thumbs up button. That is a like. It is free. And while you're at it, if you could make sure that you are subscribed to my channel, that would also help me immensely get out the reach with the algorithm. Thanks, guys.
Florida. That's what I told them even again today. I told them that 4 times today. I sat up at the police station, up at the county police station.
But she's the one who has Kaylee, or she transferred Kaylee to somebody else? Because
honey, I haven't talked to her. I don't know. I haven't talked to her.
How can everybody saying that you're not upset, that you're not crying, that you show no caring of where Kaylee is at all?
I'm not sitting here fucking crying every 2 seconds because I have to stay composed to talk to detectives, to make other phone calls, to do other things. I can't sit here and be crying every 2 seconds like I want to. I can't.
Okay, Casey, don't yell at me. I'm on your side. I'm on your side.
I know you're not.
Trust me.
I know you're on my side. I'm not trying to
Nobody is saying anything bad about you. Your family is with you 100%.
No, they're not. That's bullshit because I just watched the fucking news and heard everything that my mom said. Nobody in my own family is on my side.
Yes, they are. Nobody has said.
They just want Kaylee back. That's all they're worried about right now, is getting Kaylee back. And you know what? That's all I care about right now.
Casey, your daughter, your flesh and blood, your baby girl.
Christina, please put my brother back on the phone. I don't want to get into this with you right now. I love you, honey, and I'm glad that you're there. Thank you for your help. I will let you know if there's anything that you can do.
You can't tell me anybody that can find Kaylee. Nobody.
No, because every number that I've tried, every number that I've called is disconnected. Nothing. I can't get a hold of anybody.
But that girl was the last person to have her?
She was the last person to have her. That was the last time I saw Kaylee.
Okay. He doesn't. Lee says he doesn't have Tony's phone number.
Yes, he does. He has Tony's phone number in his phone. He needs to stop fucking lying. He just told me a second ago that he'd give me the number.
So if I go and I get you Tony's number, are you gonna finish talking to me?
I will call you tomorrow. I want to talk to him really quick now. I don't want to actually try to close my eyes. I haven't slept in 4 days. I have not slept in 4 days.
Listen, if you're going to talk to anybody, you can talk to me. And
I know I can talk to you, but at the same time, I know I can talk to Tony, and that's who I want to talk to right now. I haven't gotten a chance to talk to him since this morning.
This family, I can read them like a friggin' book.
When you use your common sense, you can listen and hear that there's nothing that's wrong with Casey Anthony that can't be explained using 2 words: pathological liar. She's not grieving the accidental death of her daughter. Her focus in that call was where it had been for that day and the 31 days preceding it, and that is with Tony Lazzaro. That's all she wanted to do when she called her parents, aside from cuss them out. I want Tony's number.
Let's speed her up a little bit.
You have learned during the course of this trial that Casey Anthony
She doesn't talk
is
so
the only
fast.
person who had access to every single piece of evidence discussed by Mr. Ashton today
No.
and yesterday. The duct tape, the laundry bag, the blanket, the shorts, the car. There's no evidence that anyone other than Casey Anthony was driving around in that car that began to smell to the point where she is texting her friend, Amy Huizenga, "I think my dad has run over a dead animal." She texted that to Amy Huizenga about 15 minutes before her boyfriend, Tony, picked her up at the Amscot. So you would think if your car smells like there's a dead animal plastered to the frame of it, maybe you check the trunk. Maybe you see if there's a garbage bag or a trash bag in the trunk. That trash bag was placed there as a decoy. You heard testimony from Catherine Sanchez. that that car was backed into that spot by the dumpster. Why the dumpster? Guess why the dumpster? Because in addition to the bag of trash, the dumpster was a decoy to keep people either away from the car or thinking that was the source of the odor. The Anthonys didn't have access to that car. George Anthony didn't know where that car was. Miss Anthony was on the way to the boyfriend that her parents didn't even know existed. How would they know where to find her car? She told her mother she was in Tampa or Jacksonville or somewhere. They didn't know where she was or where the car was. And finally, the shirt. Big
Just
trouble.
Jane, is your
Comes
name
in small
Kate?
packages. Indeed. Cindy Anthony told you that shirt was not one that she was familiar with. She did the laundry.
Not Scotland.
That shirt was not
You'll
kept
get better with
at
time.
the Anthony
See you
house on
tomorrow,
Hook Spring Drive.
maybe?
That shirt was kept in the car, in the diaper bag or a backpack, because we saw it on 2 different occasions at Ricardo Morales' apartment in January of 2008, and then again in March. Someone in that house killed Kaylee Anthony. They want you to believe it was George who was involved in a cover-up of an accident that did not happen. Even George Anthony didn't have access to all of these things. Only Casey Anthony did. No one else tried to cover up and lie and lie and lie and lie, and I can go on a dozen or more times.
Oh my God, guys.
Where were George and Cindy?
I didn't mean to cut it off so quickly, but look at this. Look at this. 90,551 views in the last 48 hours. Tell me that's not crazy. We're on to something, y'all. We're on to something. Oh. Whoops. I hate that it does that. I won't do it again.
For leaving the ladder down. Let's twist the knife in my mom a little more.
Hey, Debbie.
The cover-up is her dad's fault. Let's twist the knife in him too. What were George and Cindy Anthony doing in June and July of 2008?
I will. Next week.
They're living at home.
We'll talk about next
They're
week
going to work
shortly, but
when they're missing their granddaughter. What's Casey Anthony doing? Where is Casey Anthony? Well, she's not where she normally is, at home. She's at Tony's because that's who saw her. She tells her mom she's in Tampa or Jacksonville or wherever. She's not where she's supposed to be. And where's Kaylee? Kaylee's dead in the woods.
it's one way to put it.
At the end of this case, all you really have to do is ask yourself a simple question. Whose life was better without Kaylee? Was Cindy Anthony's life better?
No.
I called a little bit ago. The deputy sheriff's saying I found out my granddaughter has been taken. She has been missing for a month.
Okay, whoa.
But she's been missing. Okay, what someone here now?
Whoa. Whoa. Cindy, you are why we can't have nice things. 207-15. 207-15. Right.
Was better without Kaylee. Was Cindy Anthony's life better?
Sorry, go.
I called a little bit ago. The deputy sheriff said I found out my granddaughter has been taken. She has been missing for a month. Her mother finally admitted that she's been missing.
Okay, what is
here now?
Okay, what is the address that you're calling from?
4937 Hope Spring Drive. We're talking about a 3-year-old little girl.
4937 what?
Hope Spring, HOPESPRING Drive, Orlando. My daughter finally admitted that the baby's in the store. I need to find her.
Your daughter admitted that the baby is where?
The babysitter took her months ago that my daughter's been looking for. I told you my daughter was missing for a month. I just found her today, but I can't find my granddaughter. She just admitted to me that she's been trying to find her herself. There's something wrong. I found my daughter's car today, and it smells like there's been a dead body in the damn car.
Okay, what is the 3-year-old's name?
God bless you, Debbie.
Was George Anthony's life better? Mr. Ashton went over what George Anthony's life was like
Great penmanship, though.
as a result of losing his beloved granddaughter. Whose life was better? That's the only question you need to answer in considering why Kaylee Marie Anthony was left on the side of the road dead.
Oh, we almost finished. Almost.
There's your answer.
Oh.
Okay, ladies and gentlemen of the jury, we're going to take a brief recess. When you return, you will hear the final instructions on the law from the court. We'll be in recess. Okay, has both sides had an opportunity to look at and review the final instructions?
Yes, sir.
Defense?
Yes, sir.
Okay.
I have a motion at this time.
Yes, sir.
Yes, the defense would make a motion for mistrial based on 2 improper comments by both counsels during their second and third closing arguments. One would be the comments by Mr. Ashton, where he stated that there was no evidence no evidence or explanation of where it came from, creating a burden on the defense to give an explanation of where the chloroform came from. The second comment would be on Ms. Jane Burdick's statement, where she had stated that the defendant had changed her story once the remains were found. This is an improper comment, improper argument based on statements that were never made by Ms. Anthony. Ms. Anthony did not testify, and to make false statements as such would be improper argument. And for those reasons, we would move for a mistrial.
Motion for mistrial will be denied.
Gotta try.
Mr. Mason, turn the speaker up. Please, sir.
I mean, 3
Verdict form, complete package, missing the 2 special finding ones. You have the last one, Frank.
That's what I
Mason,
think,
you may also want to
especially from
inspect the
Youngstown.
verdict forms that I will be reading to the jury.
All right.
Make sure those are the same
okay.
ones that we discussed yesterday.
Not important. So what I'm going to do now, I'm going to not show the juror instructions, because if you've watched my other streams, I think that is the bane of my existence. So what we are going to do is go to the verdict, and then I am going to rather show you guys a clip from a juror interview, and we will end there. I got some questions. If you ask me a question, I said that I would address them. Please write them in the chat. It'll come to me, all the things that I need to say. The best way that you can show your support, aside from liking and subscribing to the channel, is to become a member, to donate gift memberships, like gift the memberships. Or if you want to send a personal donation, my information is scrolling at the bottom of the stream. And YouTube doesn't take a cut of it. So, all right, guys, you ready for this? Oh, tomorrow, 3:30 p.m. Eastern. I do this every Tuesday through Friday, beginning at 3:30. We normally go like 3 to 3.5 hours. It's just when I'm finishing up a trial, I have longer nights. I don't like it. Nobody likes it. But maybe maybe gets one of my kidneys. That's what I'm gonna say.
Let the record reflect that the defendant is present along with counsel for the defendant. Both sides ready to proceed. It's been brought to my attention that the jury has reached the verdict. State?
State's ready to proceed, Your Honor.
Defense?
Defense is ready.
To those in the gallery, please do not express any signs of approval or disapproval upon the reading of the verdict. Let's return to jury. State recognized presence of the jury.
We do, Your Honor.
And does the defense.
Watch this lady's face when she gets the papers. I did watch this yesterday.
Yes, sir, we do.
Good afternoon, ladies and gentlemen of the jury. Have you reached the verdict? Would you hand the verdict form to the court deputy, please? Will the defendant rise along with counsel? Madam Clerk, you may publish the verdicts.
In the Circuit Court for the Ninth Judicial Circuit in
Right.
Fort Orange County, Florida, State of Florida versus Casey Marie Anthony. As to case number 2008 CF 15606-0. As to the charge of first-degree murder, verdict as to count 1. We, the jury, find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, on this 5th day of July, 2011, signed foreperson. As to the charge of aggravated child abuse, verdict as to count 2. We, the jury, find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of aggravated manslaughter of a child, verdict as to count 3. We, the jury, find the defendant not guilty, so say we all, dated at Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 4. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 5. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict as to count 6. We, the jury, find the defendant not guilty. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson. As to the charge of providing false information to a law enforcement officer, verdict is to count 7. We, the jury, find the defendant guilty of providing false information to a law enforcement officer as charged in the indictment. So say we all, dated Orlando, Orange County, Florida, this 5th day of July, 2011, signed foreperson.
Madam Clerk, you may poll the jury.
Yes. Juror number 1, were these your true and correct verdicts? Pardon? Juror number 1, were these your true and correct verdicts? Not guilty.
She's
Were they all your true
frazzled.
and correct verdicts? Yes. Juror number 2, were these your true and correct verdicts?
Yes.
Juror number
I would pay out of my own pocket. I would pay money to have seen their faces when the verdicts were read. I don't care about Casey's face. Sounds awful when I say that, but for real.
3, were these your true and correct verdicts?
Yes.
Juror number 4, were these your true and correct verdicts?
Yes.
Juror Juror number 5, were these your true and correct verdicts?
Yes.
Juror number 6, were these your true and correct verdicts?
Yes.
Juror number 7, were these your true and correct verdicts?
Yes.
Juror number 8, were these your true and correct verdicts?
Yes.
Juror number 9,
What's
were
up,
these your true and
Texas?
correct verdicts?
Yes.
Juror number 10, were these your true and correct verdicts?
Yes.
Juror number 11, were these your true and correct verdicts?
Hey,
And juror number 12, were
Texas,
these your true and
be
correct
safe
verdicts?
tomorrow.
Yes. Thank you.
Will
y'all have some
counsel
weather coming.
and the
Look at
defendant
that.
approach the podium?
God, I absolutely
Not all the counsel, but just
think she's a
Representative
piece of
Sampson.
shit. But defense attorneys doing their job
Casey Marie Anthony, a jury of your peers,
something-
having found you not guilty
sounds
as to
bad.
the charge contained in count 1 of the indictment, murder in the first degree.
See,
At this time, I will adjudge you to be not guilty. As
hate
to
that. I'm sorry.
count 2, the crime of aggravated child abuse,
because I
a
love
jury
my
of your
community.
peers having found you to be not guilty, the court will adjudge you to be not guilty of the crime contained in count 2. As to count 3, aggravated manslaughter of a
Thank you.
child, a jury of your peers
You're
having
my whole
found you not guilty, I will adjudge you to be not guilty of that count. As the counts 4, 5, 6, and 7, providing false information to a law enforcement officer, I will adjudge you to be guilty of those counts in order that you be fingerprinted here in open court at this time.
God, and what did her parents' faces look like? Like, I have so many questions. And I just found out that one of her attorneys is located in Cincinnati.
It has to be in open court.
That one that
Okay,
just
Mr.
walked
Baez, Mr.
over
Mason,
there, she's from Cincinnati.
will you be prepared to go to sentencing Thursday or Friday of this week? Okay, then we'll set sentencing Thursday at 9 a.m. in this courtroom. Okay, are there any other matters that we need to take up at this time?
Nothing from the state, Your Honor.
Ladies and gentlemen of the jury, on behalf of the citizens of the Ninth Judicial Circuit,
This
I
is
would like to
important.
express my sincere thanks and appreciation
matter
for
what.
your service as jurors.
You
You
always
all
thank
residents of
jurors,
Pinellas
no
County,
matter what.
Florida. And we came over there, met with you, questioned you, and took you away from your
Okay.
families for a very extended period of time. And for that, I say thank you. As I told you when I first spoke with you, in talking about jury service, that one of the most important obligations of citizenship, in my opinion, was service on a jury. I tell you, it was very important that if we believed in that constitutional provision that provides a right to trial by jury, that it was important for people to serve no matter what that sacrifice would be. As you can tell by some of the questions that some folks answered, a lot of people did not want to serve. And you knew it would be a hardship, and you were candid with attorneys. You answered all their questions and you served. And for that, we thank you. I would also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and vote shall remain their private affairs as long as they wish it.
Amen.
Therefore, the law gives you a unique privilege not to speak about your jury work. Although you are at liberty to speak with anyone about your deliberations, you also are at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious or from those who might seek to find fault with you. From the media, from attorneys, or elsewhere, it will be up to you to decide whether to preserve your privacy as jurors. Again, thank you.
Show you.
You're hereby
I do
discharged,
want to
and
show
I will
you
see you
this
shortly
next
back in the jury
video.
room. Thank you.
I would have been throwing up and passing out. Can you even imagine? I feel like we never see this.
Okay, Madam Clerk, you may call the case.
Case number 2008 CF 15606, State of Florida versus Casey Marie Anthony.
Okay, let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney.
Girl,
Both sides ready to proceed.
get a hold of your hair.
Yes, sir.
I believe so, Your Honor.
Mr. Mason, before we proceed to
Looks like
sentencing
he has
Mr.
a
Baez, you had asked me to reserve ruling on your motion for mistrial.
All that, Your Honor.
Okay,
I bet you
that
do.
takes care of that. The defendant,
have to
Casey
laugh
Anthony, is before the court
thing.
for sentencing on counts 4, 5, and 6, providing false information to a law enforcement officer. Mr. Baez, do you know of any legal cause why we should not proceed to sentencing at this time, sir?
Thank
4, 5, 6,
you
and 7.
And
so
7.
much.
And the only legal cause that we have would be the previously filed motions packing, none of it. No legal cause why you can't proceed to sentencing with the subsequent remedies if she takes them.
Craziest.
Would the state care at this time to present any matters relative to aggravation?
Not on that issue.
The lady who put her boyfriend in the suitcase might go up there with Jody. I don't know. Maybe. Jody is just a whole different level, though.
Your Honor, no.
State care to present any issues at this time concerning any other matter?
Your Honor,
I want to stress this comment.
yesterday I filed a motion to tax special costs of investigation and prosecution and to reserve jurisdiction. The only reason that I would bring this up prior to the actual sentencing has to do with the jurisdiction of the court. Once sentence is imposed, if defense counsel intends to appeal the misdemeanor convictions, then this court would not be able to entertain a later hearing until that matter is resolved as it relates to costs of investigation. If in fact that is their intent, what we would ask is that the court bifurcate the sentencing hearing proceeding to the matters of punishment first. The issue of cost of investigation is not intended to be punitive, and I believe can be handled at a later point in time in a bifurcated type of proceeding that would not divest the court of immediate jurisdiction to handle this matter so that this can be closed as expeditiously as possible. That is the only thing I would bring up at this time.
Coverage
Mr. Baez?
footage.
Mr. Mason, I will be handling.
Mr. Mason?
I do not object to the bifurcation process, Your Honor. They have not presented invoices to us in any accounting as of yet, which we will be reviewing and then challenging as a.
I want to say something, and that is because I have in the last month, and I am going to pat myself on this. I listened to what was going on YouTube. I had the ability to critique myself and to take the criticism of others to realize that what I was doing wasn't working. And I feel like it's so important in order to understand the future to the best of your ability, you have to look at the past. And there are very few people doing what I'm doing right now. And I think that everyone gets so caught up on what's happening right now and just like, and maybe this has nothing to do with you because maybe wants me to do newer trials. And a lot of you voted for like a mix. I'm really at an impasse because it seems like a lot of people really enjoy reflecting on the trials that have built the society to what it is. And we're unaffected by things as trivial as TikTok. And for that reason, I've really enjoyed all of this. I've enjoyed every moment behind screen. And people like Maybe and people like Bad Kitty, I couldn't do this without them. So whatever you guys want to want to see, as long as there is video footage of the trial. I'm all ears. Like, let me know. Otherwise, I can't. I'm just not going to. So let's continue. Get the brunt of what's going on here. And then I want to show you that juror interview. And then we'll be done for the night. Thank God. My back's killing me.
Appropriate. So she asked for 60 days, and I have no problem with that.
Okay, the court will retain jurisdiction to deal with the issue of cost of prosecution and other costs, I guess, pursuant to Chapter 938. That's the statute that you're seeking those costs under?
It is, Your Honor. Thank you.
Okay. Mr. Mason, mitigation. You may proceed, sir.
And I do think this is just as important. And this stupid old man never learned to turn on his
Go
fucking.
ahead. All right.
May it please the court?
Good morning.
Good morning, Your Honor. Your Honor, before sentencing, we respectfully request that the court address the violation of double jeopardy at issue with respect to counts 5, 6, and 7. Because all 4 statements in the indictment arose during the July 16th interview between Detective Melich and Miss Anthony, all 4 counts of providing false information to a law enforcement officer were one continuous criminal act with a single intent. As such, each false statement separately charged violates double jeopardy and must be reduced to one conviction based on one occurrence and course of conduct. In Hamill v. State, which we provided to the court, that's 934 Southern 2nd, 634, that's a Florida 2nd DCA case from 2006, the defendant was convicted of 15 counts of using a computer to seduce a child. At issue was whether counts 5 and 6, among other things, arose from a single criminal episode. In Hamill, the court articulated the test to determine whether offenses arise from a single criminal episode. In that test, the court articulated that—
Fryer, let me stop you for a second.
Yes, Your Honor.
I don't seem to have benefit of what you said you provided the court.
I apologize, Your Honor. I gave that to the clerk, and I should have instructed that you needed.
Sorry,
have that.
my dog's barking. Hold on. Is everything okay? Okay. I had it on I slowed it down, guys. I slowed it down. I'm sorry. I know people have places to go. So I was trying to be respectful. But here we go.
Okay.
Just a little bit. I slowed it.
Okay, go ahead.
Okay, thank you, Your Honor. This test requires a court to look to whether there was a separation of time, place, or circumstances between the crimes because those factors are objective criteria utilized to determine whether there are distinct and independent criminal acts or whether there is one continuous criminal act with a single criminal intent. The court went on to say that the spatial and temporal aspects of the crimes, looking at that criteria, a court can ascertain whether the defendant had time to pause, reflect, and form a new criminal intent between the occurrences. Your Honor, in finding that counts 5 and 6 in the Hamill case were a violation of double jeopardy, the court pointed to the fact that there was no temporal break in the conversation or change in circumstances to warrant separate charges, where the conversation in question spanned several hours. Similarly, Your Honor, the false statements Miss Anthony made to Detective Yuri Melich occurred during the course of a single interview on July 16th, 2008. The interview was one continuous conversation, and similarly, there were no temporal breaks or other objective criteria that would suggest that the defendant had time to pause, reflect, and form a new criminal intent as required so as to not run afoul of double jeopardy. We've also provided the court with 2 other cases. That Hood case, that is 511 Southern 2nd 401, and that was out of the 5th DCA. That's a 1987 case. And we also provided the court with Burke v. State. That's 475 Southern 2nd 252. And that's a 1985 case. It's our assertion that the Hamill case is similar in that it touches on the temporal aspects that are present in this case as well. However, the Hood decision, the double jeopardy was invoked when the defendant was convicted of 5 incidences of leaving one scene because there were 5 people in particular who were left at the scene of an accident. Burke, on the other hand, is a case that's invoked a double jeopardy where there were 3 convictions of the defendant based on one transaction of 3 altered bills. And those convictions were charged separately. However, because they were found to be one act, double jeopardy was violated in those cases as well. Your Honor, in order to avoid a legal sentence, we respectfully request that the court sentence Miss Anthony only for one occurrence, one count of providing false information to a law enforcement officer. Further, we reassert that there is an issue of materiality in these charges and should be read into the statute as legislative intent. Thank you very much.
Just a second.
Yes, sir.
Let's look at count 4
Yes, Your Honor.
of providing false information to a law enforcement officer.
Yes, sir.
Specifically, what is alleged in count 4?
Count 4 alleges specifically that on the 16th day of July 2008, that in violation of the statute 837.055, there was a knowing and willful violation and giving false information to Yuri Melich, a law enforcement officer. So that specific allegation was that Casey Marie Anthony suggested that she was employed at Universal Studios. However, it arose during the July 16th, 2008 interview, as did every other charge, Your Honor.
As a result of her telling the police that she was employed at Universal Studios, did the police have to take any resulting action with their investigation?
They certainly did, Your Honor. However, if we're to charge her, we have to charge her for the crime. And the crime here arose out of all 4 incidences were a part of the same continuous act, even though there were several false statements.
Count 5 alleges she violated that statute by doing what?
That during that same interview on the 16th of July, that Miss Anthony identified a person as Zenaida Fernandez Gonzalez and suggested to Detective Melich that she left her child with this woman.
And did that require a separate and distinct act on behalf of law enforcement to investigate?
It did, Your Honor. However, I would assert that the reaction based on the violation isn't how we measure this. How we measure if there was one instance, one particular criminal act that wasn't broken up temporally, we look not at the resulting conduct of the police department. What we look at is the conduct of Miss Anthony and the temporal aspects of her statements as required under this Hamel decision.
And count 6.
Yes, Your Honor.
What was she alleged to have done in count 6?
During the same interview on the 16th with Detective Melich on that 16th day of July in 2008, the allegation and the conviction is based on Miss Anthony informing Detective Melich that she identified a Jeffrey Michael Hopkins and a Juliette Lewis, that she had told them of a disappearance of her child. However, we reassert that there's a materiality issue related to this particular charge, and again assert that this is out of the same instance of conduct.
And count 7.
Count 7, Your Honor. This is the same interview that we've been discussing to Detective Melich. And this allegation is based on Miss Anthony asserting that she received a phone call from Kaylee Marie Anthony.
Just a second, since you just provided these cases
Yes,
to me. Let me read them right quick, see if I have any additional questions.
Let me read
Yes,
them.
Before I hear from the state of Florida. One last question, Ms. Fryer.
Yes, Your Honor.
Are you saying that Ms. Anthony did not have time to pause, reflect, and form a new criminal intent for each one of those 4 separate acts?
Yes, Your Honor. As the test is articulated under the Hamel decision, there has to be some separation of time, place, or circumstances. In the situation that we're dealing with today, there was one single interview. It can't be said that there was a break in either time, place, or circumstance as required to not invoke double jeopardy.
Is
Thank
this
you, Ms.
the
Frye.
Thank you,
state
Your Honor.
or the defense? I just think it was a really
Response from the state of Florida?
okay. I didn't think it was a good argument.
Like the court, I was only provided with this motion this morning. However, I believe even under their case law, as well as case law from the Florida Supreme Court, specifically Valdez, which I did not bring copies of, unfortunately, found at 3 Southern 3rd, 1067, the Florida Supreme Court case from 2009.
3 Southern 3rd.
Second, I'm sorry, 3 Southern 3rd, correct. 1067, Florida Supreme Court 2009, and Anderson at 697 Southern 2nd 309, the Florida Supreme Court case from 1997. These are not single acts. This is different core conduct. It is our position that there is a temporal break between each of the lies, and there are several, not just the ones charged, but that these lies occurred over the course of 3 separate statements. The fact that they all occurred on July 16th of 2008 should be of no consequence. The court, through the course of pretrial hearings as well as the trial, knows that Ms. Anthony gave statements at approximately 1 a.m., 4 a.m., and then 1 p.m.
I
on
mean, I
July
personally
16th
say
of 2008.
crazy
Each of the
middle
lies are material to the issues that were investigated by the sheriff's office. As a result of the lies, each were intended to mislead law enforcement and to send them, as Ms. Anthony herself at the end of the final statement indicated, on a wild goose chase. They are not degree variants of the same crime and are not a single criminal act. Most of the time when we're not dealing with multiple
telling me you
punishments for a
didn't
single act,
subscribe
what we
yesterday?
are
What the hell?
dealing with are whether or not a single act can be broken up into episodes. We typically see this in sexual battery cases where there are multiple sex acts performed on a single victim at the same time. And then the issue is whether or not there is a break between the various types of penetrations in those cases sufficient to convict for separate acts. And indeed, the case law suggests that there is a sufficient break where an individual does have the time to pause and reflect, as the court has already inquired. Given the fact that there were multiple statements over the course of 12 hours, it is the position of the state of Florida that these separate acts, as separately alleged, do not violate double jeopardy.
That their site was 3/7/3 edition. What page?
1067, if I have that right.
1067.
1067. I do have a copy. This is a situation where an individual
No one's told. No
was
one
charged
told
with
me I'm
2
really
different
pretty
counts
today.
for one
But
act
thank
of shooting.
you.
Would the court
Very
like my
sexy
copy?
old man.
It is just a second. Okay, Mr. Mason, Mr. Baez, anything else you would like to say prior to the court imposing sentence?
No, sir.
Does your client wish to say anything prior to the court imposing sentence?
No, Your Honor.
Not my super love for Casey. I think she's friggin' nuts.
The court will make the following finding concerning the defense motion to bar imposition of sentence on these 4 distinct counts as violating double jeopardy. Count 4 of the indictment alleging providing false information to a law enforcement officer
Throw the book at her.
basically dealt with the following conduct. It is alleged that the defendant was employed at Universal Studios during the year 2008. This information was given pursuant to an investigation for a missing persons report. That information caused law enforcement, in following up on that statement, to go to Universal Studios to expend law enforcement resources to determine that, in fact, Ms. Anthony did not, in fact, work at Universal Studios. Count 5, Ms. Anthony informed the authorities that she had left her child, Kelly Marie Anthony, at the Sawgrass Apartments with a babysitter, which caused law enforcement again, as a result of a missing persons report, to develop and follow various leads trying to locate this
He's usually
babysitter commonly known as
a great
Zanny.
orator, like great speaker.
Count 6
He didn't do well
again,
with this one.
dealt with the fact that she had informed 2, quote, employees of Universal Studios, Jeff Hopkins and Juliet Lewis, of the disappearance of Kelly Marie Anthony. Ms. Anthony in count 7 indicated to law enforcement that she had received a call
100%.
and spoke to Kelly Marie Anthony on July 15, 2008 at approximately 12 p.m., thus causing law enforcement to devote extensive resources. As a result of those 4 separate and distinct lies, law enforcement expended a great deal of time, energy, and manpower looking for young Kelly Marie Anthony. This search for her went on from July through December, over several months,
Okay, I
trying
can speed
to
him up.
find Kelly Marie Anthony. 4 distinct, separate lies. Just as the jury spoke loud and clear on counts 1, 2, and 3 by their verdict, they also spoke loud and clear as to the remaining counts 4, 5, 6, and 7. There being no legal cause shown why this court should not impose sentence, and the court having previously adjudged you to be guilty of the crimes contained in counts 4, 5, 6, and 7, I will sentence you to 1 year in the Orange County Jail, imposing a $1,000 fine on each count, all 4 counts to run consecutive to each other.
It was driving me
giving
crazy.
you credit for the time that you have previously served. Mr. Baez, Mr. Mason, we're going to spend some time this morning figuring out her credit for time served. And it's going to take us probably about an hour to sort it out because of the previous sentences that she has been given. But with the good time and gain time, depending on preliminary figures, sometime early August, maybe late July. But I can't say that until after I first determine time served, and then the jail has to apply, according to their figures, their good time and gain time that she has gained in this. So if you want to wait around, or we can communicate that with you, and if you have a different figure, then we can get that taken care of. I will reserve jurisdiction for 60 days to determine the cost of prosecution and investigation. Tell me when you'll be ready.
I've been advised a minimum of 30, so any time after that would be acceptable.
Well, Mr. Mason.
I want to have some time whenever they get around to providing and gathering up their invoices so we can check the validity of those and potentially conduct some discovery on it. So at least 30 days, I would assume. Depends on when she gets it to me. If she gets it to me on the 29th day, that's not going to be good.
I believe I would do that to Mr. Mason. They have indicated that they believe they can have all the documentation to me within the time frame that I've suggested, and then that should give Mr. Mason ample time to review the validity of the affidavits of the sheriff's office.
Well,
after she gets it to me.
Well, I'm trying to give you a date now. The week of August 15th, I will not be around. The week of the...
But he was around. Stay tuned.
22nd, I'm involved in an evidentiary hearing on a 3851 case that's supposed to last 3 days. I have some time on the 25th and the 26th. Depending on how long you need, I can fit you in on the week of the 29th, but I would have to fit you in because I'm unfortunately going to have to take over Judge Adams' division since he's leaving at the end of the month.
His plan was to retire right after this, and some asshole judge that he worked with, like 2 days before the trial ended, handed in his letter of resignation. And so Judge Perry had to like be a filler during this time when everyone knew that Judge Perry was trying to retire. Can you even imagine after sitting through this trial? I'd be so pissed. I'd be so pissed. Oh, 18
I have
comments. I'm sorry.
again the week of August 1st, but I have to fit you into that division's regular work. The week of August 9th with the same proviso.
except that
Okay.
Friday.
Bold strategy, Cotton.
So when would you like the hearing, folks?
Any of those options is acceptable, Your Honor.
You can have the 25th or the 26th. That should give you more than enough time to get the information, get it to Mr. Mason, Mr. Baez, and have them digest the information. So you want to do it Thursday or Friday, the 25th or the 26th? Friday being the 26th.
Thursday's fine.
I think this is
Acceptable to
how
counsel, and
the justice
I
system
don't know what
works.
Ms. Anthony's status will be at that point. Do they want to waive her appearance at that or have her present? I don't know if you want to address
But
that
that's
issue now.
what's awesome about our channel is we are allowed to have
The
different
25th,
opinions.
according to the preliminary
And not be
calculations, without
assholes.
going over, double checking some things, she won't be there.
So that's why I didn't know if we wanted to address whether or not the court would require her attendance. It's not a punishment aspect to the sentence.
That's
So-
entirely left up to her and her counsel. As far as I'm concerned, she can waive her appearance or she can come. That's left up.
We are intending to waive her appearance of the proceedings, Your Honor.
Oh my God, Coach.
I will also impose the statutory court costs. Ms. Anthony, you have a right to appeal the judgment and sentence that I rendered here in your case today, provided you file a notice of appeal within 30 days of the day's date with the clerk of the court. If you cannot afford the services of an attorney to assist you with this appeal, the court will appoint one to represent you. Bear those rights in mind, and after consulting with your attorney, do you wish to appeal?
We can have a moment, Your Honor.
Oh,
You may.
whoops. I think the whole family is a bunch of nutcases, and I know this for fact. And I explained that. at
Your Honor,
the
we
beginning
can't, we would like to reserve our right to make that decision at a later time.
You have 30 days from today's
Of
date
the
to file a notice
trial.
of appeal, or you forfeit or give up your right to appeal. Does she have the
My ex-boyfriend's dad dated Cindy. They went to prom together. And so, and I lived in Cleveland while this trial was happening. And the Anthony family is originally from Youngstown, which is not very far away at all. And so things like after the trial, I know for a fact that she was up in Youngstown. And it just like the whole family is in the head.
financial wherewithal, Mr. Baez, if she decides to appeal, to pay for appellate counsel?
No, Your Honor, but we would,
If she decides to do that, then please make sure that she fills out an affidavit of insolvency with the clerk of the court to timely bring that matter so counsel
Bad
can
kitty.
be appointed. As you know, if she does
You're
not file a
deported.
timely notice of appeal, then she
You're-
forfeits or gives up her right to appeal. If she decides to appeal and she wants appointed counsel, but it will be your responsibility to file the necessary appellate paperwork, that is the notice of appeal, statement of judicial acts to be reviewed, and designation to the court reporter. It will be your responsibility before you are relieved of your responsibilities as far as this case to have those documents filed. Are there any other matters on behalf of the state of Florida?
Nothing from the
Okay,
state,
here we go.
thank you.
Are there any other matters
That's
on
what I
behalf of the
wanted to show
defense?
you guys. This is the jury
Court will be in recess.
juror interview. It's not very long.
Where tonight, for the first time, you will hear
I have to
from a
talk
juror in the
over
Casey
it.
Anthony trial. In an exclusive
Going on
interview, this
couple.
woman, previously known only as juror number 3, gives us a first-hand account of the secret deliberations that led to yesterday's stunning verdict. Jennifer Ford is her name. She's 32 years old, training to become a nurse. And she tells us the first vote in that jury room was 10-2 for not guilty on first-degree murder. And tonight, she takes us inside those deliberations. Why? Why did you and the other jurors acquit Casey Anthony of murdering her daughter?
There wasn't enough evidence. There wasn't anything strong enough to say exactly. I don't think anyone in America could tell us exactly how she died. If you put even just the 12 jurors in one room with a piece of paper, write down how Kaylee died, nobody knows. We'd all be guessing. We have no idea.
So it's cause of death that was a problem?
How can you punish someone for something if you don't know what they did?
The prosecution wasn't able to give you a solid enough picture of how
Do you see
Kaylee
that
died.
picture? I have no idea what it like. They didn't even paint a picture for me to consider.
You think that this might have been an accident, that you might have drowned in the pool? You believe the defense on that?
I'm not saying that. I'm saying it's a lot easier to get to that conclusion. I can walk from here to there and make it happen. With the chloroform, I'm all over the place. I have no idea. I'm in a maze. I don't know where I'm at. I don't know where the end is. I'm not even quite sure where I began with the chloroform. So I can't get from beginning to end, A to B, to see what even happened. I can't make it work.
When you all went to deliberate this case, were you unanimous from the start? Or
No. Oh, no.
Really?
No, I mean, a lot of people, I mean, I don't know, I don't really want to speak for everyone else, but there were a lot of conflicting ideas, and some people were like, I feel like she did, but there's just not enough to substantiate it. Some people were just like, no, she didn't do it. Like, they have nothing for me to even have any idea what happened. And I did hear someone say, we're from Pinellas County, we didn't have that emotion, and that, whatever. That means we have no bias. We're just looking at the facts. And the facts, when you don't have that emotional connection, they don't prove anything. Like, I'm still confused. I have no idea what happened to that child.
There have been people who said you only deliberated 10 or 11 hours, and that shows you weren't serious. That you didn't really look at the evidence. It's a 31-day trial or whatever, it was 33-day trial. They say you must not have looked at the evidence.
That's speculation, and you know what? Speculation is not fact. We had a lot of discussions. We started to look through stuff, but none of it. How did she die? If you're going to charge someone with murder, don't you have to know how they killed someone or why they might have killed someone or have something where, when, why, how? Those are important questions. They were not answered.
That gets to Casey.
Right.
31 days that she does not report the death or disappearance of her daughter, and she parties.
Right.
And people say that's evidence that she.
Go back a little bit.
Is, and some people were like, I feel like she did, but there's just not enough to substantiate it. Some people are just like, no, she didn't do it. Like, they have nothing for me to even have any idea what happened. And I did hear someone say, we're from Pinellas County, we didn't have that emotion, and that, whatever. That means we have no bias. We're just looking at the facts. And the facts, when you don't have that emotional connection, they don't prove anything. Like, I'm still confused. I have no idea what happened to that child.
There have been people who said you only deliberated 10 or 11 hours, and that shows you weren't serious. That you didn't really look at the evidence. It's a 31-day trial or whatever it was, 33-day trial. They say you must not have looked at the evidence.
That's speculation, and you know what? Speculation is not fact. We had a lot of discussions. We started to look through stuff, but none of it. How did she die? If you're going to charge someone with murder, don't you have to know how they killed someone or why they might have killed someone or have something where, when, why, how? Those are important questions. They were not answered.
That gets to Casey.
Right.
31 days that she does not report the death or disappearance of her daughter, and she parties.
Right.
And people say that's evidence that she is a killer.
It looks very bad. The behavior is very bad, but bad behavior is not enough to prove a crime.
What did it tell you about her?
Well, if you consider the whole family, they didn't really live in reality. They wanted everything to be happy and everyone to be fine. Even when she, in the jail video, she came up smiling and she looked happy. She's in jail. Do you think that's how she really feels? I'm guessing not.
Did you believe the defense accusation that this was a family that had incest in it, that Casey had been molested by her father or brother?
I have nothing to substantiate that. So no, I mean, if
that
you don't
played
prove
no
it,
role in your deliberations.
no, if you don't prove it, I'm not going to just because I hear it. No, that's not a factor.
No,
What did you make of George Anthony's testimony?
that is.
He did not help the state's case.
Why?
Because he was clearly dishonest.
He was dishonest.
Yes.
How?
Well, he was evasive, number one. His story seemed to change depending on, like they said, initially he was on the defense's side. So he would, fight with Mr. Ashton and not give straight answers. But then he switched to the prosecution side. And then now he won't give the defense straight answers. It's all, what do you mean? And can you ask a question again? And I don't, clearly you can follow a logical conversation and respond. Like, he acted like he just couldn't understand what was going on. It was clear to me that he was just being difficult. He didn't want to answer questions. And if it didn't help the prosecution's case, he was going to try and I don't recall.
Do you believe George Anthony had something to do with what happened to Kaylee?
I don't know if he had anything to do with it, but I think he was there. Him and Casey have something. And the jail videos, again, her mom has all the questions and George sits there and, pats his wife's back. And then he's like, do you have anything else you want to tell me? He's not like, what's going on? He's always like a step back, hands are clean, not too close.
I want to get back to Casey because she's been the focus of so much attention.
Right, with her daughter, so.
Casey lies
Yes,
and
she
lies
does.
again. And then she goes out and she leads the high life while her daughter is dead.
Right.
People say that is evidence that this person was capable of killing that child.
Even if that's evidence that she is capable, it doesn't show that she did do it. Do I think she's completely innocent? I mean, I have no idea. I don't have the evidence to say one way or another. I'm not going to accuse her of killing. I have no idea, but we'll just say something happened. At some point, she probably needed medical care, or at least there could be some attempt to save the child's life. That was never made. That bothered me.
If it was an accident in the pool or wherever, how did the child end up in a swamp months later, rotting away?
You deny it, you get rid of it. You don't look at it, you don't think about it, it doesn't exist. It's gone.
You
push it out of your
cover up a
mind.
murder. That's what the prosecution said. It was
You're covering up something. It's not proven that's a murder. You're covering up something. It's either an accident or, nobody knows what it is.
I'm going to press you on this.
Go for
Duct tape on a baby in a bag rotting in the woods. Most people look at that, they put two and two together, they say that's a murder.
Well, in our country, unfortunately, we have to prove it. You can't just be like, yeah, that really looks bad. Smells bad, looks bad. I get that. It does. Smells bad, looks bad. I get that. but it's someone else's life. And if I'm wrong and I kill someone else, I can't live with that.
When you're in court as a juror, you have certain responsibilities.
Correct.
You're here now. Do you think Casey Anthony might have killed her daughter?
Again, it's a possibility. I don't know one way or another. Gut feeling, like I said, I feel like she had something to do with it. I don't know what, and I don't think it's fair to speculate. That's how I feel.
If you feel that she might have killed her daughter, a lot of people might say, how are you going to sleep at night?
I'm going to sleep just fine because I did
her job.
In this country, that's our constitution. I applied the law. I did the best I could. I tried to make it work. I was reaching. I was trying to, like I said, if they're all three there and no medical attention is given,
she followed the rules, guys.
What's it? Culpable negligence, failure to provide safety and medical care and things like that. I was trying to go for that, but there's just not enough. It's just stretching and reaching, and it's just not quite enough to get there.
How emotional was it to be a juror in this case?
I mean, there were quite a few people when we got back after the verdict was read. We were in tears.
Why were you
I would be too.
after you handed down
You
a
know
not
she's
guilty
fucking
verdict?
guilty, but the state's
Not guilty doesn't mean innocent.
How do you feel about that you may have let a woman who murdered her own daughter walk off that charge?
They
It
didn't.
doesn't feel good. It's a horrible decision to have to make, but I had to do it based on the law.
One thing you hear among the people who followed this trial is that they wanted justice for Kaylee. Was there any justice for Kaylee here?
That's the way our system works. You can't. I don't, if there was a way to give Kaylee justice, if that's what happened, you have to prove that what happened, and then I'll give Kaylee justice. I can't just do it because I can't. I mean, it's not how it works.
When you left the courthouse after your verdict and you found out the international reaction, anger, fury, people calling you names.
Yep.
What was your reaction?
My reaction is, why be mad at me? The prosecution had to prove it. Why is it my fault that they didn't prove their case? Like, if you give me the evidence, I'm happy to, return a verdict accordingly. But if it's just not there, I'm not going to speculate. I'm not going to be emotional and just charge somebody. I can't do that in good conscience.
How much did the fact that this was a death penalty case weigh on you in the course of the trial and in your deliberations?
Well, it weighs heavily. It's the ultimate. It's the ultimate. Like, it's as big as you can get. It's someone else's life in your hands. So if they want to charge and they want me to take someone's life, they have to prove it. They have to prove it, or else I'm a murderer too, and I'm not any better.
All right. That's it. Nope. Wait, what's this? It's not very long. Let me, in case you have to go, my stream, I do this on Tuesdays through Thursdays, beginning 3:30 p.m. Eastern time. So next week, let's have a conversation. Very quickly, I have to leave the premises because my father-in-law has been nice enough to commit to doing some renovations in our bathroom. It's going to be loud. It's going to be gross. We have dogs. There's a whole lot going on. So my husband and I have decided to leave town. He is going to stay in the home. He doesn't drive. He considers staying here a vacation. So he stays here the whole time. He watches the pets. We are going out of town. I am going to be going live. But I wanted to let you guys know that because it's not going to be as consistent as it normally is. It might be a little bit shorter streams. And I think that I am going to have to restream one of my old trials. I don't know yet. And I'm not worried about safety because my father-in-law is a card-carrying member of the Second Amendment. So, with that being said, I felt like I needed to let you guys know that. Second thing, if you buy this Sunbum 50 kids and try to go buy it in the adult, same amount in the adult packaging, it is almost twice as expensive. I just found that out. So now you know. Hopefully that helps, and let's continue. Thanks for being here. this guy gets really little, like, he gets a little angry when people use his materials. So, oh, good night, maybe. Thank you for your support. Okay, guys. I love and support you. Yes, bathroom. I'm thrilled. Sorry, guys. I'm like literally 30 things behind. Look at Lefty. He's so smart. Hey, mysterious. Nope. And if you try to keep talking like that in my chat, it's only going to be more problematic for you. Because once again, I have built this platform by following the rules, by listening to people, by doing what I love. So I will not let someone get in the way of that. Please respectfully follow what I am asking you to do if you would like to participate in here. Thank you. Maybe I'm Lefty. I will show the remodeled bathroom when it's done, absolutely. Okay, Baez and the judge had no arrangement. They hated each other with an ungodly whatever. Yeah, I'm not going to debate you on which words you can and can't not use. Okay. Bye. See you never. God, people are such dicks. All right. And on that note, I gotta go. I've been doing this since 3:30. So, tomorrow we start a new case, and I think that you guys will like it. And we are going to do that until I leave town. And then, while I am out of town, I feel like I have to say this. While my father-in-law is here, literally, he does not leave. That's why I have to leave. Anyways, that's gonna bite me in the ass. We will show a case that I did last month or 2 months ago that you guys probably are not aware of while that is going on. And then around the 26th is when I will pick things back up. So, but I'll be here next week, so don't worry. I hope to see you then. And I hope to see you tomorrow, 3:30 p.m. Eastern. And thank you for everything. You guys are great. Thank you to my mods. Thank you to everyone. I appreciate you. Oh my God, 3.5 hours. I gotta go. All right. I'll talk to you guys later. Bye-bye for now.